Susanne, guten Tag.
Hey, grüßt euch. So.
Recording in progress.
But how are companies supposed to stay current when data policies are constantly changing? This will be discussed on October 9th and 10th at the Bitkom Privacy Conference. And even more at Bitkom's Privacy Conference 2024. Tickets are free. Get yours now. Good morning and welcome to day 2 of Bitkom's Privacy Conference 2024. Since last year, the regulatory landscape has continued to evolve, with significant developments such as the Data Act, the GDPR enforcement regulation, and the AI Act shaping how we approach data protection. Today, we will explore the international perspectives, address the challenges of compliance, and discuss new business models in data economy. Together, we will explore these topics with leading experts examining the future of data protection. My name is Isabel Stroth, and I am a policy officer for data privacy at Bitkom, and it is my pleasure to guide you through today's day of the conference. The day 2 of this year's privacy conference is focusing on international perspectives in data protection as it did last year. We will begin with keynotes from prominent figures, followed by panels covering topics such as the GDPR enforcement, AI governance, global data security. Discussions will also dive into challenges posed by legal overlaps, especially between the GDPR, the AI Act, and the Data Act, and how businesses can adapt while fostering trust and transparency. Today's session will provide actionable insights to navigating these evolving regulations in a dynamic, data-driven world. To guide your way through the platform or app you are using today, just a few heads up. You can get an overview of today's entire program on the platform and save your favorite sessions. Here you will then also find all the information on the speakers of the current session. You can also find more about the products of our partners and contact the relevant people on the platform if you would like to. It's also possible to make appointments and have short meetings via the platform. Of course, you will also be able to post your questions today, and so feel free to type in your questions and we will do our best to answer all your questions. If you would like to build the discussion on social media, our hashtag this year is #PCO24. A big thank you once again to all our partners this year. Without their support, this conference wouldn't be happening and it wouldn't be, you all wouldn't be joining us for free. That's all from me for now, and I am very happy to now give the stage to Susanne Demel. Susanne Demel is Managing Director of Law and Security here at Bitkom and will be welcoming you for this year's conference. Susanne, the floor is yours.
Thank you, Isabel, and good morning, everyone. Welcome to the second day of this year's Bitkom Privacy Conference. Our conference this year once again brings together key stakeholders to discuss current issues in data protection. And to set the scene, as in previous years, we have once again asked German companies in a representative survey about their state of data protection and their views on it. And I'd like to present some of the findings from that study, which highlights the growing challenges businesses face when implementing data protection rules. Despite being 6 years old, apparently the GDPR continues to pose significant challenges. As we heard already yesterday, the vast majority of companies in Germany reports that the expenses required to comply with data protection provisions remain high, or that their workload has even increased over the past year. While 71% of companies have either fully or mostly implemented the GDPR, the ongoing effort required remains a major concern. More than 80% of businesses report that implementing new tools or technologies trigger additional data protection reviews, and 76% still experience legal uncertainty regarding GDPR compliance. And this uncertainty apparently comes from the inconsistent interpretation of the regulation across the EU, as cited by 56% of respondents. 64% of companies feel that data protection provisions are applied too strictly by German data protection authorities, and 53% see the GDPR as a competitive disadvantage for the EU compared to other regions. Another key challenge lies in finding the balance between robust data protection and fostering innovation. 63% of companies believe that the fear of violating GDPR has led German companies to overcompensate, stifling innovation in the process. At the same time, 70% acknowledge that GDPR has improved data security within their organizations, and 48% believe it has created more uniform competition within the EU. When we come to the overall dominating subject of AI, this seems to be a double-edged sword when it comes to data protection. On the one hand, 48% of companies are exploring ways to use AI to improve their data protection efforts through tools like chatbots to handle data privacy questions or automated data anonymization systems. And I think that's quite surprising, actually, which is not so surprising, maybe on the other hand, is that 68% see AI as posing new challenges to data protection, especially when it comes to training AI models on large data sets. A notable concern is that the strict data protection rules may limit AI innovation in Europe, with 57% fearing that the GDPR will restrict AI applications, and 52% suggesting that companies may even relocate outside of the EU to avoid these constraints. Businesses are also calling for significant changes in how data protection is supervised. 69% of companies in Germany want reforms to the current oversight system, particularly regarding better coordination among national and European authorities. There's strong support, 67%, for centralizing data protection oversight in Germany to streamline decision-making, reduce bureaucracy, and create more consistency in enforcement. Finally, data breaches remain a concern for many companies, with 20% reporting that they had violations in the past year. And most of these breaches were reported to the authorities, and the consequences could be severe. 11% described the impacts as very serious, while 47% said the breach led to fines or penalties. I think that shows that violations of data protection law actually have consequences, and that companies are also aware of that. All in all, I think the findings of the study show that we might not have reached yet the ideal balance between protecting personal data, maintaining legal compliance, and fostering innovation in the digital economy at the same time. Companies are eager for reforms that will bring more clarity, reduce bureaucracy, and make the implementation of data protection laws more practical. But at the same time, when companies digitize their data and processes, when they introduce new technologies like AI in their products and processes, it is pretty clear that this will trigger new data protection questions and assessments on the go. It will require new risk mitigation, and it will require adaptation processes. And I think these efforts won't go completely away. This said, we cannot lean back and say there's nothing that can be done about this real burden for the economy. There's certainly something we can do about bureaucratic burden that is not necessary or helpful for effective data protection, or about uncertainty that comes from inadequate or inconsistent cooperation or decision processes in enforcement. And I think we will hear about that later. We also have to look closely on related fields of law like AI and data regulations, and we need to make the legal framework more consistent. And this is discussed today between practitioners on this conference and, of course, also beyond. I think the findings need to be communicated to the European Commission to help them with their efforts to create the single digital European market we all wish for. And I'm now very happy to introduce today's keynote speaker, Didier Reynders, the European Commissioner for Justice, who once again will lay the groundwork for our discussions. Welcome, Commissioner Reynders.
Hello from Brussels. It's a real pleasure speaking to you also this year, as I did in the last editions of your conference. The European Union institutions are currently going through a transition from one political cycle to another. Naturally, this is also a moment of reflection about what has been achieved and what lies ahead of us. When I think about privacy and look back at the last 5 years, I see many encouraging developments and some areas requiring further work. I certainly see encouraging developments at the global level. When I travel abroad, I observe there is an increasing recognition of the importance of having modern rules of game on the responsible use of data. We may still have discussions with our international partners on the how, but I hear much less questions on the why compared to even a few years ago. That has allowed very significant progress in facilitating free and safe data flows. In particular, we have concluded several so-called adequacy arrangements with important partners, such as, for example, South Korea, and are currently negotiating new ones with Brazil and Kenya. We have also reinforced existing adequacy decisions to ensure their continuity and are working on expanding the one with Japan to cover new sectors such as research, following legislative changes in that country. EU-US data flows are, of course, another area of focus of our work. I recently went to Washington to discuss with my counterparts, Gina Raimondo and Merrick Garland, the implementation of the new data privacy framework in the context of its first review. As the first report we just published on this first health check concludes, all the elements of the framework are in place and functioning well. Our report also contains some recommendations on the way forward. You will get an opportunity to discuss all this in more detail in a session later today. But more should be done and can be done to enable data to flow safely. This is why we have modernized our system of model contractual clauses, which is the main tool European businesses use to transfer data. And we are working on further sets of clauses on the basis of the feedback we have received, in particular from companies. This is also why I launched in March of this year the Adequacy Network, bringing together like-minded countries to develop concrete, pragmatic solutions to maximize the benefits of safe data flows. And I'm very pleased about how that work is progressing. A lot is happening also at home. 2024 marks 6 years of the GDPR, and in July we published our second report on the application of this landmark regulation. It shows that the GDPR continues to deliver effectively for individuals and businesses. The report highlights the benefits of the GDPR's risk-based and technology-neutral approach that provides strong protection for individuals and proportionate obligations for data controllers and processors. Many businesses have developed an internal privacy culture. they increasingly see data protection as key to their competitive strategy. But, as identified in the report, there are also challenges that we need to address. You will hear shortly more on our report from a Commission expert in this field, Olivier Micol, but let me mention 3 areas requiring improvements. First, there is a need to step up efforts to support compliance by SMEs, including through the development of tailor-made guidance and tools. This should also reflect the risk-based approach, as many SMEs do not have data processing as their core business. Second, consistent interpretation and enforcement of the GDPR must be ensured throughout the European Union. Too often, national data protection authorities adopt diverging interpretations on important data protection concepts. This creates legal uncertainty for individuals and businesses, increasing costs and obstacles to the free flow of data in the Union. This issue is also identified in the recently published Draghi report as one which may discourage innovation and investment in Europe. Addressing this question requires a collective effort from the EDPB, national data protection authorities, but also the European Union legislator. Last year, I proposed the GDPR procedural regulation to foster coherent enforcement. These procedural rules will not amend the GDPR, but complement it so that data protection authorities can work earlier on and better together on cross-border cases. I hope the new regulation can be soon adopted under the new legislature, on the basis of the work already done in Council and Parliament over the last year. Once this regulation will be in force, and in light of the experience gained from its application on the ground, it will need to be seen whether further measures are necessary to ensure a consistent enforcement of the GDPR. This may include, among others, considering possible adaptations to the governance model. I'm hearing, for example, ideas about strengthening the role of the EDPB as a pan-European regulator for certain cross-border cases, drawing inspiration from other regulatory systems, such as competition law. And thirdly, data protection authorities need to be equipped to do their job. While most authorities have been given more resources in recent years, many still lack specialized technical and legal knowledge and have difficulties recruiting and retaining staff. This is more important now than ever before. In a union like ours, DPAs need to talk to each other, and they need to communicate with regulators in different sectors, as many of the EU's new digital regulations involve competition, consumer, media, and cybersecurity questions too. As you can see, when this conference will meet again next year, there will still be much to discuss and debate. But what is clear is that to develop useful solutions, we need your feedback and suggestions. My colleagues and I look forward to hearing them today. Once again, it has been a pleasure to address you this year and over the last few years. Thank you, Bitkom.
Thank you to you, Commissioner Reinders, for those insightful thoughts. We now transition right to our next keynote speaker. Our next speaker is Carmen Alvarez Valdez from Microsoft. Carmen will give us a presentation on is this the new AI economy era, the AI tech stack. Carmen, the floor is yours.
Yeah, thank you so much. So I shall present. So can you see my slide? No.
Not yet.
Okay, let me see. Share. Okay, sign in. Share. Okay, thank you. I think you could see now, right?
Right.
Well, hello. My name, as it was said, is Carmen Alvarez, and I'm a privacy lawyer at Microsoft. I work at the Office of Data Protection. And well, part of our role is to reach out proactively to data protection authorities. We listen to them and we gather their input. Well, I appreciate the invitation from Bitkom. And when I was asked to talk about AI, I was considering what you have heard yesterday and what you will be hearing today. And I thought interesting to stop and look at the AI tech stack. So the full AI spectrum, as this is something that we can know about because we cannot distinguish between a data center and application. But what we may not have realized completely is about its complexity to a point where we can say that we are living the new AI economy. And that is because AI is a general purpose technology. This is similar to electricity and the print press that were general purpose technologies that saw the advent of the Industrial Revolution. So because AI is a general purpose technology, but also because it will make other technologies and sectors flourish from it, I think that we can refer to the new AI economy. And indeed, it's something that's not just me who says that. Like, for example, just this week, we've learned that the Physics Nobel Prize has gone to those that laid the foundations for today's most advanced AI applications because of the impact that these applications have in our daily lives, right? Isn't it? So, well, in any case, I am conscious that this is a privacy conference, so I'm not going to be talking about economy, about markets or competition, but I will be talking about the impact that this AI economy has in personal data protection and the other way around by way of going through an AI tech stack. So let's do a pause and look at it. Okay, well, I think that this slide is eye-opening because it shows that the AI tech stack has a layer structure where each layer plays crucial roles for allowing efficiency, scalability, or adding value. The core components of this structure are physical, digital, and applications infrastructure. So these layers constitute the essential building blocks that underpin an AI system. So at the bottom of this structure, we have the physical infrastructure that starts with electricity, connectivity, and land. Companies are investing billions in new power generation, including in renewable energy, new transmission infrastructure, and new telecom pipes such as subsea cables. We also need AI chips. The chips are vital to training and deliver more capable AI for users. This demand indeed is driving billions in new chips investments and competition. And it's made of NVIDIA, a $3 trillion company indeed. Well, we need also data centers to house and to hook up to power and connectivity. Here, to put an example, Microsoft will invest 3.2 billion euros in Germany in the next 2 years. This includes infrastructure to ensure that people will have that connectivity and includes as well the training of people with AI skills so that this investment creates long-term benefits. So Microsoft indeed is building out capacity and investing in skilling around the globe, not only in Germany, to ensure that AI reaches and serves the global south and not only the wealthy countries of the globe. Then, well, at the middle layer is what I refer to as a digital infrastructure. A lot of this relies on data used by the AI system to understand how people talk rather than retaining it. Data is a key part of the stack. It's needed to train AI to recognize patterns, to learn from human knowledge, to learn how we communicate, or to create new output. Data is one of the ingredients for generative AI, because to train these large language models, we need to train on larger quantities of data and greater diversity equality, because this will produce more capable models that are better able to understand local languages, culture, references, and context. Because at the end, diversity is key to more inclusive models and to mitigate any discriminatory biases. Next is foundation models. Many companies are racing to build foundation models. Some may be downloaded. Some models also may be queried through an API. Microsoft is both building its own foundation models and investing in promising startups to help increase competition and grow the ecosystem. Because in fact, there's 3 ingredients that are needed for generative AI models. So it's data, it's compute infrastructure that we already talked about, and it's also new algorithms that will run over the training data to come out with the AI model. But when talking about data, of course, us as privacy professionals, we think of personal and non-personal data. Personal data is not intended to be stored in the model, as is at least, to be memorized or to be regurgitated. Really, for models, the goal is just to learn from human discourse. Models are training trillions of tokens, trillions of words. These aspects, especially the fact that models do not store personal data and how they are trained, those have been addressed in great detail by the Hamburg DPA in a discussion paper, which concerns large language models and personal data from this year, which I invite everyone to read it. The outcome of these 3 ingredients is a trained model. So a model that has been trained in trillions of tokens over a lot of GPUs for a long time, which will be later on fine-tuned for specific tasks that exhibits general purpose capabilities. Next in the stack come platforms to host the foundation models. As AI has matured, we have seen a more platform-shaped model on the structure. Microsoft offers platform for hosting first and third-party models in Azure, which is growing rapidly. Other companies offer platforms for models too. These platforms offer systems, controls, and tooling to help companies, government, it's very important as well, and others to safely and secure use these models and build their own AI solutions. So you get an idea. The site on Azure is that we have more than 1,700 models, the majority of which are open source. Then comes the apps infrastructure level. There's a huge ecosystem of finished apps to deliver AI services, such as Microsoft's Copilot. In this layer, where people create the application, is where one can best address local needs, and is where you get the work that Microsoft is doing to advance local climate needs, conservation, biodiversity, or social development needs. And at the top of the structure is the people that companies like Microsoft serve, users and developers who bring tech to everyone. Okay, so remarkably, there's more regulation at the top of the layer than at the lower. Regulators think that, or think of regulating AI, but our proposal at Microsoft is that there are different requirements at each layer. Therefore, a risk-based policy should align with the technical architecture of the AI. and place different responsibilities at the different layers. So for example, data centers should be licensed, like power stations are. We need regulation around red teaming, around apps for privacy, digital safety, or non-discrimination. And then, of course, those on the AI tech stack at the top layer are subject to personal data protection legislation for the processing of personal data. So from the perspective of the GDPR, there are scenarios where it is clear which companies taking decisions about how to process personal data and clearly takes a controller role. That's, for example, when an AI provider trains a model and pre-processes personal data, or when an AI deployer uses an AI system to process its own personal data via chatbot. In these two cases, you can conclude that both are the AI provider or the AI deployer in the second case are controllers. However, there are more complex scenarios that blur the lines between the roles under the AI Act and the GDPR. This is the case of AI deployers, many cases that offer services that involve the processing of personal data and the use of an AI system to process that personal data. So depending on the facts, they may sometimes qualify as controllers or as processors. Okay, so next slide. Okay, as we know, well, the GDPR is built around the data protection principles, which are set out in Article 5. These principles are lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity, and confidentiality. At Microsoft, we have a long-standing practice of protecting our customers' information. We are committed to security, privacy, and compliance across everything we do. And our approach to AI is no different. We believe that the development and deployment of AI must be guided by an ethical framework, because when you create technologies that can change the world, and the use of AI may come with some risks, we cannot deny that, we must ensure that the technology is used with responsibility. Our work is guided by 4 core principles of fairness, reliability and safety, privacy and security, and inclusiveness. Those are underpinned by 2 foundational principles of accountability and transparency. The privacy commitments our commercial and public sector customers have long relied on at Microsoft, from Microsoft, for enterprise cloud products also apply to our generative enterprise AI solutions, including Azure OpenAI Service or our copilots. Okay. At Microsoft, we have been researching and developing AI technologies for decades. Our goal is to deliver trustworthy AI across all our products and platforms, from Microsoft 365 to Azure. Trustworthy AI is only possible when we combine our policy commitments with our product capabilities. This ensures that the approach that security, privacy, and safety are built into our technologies by default. Indeed, security is our top priority. We have a multi-year commitment called the Secure Future Initiative, or SFI, which prioritizes security above all else. Our AI services come with foundational security and compliance controls. So, for example, we provide built-in controls in Microsoft 365 Copilot to prevent prompt injection attacks and copyright violations. These controls help protect AI applications and ensure they comply with regulatory requirements. Privacy is another critical aspect of our commitment to trustworthy AI. Our approach is built on long-standing privacy principles, which I mentioned just in the prior slide. We are committed to protecting privacy by providing products, information, and controls that allows users to choose how their data is collected and used. From product builds with privacy by design to transparent information and user controls. Our goal is to empower individuals and customers to make informed choices about their data. So, for example, we have confidential computing. Confidential computing is a technology that protects data while it is being processed. It isolates sensitive data in a hardware-based secure enclave called Trusted Execution Environment. Only the code running in the trusted execution environment can see the data in plain text, ensuring that unauthorized access is prevented. Microsoft has pioneered confidential computing on Azure, and we continue to innovate in this area to support privacy and AI. Finally, AI safety is a necessity in the fast-paced AI landscape. It involves building, testing, and monitoring systems to avoid undesirable behaviors like harmful content, bias, misuse, and other unintended risks. We have developed responsible AI tools that our company and our customers can use throughout the AI development lifecycle. These tools help identify, measure, and mitigate risks, ensuring that AI applications are safe and trustworthy. In conclusion, Microsoft's commitment to trustworthy AI is unwavering. We continuously deliver industry-leading security, privacy, and safety across our AI technologies. So whether you are building a copilot, using a copilot, or searching the web, our trustworthy AI commitments and capabilities make it possible for you to accelerate AI transformation with confidence. Well, many thanks for your attention, and I hope you found this useful, and please do not hesitate to reach out to me to discuss, and enjoy the rest of the day.
And for that enlightening presentation, your insights to data privacy and I certainly set a stage for our discussion today. Thanks a lot. Now let's dive into our first panel discussion based on the topic pay or consent. I'm now going to give the word to our moderator for the panel, Professor Dr. Markus Helfrich.
Thank you very much, and welcome everybody for our today panel discussion or panel session, Pay or Consent. And I'm very happy to introduce not only my panelists this morning, but as well to discuss, I think, an interesting topic that leads in the nearer future to several points and discussions that have to be clarified, not only within the academic area, but within the practice as well. Some remarks on my person. I'm Markus Helfrich. I'm professor for international business law, IT and data protection law. And as an attorney at law, I got in contact with many companies, and I'm consulting since around about 30 years in data protection issues. So one can survive that, as you might see. So before I give you an introduction to our panelists, let me summarize or point a little bit on the main topic today. On April the 17th, 2024, so not long ago, the European Data Protection Board issued its Opinion 8/2024, which addresses a core topic on online platforms and information providers. The EDPB had to clarify the question if the concept of consent or pay models as implemented by large online platforms. So Meta had been one of the main focuses on that opinion. If this concept does comply with the concept of information and valid consent of the GDPR. The EDPB had been asked by the supervising authorities of the Netherlands, of Norway and Germany to take into account the decision of the European Court of Justice Bundeskartellamt, where, as we all know, we had let's say, the mingling between antitrust law on one side and data protection law on the other side, and focus on the question of freely given consent. So the question that had to be clarified by the EDPB had been if the valid consent as well might be not only a matter of antitrust law, but being in compliance with the idea of getting a consent as an alternative to paying for services. There had been a second limitation of the opinion of the EDPB. The second limitation is dealing with the scope of data processing. So the opinion focuses on gathering and compiling data for the purpose of behavioral advertisement. So this is maybe an important limitation, or let's say focus on the core question. I find it interesting what the EDPB itself highlights as a key finding. It says, as a quote, "In most cases, it will not be possible for large online platforms to comply with the requirements for valid consent. If they confront users only with a binary choice between consenting to processing of personal data for behavioral advertisement purposes and paying a fee. So large online platforms should consider providing data subjects with an equivalent alternative that does not entail the payment of a fee. Offering a further alternative free of charge without behavioral advertising, for example, with a form of advertising involving the processing of less or no personal data, occurs to be required by the EDPB opinion." Okay, that's as a starting point. Let me first give you a short introduction of our panelists today. I'd like to start with my dear colleague Barbara Schmitz. She studied law in Münster and Bonn. She has been working for 20 years in the field of data protection, IT law, and selected compliance areas in various companies. Her professional experience covers telecommunication industry as well as lighting industry and media. She is a renowned specialist in data protection law and practice. She's involved in the development of legal doctrine in the key areas of international data transfer and payment with data, so more or less our today topic. She's much in demand as a lecturer and speaker at professional conferences and in training events. And not to forget, she's regularly publishing, she's a publisher in professional journals. She is co-author of commentaries and member of the scientific advisory board of the Zeitschrift für Datenschutz of the Beck Publishing House. My second panelist, Ms. Caroline Loy. So she studied law at University of Erlangen and worked previously as a lawyer in civil law. That's an interesting side aspect of our today topic because you know the other side of the table, let's say. Since 2020, she is a member of the Bavarian Data Protection Authority for the private sector. She's responsible for e-privacy, internet and digital services. And since 2022, she is head of the staff for European cooperation. And since April this year, she is working as press and public relations officer for the Bavarian DPA. Last but not least, Marco Kaiser. So maybe the one who affects the decision and the opinion, most of it from our today panel. He's acting as a CTO at Zeit Online. He's running software development and operations for the news portal Zeit.de and other online products since 2013. He became a member of the executive board for Zeit Online GmbH in 2019 and is responsible for producing technical audience management and data protection. Before his actual role, he worked at various international and national startups as a head of product, director of engineering and CTO. So, thank you for your activity this morning. And I would like just to address as an opener one question to all of you. Quite a simple one. What were your initial thoughts on the EDPB opinion, pay or consent? And maybe you could give us some idea, where do we stand today, round about half a year after that opinion had been issued? So maybe I would like to start with Marco, because you as the practitioner should be, in my point of view, affected most. So.
Yeah, sure. Thank you. I mean, when it came out, it was expected that it would come out. The question was more or less like, what will be in it and how strict will it be? And will there be a third alternative way or option that is requested? We all hope that it would not be in it, obviously, as we don't have it, but it was in it. So in the end, I mean, we always welcome to have like common regulation, common guidelines. The GDPR regulation market is so fragmented. Like in Germany, at least, we have like 17 different authorities. In Europe, many more. So it was always difficult to find one solution, one way to deal with consent in the GDPR sense that would kind of like work everywhere. So guidelines are good. Obviously, that guideline was not what we hoped for, or that opinion. But after like having a lot of discussions afterwards with other publishers, with authorities, and hearing statements also from our Hamburg DPC, Thomas Fuchs, that this was no longer his opinion, no longer his paper, it became very clear to us that this paper, this opinion does not really affect us in how we deal with pay or consent models. We are not a large online platform, although the opinion is not very specific in how it defines that term, but from what we hear from authorities, we are not kind of like the prime target of that phrase. That's maybe, you mentioned Meta as well, so maybe those platforms are more affected by this opinion. So for us, after some confusion at the beginning of how will this apply to us, it has become pretty clear that this is not for us. So right now, it hasn't changed much for us. We're more waiting for any further opinion or guideline or whatever that is what we hear coming at some point that is still under consideration between the different countries and in the EDPB, which might apply more to the whole market, to all businesses, and obviously that would have a bigger impact on us.
Thank you. Barbara Schmitz, with your experience from consulting and specifically media branch, what was your impression?
Thank you, Markus. My impression was at the first, it was not so surprised. After you mentioned this, after Meta and against Meta decisions from the EDPB and from the courts and the EU court, it was not so surprised, and it was as expected also in the extent from the statement. But your question about the direction and the status after this statement, from my point, it was the so-called contract solution. From my passion, it was a good basis to keep this approach and this argument in the statement for this solution to not only pay and consent, or pay money and pay data in the contract, and the arguments are very good for this approach. And so it was a direction from my side and for the consulting for my clients.
Okay, thank you very much. Thank you. Ms. Loy, not surprised or disappointed?
It would be sad if I would say now that I'm disappointed, because I was a member of the drafting team of the opinion. So it was not that surprisingly. Yeah. But I want to answer as someone who has to handle complaints on this topic, and someone who has to assess such business models in practice. I would say the opinion is very helpful because it provides the legal framework for assessing the consent or pay models. although you have to be aware that the opinion has, as you already mentioned, a very narrow scope. It has the focus on the very large online platforms because the request wanted the EDPB to do so. But as it's stated in the opinion, there are some considerations that may also prove useful in a more general way, because the requirements for valid consent are the same, regardless if there's a large online platform or if there's a small business. The difference is the impact this has, because this can vary strongly depending on whether you're a large online platform or not. So I would say, from the perspective of someone in a national supervisory authority with mainly no large online platforms to assess, the opinion provides guidance, but you must bear in mind that the opinion doesn't and can't show the complete picture. It's just a small part with the focus on the controllers on the large online platforms, and just a small part of the whole discussion, consent or paying with data. But nevertheless, I think I'm happy, I'm glad that we have the opinion, because there have already been some other papers from national authorities who tries to give guidance in this case. And I think it's very important that we have consistent guidance and a consistent opinion in the whole European Union in such a significant topic.
Mm-hmm. So thank you very much, Ms. Loy. Maybe we'll talk in some minutes about the question, let's say the reach of that type of guidance. And you already mentioned that there is a slight side remark in that opinion that maybe opens up the broadness of that, let's say, picture, not only on large media or large platforms, but let's talk about that maybe a little bit later on. First of all, for the first round, I would like to ask Barbara Schmitz again. Although the EDPB addresses primarily the large platforms, as we already said, the opinion discusses the preconditions of a valid consent very detailed or in detail. How are your clients preparing themselves to comply with the opinion, even if they might not be a large online platform? So do you think that this opinion not only affects, in that sense, large online platforms, but gives, like Ms. Loy said, guidance for all the rest of online providers who like to gather information for behavioral advertisements? You're just muted, sorry.
Sorry, I saw it. Sorry, Markus. Your question is, the question is, how great is the company you use this guideline and use the requirements of the guideline. For the large companies, it is a good guideline, and it is to keep this advices. But for my clients and for the general clients in my daily business, we have to check if the question of pay or consent is not the main question, it's not the core question. So more of my clients and I think the most of the websites companies or websites provider is the question we need to finance our services and products, or we take cookies only we would like to know what our users do on the website. So I think, but it is in the discussion, I think it is not the guideline for the EDPB is not affected the most of the provider in the website provider.
Mm-hmm. Thank you. So, Marco, you already mentioned that, let's say, your first finding of that opinion is, well, okay, it does not really affect us. If you take into account the European Court of Justice decision last week, Friday, maybe you already got that about another Meta case, which dealt with the question not is it depending on a valid consent, but it dealt with the question of the broadness and detailedness of gathered information, and the question, is it compliant with the requirements of the GDPR, specifically with Article 5, paragraph 1, to collect quite enormous amount of information just to follow specific aims and purposes. And as a result, the ECJ said, well, okay, it's not covered by the GDPR if you collect quite a huge amount of data, and then you only need a small amount or smaller amount of these data for behavioral advertisement. So this is maybe a follow-up of that opinion, not only questioning, do I have a valid consent or not, but questioning what am I aiming at doing with that information that I do gather. And I think there we get back to the EDPB decision. We have to take into account what are the legal consequences of collecting data, and are they covered by the purposes we follow. What's your strategy as a media house where quite a lot of people are reading articles and informing themselves, and therefore leaving, let's say, very specific traces in individual interests and so on?
I mean, not an easy to answer question probably, but we changed our model basically last year after some month of discussions with the Hamburg Authority, Data Protection Authority, and allow users to also not consent to some purposes, even if they don't pay us money for a pay subscription, and basically you can now not consent to anything that is not related directly to monetization on the site, meaning like building profiles for personal recommendations of content and stuff like that. The only things we do really require you to consent to, if you don't pay for the poor subscription, as it's called on our site, is like advertising, like third-party advertising and first-party advertising, because we also obviously use that data to advertise our own products, our own subscription for content. So it's probably difficult, and I think that's also one of the things, if you look at the opinion, and they speak about large online platforms without naming them specifically, because I think they are not allowed to in the opinion, but it's always clear that they are talking about Meta and the others like that. And we don't collect so much data, right? I mean, people come and read articles on our site. We know a little bit about their interests, probably, of what topics they're interested in, what time of day they come. But I think it would not be fair to compare what we collect as data to what Meta on Facebook or Instagram collects with data or data of users. So again, like, yes, maybe, and I can't speak for them, maybe for what they do with data collection on users, it's difficult or more difficult with GDPR compliance than what we do, because also like the advertising data that is collected for advertising, for personalized advertising, is not collected on our site, and it's not collected on one server or whatever, but it allows an ecosystem basically to track users. Yes. Do I like it? Not always, and not to all the extent it does sometimes, but for us, it's just an important pillar of revenue still to be able to do that, to provide our content, which is quite expensive to produce because it's quality journalism, and we need that, and we can't just use no consent advertising. It just doesn't generate the same revenue. So in that regard, again, like, as we allow fine-grained controls over some of the purposes for data that we collect, and even allow users who do not pay money to opt out of those. Well, not opt in, I would have to say. I think we can live with that decision.
Okay, thank you very much. Ms. Loy, from the perspective of the supervisory authority, we already touched that topic in general. Do you think it might be necessary to differentiate between large online platforms, publishers, and normal website providers or operators, like Mark already pointed at, saying we are a little bit different from the big ones like Meta, Google, and so on. I had been a little bit surprised about the focus on large platforms, dealing with the question of valid consent, because I still think that the question what is needed to have a valid consent is not depending on the question how big the processor is and what's he intending to do with those data. Is it really necessary to differentiate? And if yes, how?
As I said before, and I totally agree with you, the requirements for valid consent are the same regardless if you are a large online platform or not. But there are a few points where it may differ a bit. Because when you're looking at a large online platform, it is much difficult to ensure that there's a freely given consent, because you have other impact on this. Because there's an imbalance of powers, there may be more detriment, because with a large online platforms, you are more depending on it. You're more depending on using the service, because there are large online platforms maybe so special for jobs, or if you want to stay in contact with your families, and you are depending to use this platform. And there's the question: is it really possible to give a freely given consent if you're depending on this platform, when the alternative is only a paid version? But there's no, it's not possible to differentiate by services in general, because there's no legal basis for this. I think it seems necessary, because in some cases it seems appropriate that you impose a fee for the service or the content. So here we can speak about the often used comparison to the newspaper. You pay for your newspaper in the shop. Maybe you can also pay for it on the internet. And there are other cases where you might think that's just a circumvention of the requirements of the GDPR, that there's a consent or pay model now. But there's no legal basis where you can differentiate between these services. So all we have is to say that we assess the requirements for valid consent, and we say what impact does the size of a company or the status of a company, there are several criteria in the opinion, make on the freely given consent, because this is the main issue, I would say. And this is the only way we can differentiate here, because otherwise we got no legal basis for it.
I think there's an important point, let's say, reading the opinion very carefully, I think it's an absolute must for future concepts, how to deal with getting a valid consent in processing personal data, because the opinion points out quite clearly that there are specific criteria. And what you said is, I think it's an important thing, that size matters in that respect. If we look at the core criteria in giving a freely or to build up your will freely, and then have a free decision to consent or not to consent. So, Barbara, let's say follow the statement Ms. Loy gave right now. What are equivalent alternatives in that sense? Are there maybe already proven or best practices in that sense, that there is a third way, or maybe a fourth way as well, outside or in addition to that binary alternative, consent or pay?
Yes, the EDPB framework names it what is a free alternative without behavior advertising. It's FAWBA, the shortcut. I think it's a new shortcut for the new alternative. But I think it makes sense for the big platforms, as Ms. Loy said, is for this in the contextual and with regarding to the lock-in effect. Ms. Loy explained it with other words, and this lock-in effect is another purpose as for the publisher, I think. So I think it makes sense that the big platforms need, or for this, the big platforms, the requirements make sense, and not for the normal platforms. And so I think it is yes, we have to see that we different between each platforms, and not make this for all platforms. But I think this is the discussion we take in the past, and we will make it in the future. And there is a new guidelines from the EDPB, and the court make guidelines for this. And so I think we go in the right direction for paying data with each solution. So the solution for contract and solution for normal platforms without behavior advertising, or with a solution for the publisher for commercial functions behavior on the websites. I think this is different parts of websites.
Mm-hmm. You already mentioned that before, the contract solution or something like that. Could you give us some hint what's maybe hidden behind the idea of, well, don't ask about consent, let's fix the relationship between the user and my platform within the contract? So you get the consent indirectly by agreeing in the obligation to provide information in respect of getting the required whatever services rendered by that platform.
Yes, but we have in the past some of judgments, they put the consent in the contract, in the data privacy in the data privacy Erklärung. Okay, and so I think it is the digital directive as a basis for this thoughts about. We have the consent, the pure consent. So we have to see the consent in the circumstance of the contract, and the contract in the data privacy, in the digital circumstance is a obligation for the new deal with paying data in the digital world.
Okay, so Marco, let's get in practice, or let's find solutions. What are, hopefully, which type of measures do you take? You already said, well, okay, it doesn't affect us in our core activity. But if you think about your environment, the ecosystem you're in, are there specific measures that might help to ensure or to give a clearer idea of a valid consent that is given for collecting data specifically for behavioral advertisements, or for, let's say, collecting data to give them away to a third party that, let's say, processes this data and allows you to send out more precisely advertisements to your clients?
I mean, I think we have a solution. I mean, first to say, we don't need to find one. We have one. It's following the DSK paper statement on pay or consent. Our local authority is fine with it. So there's no need for us right now to basically search for a better solution. Okay. Still, what we always have to do is to defend it in a way of saying we want to comply with all the laws, with all the regulations that there are. in the sense of like for the people who are in charge of like controlling us about it, and that's why we had this discussion last year with the authorities, obviously to our very strict binary model from the past, which only allowed you to allow all tracking or pay. Now it's more fine-grained. We only request users to, well, not request. We require users to consent to anything that is directly monetization related. If they don't pay a subscription, otherwise they can disable other purposes. I think doing these things and being transparent to the user on the first layer, explaining what we do, following the same transparency and information rules that every regular consent wall site basically also has to follow, because we use the same technical framework, which is all based on the user consent, the TCF, I know, which is also under some, well, yeah. They have some challenges on their own, but it's still it's the technical foundation that the whole consent is based on right now on the web, right, for advertising, and just making sure we are transparent to our users. We don't want to trick our users into anything that they don't understand or they don't follow. I know that not many people actually, from other sides I know, many people actually go in and really have a fine-grained control over their consent. They either consent or do not consent. And we want to make it clear to them what they consent to on the first layer, and have everything on the following layers as well, if they want to really go down into that deep information. I think that's the thing we are looking at. The question really here is like, how long will we have this behavioral advertising in general? We know already many technical platforms don't allow that anymore in the way that it was possible before. It's much shorter time frames that people can be tracked. So the question really here is, how is the whole advertising market developing, the whole ad tech developing in the future? Will there be a need for that anymore? Will there be the possibility, at least, for that in the future, to actually track users over different sites, across different sites that they visit? We will have to see. I think this is something we can't really influence ourselves a lot. We try to follow that, obviously.
So your final, some sense, or preliminary finally result is keep on going like before, because you already were compliant with the idea of valid consent.
Yeah. And again, like, I mean, if I may, the main point about the validity of the consent has always been, is it freely given? Is it voluntary? If you don't have an option where you don't have to give away your data or pay. But on the other hand, we're a business, right? I mean, what do people expect? We can't give away our product for free or at a price that is not sustainable for us. And there is a third way, I always say. It's like, go away, go somewhere else. There are enough sites out there where you can get news, where you can get information and not be locked out of society or whatever. And that might also be what Caroline Lois said. We are not locking out anybody from the information society, because at least in Germany, we have the public radio, television stations who give away the information for free. Everybody can read it there. So we're not locking out anybody from taking part in society. We have a product which costs money to make, and we want to actually monetize it, obviously.
So quality, for quality, you have to pay a price. So I would just add one aspect. I'm not so optimistic like you that behavioral advertisement will maybe in future not the core topic. Maybe we'll meet again maybe next year or the year after that, and we talk about AI and how to learn more about your customer, and then we are back in our topic again in some sense. So my final question to Caroline Loy, before I have a last question for all of you, from the regulatory perspective, how the Bavarian Data Protection Authority ensures that companies, and I know the question is really tricky, ensures that companies really comply or obtain voluntary consent for users and do not offer manipulative, let's say, alternatives or techniques to get a consent that is given but not given freely.
I would say we can't ensure that companies are doing what we are expecting them to do, although we wish for. We can just assess the GDPR and enforce the GDPR. We do a case-by-case assessment, which is based on the decision of the German supervisory authorities and the opinion of the EDPB. And I think we try to talk and to exchange with the control rooms for which we are responsible for. But there's nothing different because we have a lot of topics with the voluntary consent also in other cases. This is not a new problem. We already have the cookie banner task force or other working groups in Germany and also in the European Union. And we already have papers on this, for exception, the deceptive design patterns in social media, where there are also the problem of the voluntary consent is mentioned. And so I think we do nothing else than we do in other cases. Maybe the only thing I would say we try a bit harder here is to stay in close contact with other authorities and also with other European authorities, because we think, as I already said, that's very important that we have a consistent enforcement here. Yeah. But there's no special way that we ensure this in this special case, so it's like in every other case.
So thank you very much. And as announced, my last question to all of you. Just a short view in the, let's say, in the glass bowl. What are the challenges now and in future for companies implementing the new framework that meets the requirements of valid consent between protecting the privacy of users, of customers on one side, and I would amend that not only behavioral advertisement and, let's say, the trend in getting a clearer picture who I am as customer and what I might wish in the nearer future. Well, maybe we start again with Marco and then Barbara, and last, but so the last famous words are the ones of the authority then.
Okay. Yeah, it's really difficult. I mean, I've been doing this with trying to operate a new site in the scope of the GDPR over the last 4.5 years, basically, with the introduction of the pay or consent model on our side. And it's been quite a rocky ride, I would say, like with decisions going one way or the other way, and like regulated authorities in one state going this way and the other way in another state. I think what Caroline Loy just said in her statement before is like consistency would be something that would really help. I think not only publishers, not only companies offering sites on the web that require consent, but also users, because then there would be also some common understanding of like how consent can be obtained, how it's handled. And I think, again, like the thing is really be transparent about what you're doing. Tell the user what you're doing. Don't trick them into doing something that they do not understand or do not want. I think the whole GDPR and the regulations around it always assume that the user, I think, fully understands to the technical detail, to every technical detail what happens there. I think that is very hard to obtain. I wouldn't even claim that I understand every detail of the ad tech stack because I'm not working in that specific tech stack. I think you have to still try to tell users what you're doing, what they consent for, and then you will find good solutions. And I'm not saying, and I know Barbara Schmitz is likes that contract or pay.
Pay money or pay data.
Pay money or pay data. Thank you. And I think that's fair. I mean, from the user's point of view, that's not so different from pay or consent, right? I know the legal framework is different. From the user's point of view, it's a binary decision. Either you pay money or you do something else. and your data is used then, and that's fine. I mean, it's good that there's an ecosystem developing that has different solutions. If there would only be one solution for this question, that would be, I think, pretty boring.
Barbara, before you start, I'd just like to add one aspect from the web here. There's one question: is it really ethical to, let's say, trade in fundamental human rights against paying something, monetarize business concepts?
Who are you asking, Barbara? Or me?
I think Barbara, but you obviously you can add something if you like.
I think it is the big issue in the related to the pay or consent, the tension relation between privacy and economics, and this is also the point for this question. So, would we like more privacy or more economics, or could we make an equivalence between this both interests for customers or for companies to make more rights for subjects or more interests for the companies for economics? So I think this is a topic for pay or consent or pay money or pay data, the challenge of the social conditions, the challenge of the marketing conditions. And in this circumstance, I think we need appropriate and necessary regulation for paying data and for the transparency, or Marco Kaiser say, transparency to the customers, and then we get a good solution. I hope for the customers and for the companies, for all companies, normal company, publisher, large companies, and so on. All would like to get money and earn money, but we have the privacy rights for customers, and this is also a fundamental right.
Okay, thank you. So we have a bunch of homework for you as authorities to do. Am I right?
We try to fulfill these wishes. We are, as already mentioned, we are working on the guidelines on this topic, which should clarify the things a bit more. And there's also a stakeholder event in November where both sides can bring, there are associations of both sides, of the consumers and also of the economic side, that can bring their input and maybe discuss which topics should be addressed, which topics haven't been discussed in this topic. And I hope this will lead to further guidance, and also to the comment that you mentioned from the audience. It's a fundamental question, how we deal with the fact that personal data is an essential part of our digital economic these days. We have new digital regulatories like the Digital Content Directive or the Data Act. We have to deal with the fact, and we have to look how we can handle this in the light of the GDPR. But we also have to look at other developments like the inquiry of the European Commission in this topic. There are court proceedings ongoing, and maybe the Court of Justice is specifying it a bit more what he meant when he's saying if necessary for an appropriate fee. I think this could help us all, and I'm a fan, or I'm in favor of a judgment that will clarify the situation, and so hopefully there's just enforcement at the national supervisory authorities.
So thank you very much. I think that's the best final statement ever. So we will not only wait and see what future might bring, but we will have to continue discussion. And the last remark from the website, okay, this is really ethical issue that should not be get out of focus, and we have to have a look on that, and we will have to continue that discussion, specifically if we think of the cookie directive, its implementation in national law, the relationship concerning the GDPR and so on. So it will be interesting in future, and hope to see you soon again, and thank you to the audience outside there. Keep on going in discussing that matter. I think it's worth to do. So thank you very much, and have a nice day as well. Bye.
Thank you, Markus.
Thank you, Markus.
Bye.
Bye-bye.
Bye.
Thank you, Professor Helfrich, and thank you to all our panelists for participating. Now let's hear about the European Commission's priorities for the next legislative period. We are now joined by Olivier Micol from the European Commission. He will share the Commission's priorities in data protection for the upcoming legislative period, focusing on GDPR insights. Mr. Micol, the floor is yours.
Thank you very much for your very kind invitation, and I hope you hear me well.
Yes, we do.
In fact, I understand that you had already an intervention by Commissioner Reynders earlier this morning. And indeed, in his address to you, he already highlighted some way forward. And indeed, we are now at a time where the new Commission is being put in place. There will be the hearings very soon by the European Parliament of the various commissioners. We already have the instruction given by President von der Leyen in the mission letters addressed to the various commissioners. So we have already a very clear, let's say, way forward. On the specific issue of data protection, what is very important is that we have carried out this assessment of the implementation of the application of GDPR after a very comprehensive exercise involving the member states, the data protection authorities, the stakeholders through our multi-stakeholder group gathering the most important European business federations, civil societies. We had a call for evidence, to which Bitkom provided extremely useful input. And I guess that you have seen that in the Commission assessment, a lot of the elements highlighted by Bitkom members have been reflected. So in July, we published this report, and many of the elements as well that we have highlighted there have been also reflected, echoed in the report by Mr. Draghi that you might have seen as well, especially the issue of consistency and the fight against fragmentation. So what are the main elements that we highlight in this report and to guide the Commission future action on data protection? First of all, that we conclude that the principles in the GDPR and the rules that are put in place are fit for purpose. I don't think that there was any request for fundamental change of the rules and the principle, the legal base, which, by the way, were those already included in the 1995 directive. So we have been living with them for quite some time now. The business side and the operators have adjusted to these rules, invested to meet the requirements. So the idea was not to change or to impose a drastic change for the GDPR data protection rules. We keep the risk-based approach. We keep the 6 legal bases. With the rights of the individuals are the one again that existed also since the directive in 1995. And I think there is no intention to drastically change these rules. But what is very important, and I think it was mentioned earlier today, is a focus on proper enforcement and consistency. And this is also something that Commissioner Reynders highlighted. This is also included in the mission letter addressed to the new commissioner in charge of data protection. As you may know, the commissioner designate is Commissioner McGrath, and indeed in his mission letter sent by President von der Leyen, there is a focus on this enforcement. What is very important is the consistent interpretation of the rules by the data protection authorities, and I think it was highlighted by the Bavarian Data Protection Authority in the previous panel. Of course, in Germany, and there is a specific situation where you have Länder data protection authorities and federal one. So we sometimes say as a kind of joke that you have more data protection authorities in Germany than in the whole of the EU, in the rest of the member states, because besides this data protection authority for general rules, you have one for the broadcasting industry, you have some for churches, etc. So there is a bit of a specific situation in Germany, which makes the issue of consistency even more acute in this context. The question of consistency is a very important one, because too often we hear the narrative, especially from small organizations, that GDPR is a burden, that there are heavy reporting requirements, etc. But there are no reporting requirements under the GDPR. The only reporting requirement which exists is when there is a data breach, where you have, under certain conditions, as you know well, have to report to your data protection authority and to the data subject if the breach is very significant, etc. But there is always this narrative coming back on heavy requirement reporting and so on. And when we discuss, and this we spend a lot of time discussing with the industry, with Chamber of Commerce, regional Chamber of Commerce, it often boils down to the question of consistency. Do we get the right advice, the right support? And what is also striking is that the feedback or the impression we get when we talk with different business communities is that the same issues are not raised in all member states. For instance, we have much fewer complaints from SMEs in other member states that sometimes we hear from some lender in Germany. So here it's very important to have this consistent approach, reassuring the GDPR is not, it's also about data flows. It is not about going after small SMEs who do not have the processing of data as their core business. Of course, there is the risk-based approach. Of course, an SME who has not at its main business the processing of data has less, let's say, requirement than big tech companies whose business model is based on the processing of data. But it doesn't mean that we can exclude SMEs from the application of the GDPR, because you have also biotech companies who are very small company handling hundreds of thousands of biotech data. And of course, then the GDPR applies, and there are very strict requirements, because these are health data, these are special categories of data. So the discussion is not about SMEs versus big companies. The issue is about the risk. And I think it is very important to keep that in mind and to have a consistent approach throughout the EU as regard this issue. An important point also about this consistent enforcement and this is more this time about cross-border cases and more about a larger company. As a Commission, we proposed in 2023 a proposal for GDPR procedural rules. And here again, the idea is to foster more consensus at an early stage in the investigation between the different data protection authorities, so the lead data protection authority and the concerned data protection authorities. And here again, we are grateful for Bitkom 2 waves of comments, in fact, regarding this draft regulation. The last one being, I think, just before the summer on the Parliament position. And here again, I mean, the idea is really about consensus, about guaranteeing the rights of the parties and their investigation, also to foster solution like amicable settlements or preliminary vetting. You have different words to qualify it in different member states, but you know, sometimes solution can be found without launching a full-fledged investigation, and this is to the benefit of the complainant. This is also to the benefit of the parties under investigation. You can quickly, in fact, find a solution. So this is something we always advocated. So this consistency of enforcement, the second pillar, I think we highlight in the report, is the support to stakeholders. And this is, we welcome that in their strategies, the European Data Protection Board, so gathering all data protection authority, highlighted that as one of their priorities, especially the small companies, the small organizations. As you might know, as a Commission, we have been supporting data protection authorities to reach out to SMEs, to develop templates, to develop guides, to develop very practical tool. Now, the European Data Protection Board has gathered all these elements into what they call this guide for SMEs, translated into all EU languages. And we think it's a very important element to fight this belief, you know, that, yes, I mean, GDPR is making life impossible for small organizations. Again, there are practical solutions recognized. Still in support of the stakeholders, very importantly, are the guidelines. So we very much welcome the work of the Data Protection Authority in this field. It's a lot of investment also on their side. But what is very important is that these guidelines are actionable, are practical tool. We very much welcome that there are these public consultation on these guidelines. Probably there should be an even bigger engagement with stakeholders there. What is very important, and you might have seen yesterday, that the board has adopted a draft guidelines on legitimate interest, for instance, which is a key issue following the court ruling saying that commercial purposes can be legitimate interest. As you might know, there had been in some member states certain interpretation that it was not the case, and the Commission had intervened, and then at that time we were told that you know, we should not really make our view known, but this we had said, and we are pleased that the court has confirmed this approach, and now there is a public consultation ongoing until 20th of November, and I encourage the Bitkom members to contribute to that. So the involvement of stakeholders, and of course the data protection authorities, they need resources. Here it is a very important also element to be able to provide the advice to the data protection authorities. I just would like to point out that in Germany, there are roughly 1,100 full-time equivalent working in the different data protection authorities. If I compare that to France, Italy, Spain, this is around 4 times, 3 to 4 times bigger. So the resources are there. Of course, there are the issue and this I fully understand the various regional DPA, that it's split between a lot of entities. But globally, in full-time equivalent, you have 3 to 4 times more staff in the German DPAs that you have in France, Italy, or Spain, for instance. The cooperation between regulator is the third element I would like to highlight. After consistency, the support to the stakeholder, the cooperation between regulators. You have several new digital legislation, the DMA, DSA, AI Act, Data Governance Act, etc. Also competition, consumer law. So it's essential to foster this consistency between the action of the regulators. GDPR is a cornerstone for all this digital legislation. All this legislation have a different objectives than data protection. There are market contestability for the DMA. You have, of course, the AI Act for AI models. So they are not meant to contradict or to, let's say, overlap with the GDPR. But what is very important is the consistency. And you might have questions on that, but I can mention, for instance, on the pay or okay model, there is currently discussion at the EDPB. The colleague mentioned that there is an event on 18th of November for the guidelines. It's also discussed in the field of the DMA and also by consumer authority, and they discuss between each other. And I see that I have to close very quickly. Just wanted to highlight 2 things. First of all, that you have specific issue that we need also to look at. Children, age verification. This is something on which we are working also the Commission and the board and the Data Protection Authority, also data protection in scientific research. So I will conclude here saying, yes, we have a very clear path on us, which is making all this digital legislation work together with the GDPR, that probably when you yourself, you go to authorities and speak about the GDPR, I think it's very important to pinpoint the specific issue you are confronted with, not criticizing the GDPR as a whole, because I don't think it would make a lot of sense to reopen the rules, but really to try to address in a very practical manner the specific issue. And I will stop here. Thank you very much.
Thank you very much, Mr. Micol, for these valuable insights. And as I see, we don't have any questions, so let's shift to our next keynote. And our focus now heads to AI regulation under GDPR. Dr. Des Hogan from the Irish Data Protection Commission will walk us through some key consideration. Hello, Mr. Hogan.
Guten Morgen aus Dublin.
Hello.
Hello, good morning.
Nice to have you.
Ich möchte mich bei den Veranstaltern für diese Einladung bedanken.
Thank you very much. We thank you.
So today I will discuss the 3 areas: personal data in AI models, values, and the regulator's role in terms of pace and balance. So starting with the data in AI models, clearly personal data is present in text, images, video, and audio available in the public internet or in private platforms. Generative AI and large language models, which I'll speak about today, as it is the main focus currently of my authority's AI regulation, these are trained on large data sets. Before the start of a life cycle generative AI model or system, different data is contemplated to be used to train the AI, and given the wide definition of personal data in the GDPR, this data may very well include personal data. After an AI model or system has been developed and then deployed, that model or system may interact with people through various means, such as an application programming interface and API, and it may generate non-personal or personal data, accurate or not. It may be offered to other businesses or to the public sector. It can interact with us. For example, people use AI in actions such as filtering or assessing job applications. So this life, and indeed the afterlife or afterlives of a generative AI modeler system are not well understood. But one thing is, the AI modeler system will likely have later iterations. It will have future existences. So when we consider if a modeler system contains or reflects or represents personal data, what is the impact on user, consumer, citizen rights, and what are the company, the data controller's obligations? And if we step back looking at a wider canvas, harms arising from AI have been identified variously in common imagination as ranging from an existential threat to humankind to security threats. It can also be viewed as a threat to objective truth and the scientific method as we understand the terms. There are concerns that error and bias from AI LLM systems, if unchecked in turn, may create foundational societal paradigms different from current understanding. This raises fundamental questions that impact on our values and our democracies. Open questions include how one tests and counters such risks effectively and comprehensively during development and deployment. If there is inaccuracy or error untreated, what does this mean for decision-making in the society? What of the administration of criminal or civil justice if we tolerate or even come to rely on erroneous or inaccurate truths? Where facts are disputed, how does justice operate? Where there is injustice, can it be reversed? And what of decision-making? Where AI systems have become part of a decision-making process or are relied upon as part of that process, shall convenience or utilitarianism triumph over our current slower processes of evidence-seeking, deliberation, assessment, judgment, and discernment? And in terms of safety against harm, what of risk management, diligence, security, and accountability thresholds, which currently form part of decision-making in government and society? AI products such as LLMs can be prone to producing inaccurate or biased information. And if outputs of these products are relied upon without critical human analysis or intervention, then you may be introducing automated decision-making risks. Purely automated decisions have the potential to cause harm, significant consequences or limitation of rights for individuals involved. And this brings us to human oversight, which may be required under Article 22 of the GDPR and Article 14 of the AI Act, with their human-centric emphasis. So when we think about these societal questions, it becomes clear that these questions posed, they cannot be left to the GDPR or indeed to regulators such as my own alone. All stakeholders, from policymakers to industry to citizens, have a role to play, and I would suggest that role should be guided by our values. For our part as regulators, we must focus on our legal mandate, which I turn to presently. For our citizens, when considering AI risks impacting on their personal data, people tend to think of accuracy, safety, security, or risk harms, both of their own data and, of course, the impact of these systems on society and their place as individuals in that society. And as we can observe, where objective truth becomes contested and disbelieved, the societal effects can be severe. So, turning to the second part of my presentation, values. Data protection regulation in Europe derives, as we know, directly from the values of the European Union. Article 16 of the Treaty on the Functioning of the European Union and Article 8 of the Charter of Fundamental Rights and the General Data Protection Regulation, GDPR, all go beyond the right to privacy as traditionally understood and extend the right to the protection of individuals' personal data, introducing the values of fairness, legitimacy, the individual's autonomy, liberty, and ultimately their freedom. And these concepts represent universal ethical values and bring us back to Article 1 of the Universal Declaration of Human Rights. All human beings are born free and equal in dignity and rights. Under the Charter and the GDPR, compliance with the rules which govern the protection of our personal data are subject, as we have heard, to control by the independent regulators, the DPAs, the data protection authorities in each state. And in tandem, the individual has a right of judicial remedy, GDPR thus providing for both regulatory and justiciable accountability. And at the same time, the Charter under Article 16 importantly recognises the freedom to conduct a business in accordance with community law and national laws. So that is the legal landscape in Europe, which is now further evolving with the recent EU digital acts, including the AI Act. Internationally, we have the Framework Convention on AI and Executive Order 14110 on safe, secure and trustworthy development and use of AI These all evidence further attempts at standard setting and harmonization, with more no doubt to follow. The regulator's role then, turning up to the third area. So GDPR is technology neutral, which means that the emergence of AI models and systems should be seen as a further step in a history of new innovations, products and services with a data protection dimension entering the EU market. The difference is the potential scale of the societal impact of AI which it brings. The fast-paced development of particularly generative AI and the opacity of what an AI model or system is or what it may become leaves policymakers and regulators in the curious position of being responsible for oversight of products and services where the underlying thing being regulated is a concept not well understood or arguably understandable. So, what is the regulator to do when balancing the right to conduct a business, to innovate, create new products and services with the rights of the individual, particularly for fast-paced evolving AI? And what is a company to do when faced with the raft of digital acts recently introduced in the EU, the DMA, the DSA, the AI Act, as well as the GDPR? DPAs, data protection authorities, recognise the challenges facing companies navigating the EU digital acts. In the Data Protection Commission in my authority, we have, for example, appointed a head of interregulatory affairs function to assist in navigating the regulatory landscape with co-regulators, whether the co-regulator is based in a national authority or in the Commission. But when it comes to GDPR and AI, we, as with the other relevant DPAs, we will continue to be the main regulator. And we place importance in this area of interregulatory cooperation because it is better for industry and for individuals. There are 6 lawful grounds permitting processing of personal data found in Article 6 of the GDPR. Of these, the ground most commonly mentioned when developing AI models is the legitimate interest ground, where there's a 3-part proportionality test. There is also, of course, the consent ground, the contract ground, etc. Assessing legitimate interest involves balancing rights. But for the regulator, our focus being on the protection for the individual, we first turn to check the homework of the company or the government entity developing the AI model. Now, for a moment, allow me to take you through my authority's usual approach when assessing development of new products or services about to enter the EU market and how that can apply to AI model development. Typically, we look at whether the company has addressed the GDPR requirements of data protection by design and default under Article 25. This provides that at the time of the determination of the means for processing data and at the time of the processing itself, companies, controllers, must implement appropriate technical and organizational measures, including such as pseudonymization, which are designed to implement data protection principles such as data minimization. So, question 1, has this happened? Usually, designing a modular system with GDPR in mind will mean considering a number of user, consumer, and citizen rights. Under the GDPR, these can include transparency and explainability to data subjects, transparent information and communication under Article 12, transparency in accessing personal data under Article 13, the individual right of access to their data, Article 15, the right to rectification of inaccurate or incomplete personal data under Article 16, there is a right to erasure, a right to be forgotten under Article 17, and there is the right to object under Article 21. So going back to Article 12, it's really clear that information in concise, transparent, intelligible, and easily accessible form in clear and plain language, particularly for information to children, is required. We in the Irish Data Protection Authority normally look to the data protection impact assessment prepared under Article 35 GDPR, where there's a high risk to data subjects. Sometimes companies will have previously done their own legitimate interest assessment, which will be shared with us. The Data Protection Impact Assessment, the DPIA as it's called, is a comprehensive document, one which demonstrates how the various elements of GDPR are met, including necessity and proportionality analysis. In addition, there are the requirements for a watertight contract with processors, Article 28, record of processing, Article 30, ROPA, and security processing, Article 32. And we must also consider, of course, whether a lawful basis for the processing exists in the first place under Articles 5 and 6, that is lawful, fair and transparent processing under Article 5.1, accountability under Article 5.2, and the lawful basis under Article 6. If legitimate interest is cited as the lawful ground for the processing of an AI model, the analysis must consider the three-part test set out by the Court of Justice in Meta Platforms, also known as Bundeskartellamt last year, and last Friday in Koninklijke Nederlanden Law and Tennisbond. I hope I'm pronouncing that correctly. And this test assumes, one, if there is, presuming there is a lawful, legitimate societal or business interest, was the personal data collected for specified, explicit and legitimate purposes, and which considered the rights of data subjects, so that three, it is apparent from a balancing of the opposing interests that the rights of the fundamental freedoms of the data subjects do not override the legitimate interest of the controller or a third party. This is not a tick box exercise, but demonstrates to the regulator how the controller understands and has considered the impact of the processing on individuals. Where the preparation or homework is incomplete, the response of the regulator will be tougher, including using its enforcement powers. And we've had to do that on AI model training in the Data Protection Commission in Ireland in recent months. The reason for this is that as lead regulator for some companies, we act not alone as the Irish regulator, but also the EU EEA regulator in cooperation with our peer regulators. Last Friday in Koninklijke, the Court of Justice also spoke about the least intrusive means of data minimization as important consideration in the test. So, by implementing safeguards, less intrusive processing, data minimization, enhanced transparency, effective opt-outs, etc., the controller is more likely to have properly considered the individual rights, and this could see the balance tilted in the favour of the company's legitimate interest. For the Data Protection Commission in Ireland, examining a proposed modular system prior to development and deployment, much comes down to the company's preparation. Early engagement with the regulator allows concerns to be worked through. In my authority, we have for many years had a supervision function which engages and meets with companies regularly. In fact, yesterday I had a meeting with a large platform, and today I'll have another meeting. This relationship has to be based on trust and full disclosure. Large platforms and small SMEs avail of this engagement, and it supports our aim of consistent, coherent and fair regulation in conjunction with our fellow European regulators. More and more proactive regulation means engaging and acting in real time. Our engagement in the last year has seen proposed AI models pass and others being postponed pending further regulatory discussions. In the long run, better preparation and consideration of data subject rights brings better, safer products and services to market, which will also have the better trust of consumers. Of course, this is subject to the caveat that post-facto enforcement regulation may also occur. The pace of generative AI development is high. The purpose from the DPAs is not to inhibit innovation, but to ensure that all new technologies take full account of data protection rights, and we do this in cooperation with the European Data Protection Board. Of course, an existential type question arises. Does data training an AI modular system or data in such a system remain personal data during its lifespan or afterlives? We in the DPC have been addressing issues arising with AI and personal data across industry, and in September this year, we made a request to the European Data Protection Board for an opinion pursuant to Article 64(2) GDPR. This is the mechanism by which a supervisory authority such as the DPC can request the European Data Protection Board to produce an opinion setting out its views on any matter of general application or producing effects. The opinion invites the EDPB to consider, amongst other things, the extent to which personal data is processed at various stages of the training and operation of an AI model, including both first-party and third-party data, and the related question of what particular considerations arise in relation to the assessment of the legal basis. Being relied upon by the data controller to ground that processing, the EDPB is in charge of progressing the opinion, and with our fellow regulators, we are contributing to that work. By the end of the year, we will have a harmonised position across the EU on this most difficult area. Thank you. Thank you.
Thank you very much, Dr. Hogan, for speaking at this year's privacy conference. I actually can't see any questions on my screen right now, so thank you very much and have a good day.
Thank you.
Thank you. So now we turn to our next panel, where we will dive into the world of responsible online advertising. Leaders from Google, Accenture, Douglas, and the Lufthansa Group will discuss the value of responsible advertising from their unique industry perspective. This promises to be a very dynamic discussion, so let's welcome our panelists. First, we have Mike Egbert, Head of E-commerce Performance Management at Douglas. Next, Tobias Kellner, Industry Relations Manager at Google, Karin Libowitzki, Managing Director at Accenture, and Jörn Sarkowski, Senior Manager, Project Lead Customer Data Platform at the Lufthansa Group. I am very happy that you're all here today. And before we dive right into the discussion, we are going to show a very short video.
Access to information.
You don't even think about it, just there, and it's free.
I think it democratizes the ability to publish information. We need diverse voices, and large and small.
Hey, I'm Corey of Curb Free with Corey Lee. There are so many financial barriers for people with disabilities. If they had to pay to view it, that would just be something that I would never want to do, and I never will do.
Okay, it seems like we have some technical issues. We'll just look at that and try to start the video again. I think it will just take 2 or 3 seconds. It should be better if we get the video with sound. Okay, perfect. I think we're back. Sorry for that. Now we'll try again with the video and hopefully get it with sound too.
From that very first banner ad, the engine of the internet was advertising.
The internet could not have become what it's become without advertising.
And that turned into a fantastic business model.
Advertising delivers on that original promise of a free and open internet.
And that has dramatically increased access to information.
You don't even think about it, just there, and it's free.
I think it democratizes the ability to publish information. We need diverse voices, and large and small.
Hey, I'm Corey of Curb Free with Corey Lee. There are so many financial barriers for people with disabilities. If they had to pay to view it, that would just be something that I would never want to do, and I never will do.
Digital advertising is a massive economic driver. It's linked to almost every single modern business.
Because every dollar that they spend on advertising, they can get $2, $3, $4, $7 back.
It creates a win for the user with free content, a win for the publisher, and a win for the advertiser.
The world without advertising would be highly unsustainable.
Perfect. With that in mind, let's dive right into our discussion regarding the data privacy aspects of online marketing and advertising. Tobias, I would like to start with you and take a look at Google. How does Google approach the challenge of balancing user privacy with the need for personalized ads?
Yeah. Hi, Isabel. Hi. I'm happy to be here, and I'll try to speak as fast as the people did in the video. So I think Google's approach to balancing one, user privacy and with personalized ads is constantly evolving in response to, and what we've heard, user expectations, technological advancements, and also regulatory changes. And I think it's also important to mention that, according to a study of Public First and Google, 70% of EU businesses have used digital advertising tools in 2024. And we have seen that more than 80% of consumers also want offers that are aligned with their interest. Now, to your question on, how to balance this, I think I want to highlight 3 aspects from our perspective. One, we have increased user transparency and controls. So, for example, we introduced the My Ad Center, where you as a user can go in and with a few clicks, for example, personalize your ad settings or even deactivate personalized ads. And that's really, fast. I actually tried it this morning. It's like 2 clicks. Or you do transparency about data usage, where really we explain on one website on transparency.google, how is data collected, what are our policies, and how also you as a user can flag content. I think the second one that's really important is that we have clear guidelines. So for all personalized ads targeting features, we don't, for example, allow sensitive interest categories, among them, for example, health, sex, race, or religion. And last but not least, and I think we will talk more about this also in the panel, is in collaboration with the industry, we are developing what we call privacy enhanced technologies, so PETs. And I'm sure we will talk about this more also now in the session.
Yeah, we definitely will. Thanks, Tobias, for that. Karen, when we now look at your perspective, how, from your view, do companies reconcile the need for user data with compliance to regulations such as the GDPR or the CCPA, from your point of view?
So maybe before we dive into that, I mean, it's in the end, it's really super customer centric, right?
Yeah.
And I mean, Toby just mentioned two data points. I would love to add 2 more.
Of course.
So it's like more than 70% of the consumers are more likely to buy from brands that are transparent about how they use the data, right? And in addition to that, more than 80% of the consumers today expect brands to use AI responsibly and ethically. And I think that comes with exactly that question that you just posed. So it's really that companies need to balance the need for user data with compliance regulations like GDPR and CCPA by doing a few key things, right? And one is really around creating a clear data privacy policy. Another one is really around using strong data protection measures like encryption and anonymization. Another one is really around running regular audits and assessments, which will help spot any vulnerabilities and also keep data protection measures up to date. Also, companies have started to run extensive training programs to make sure that their employees understand their role in protecting the data. And last but not least, it's really about advanced technologies like AI and, of course, for a long time already machine learning that help to analyze data efficiently while also keeping it secure. So I think by taking a holistic approach with the consumers in mind, specifically in the context of responsible advertising, it's important to not only meet the regulatory requirements, but really also to build trust with customers and stakeholders and elevate the brand and the brand value.
Yeah, thanks for that. And Mike, if we talking about the changes in regulation, how have the changes in data privacy laws impacted your ad spend at Douglas, and have they affected the campaign effectiveness in a way, or how are you handling it in a way? Maybe you can tell us something about that.
I mean, it is a super exciting challenge, and we have whole business units to try to prevent the impact on campaign effectiveness. Overall, we are a growing business, and therefore ad spend is also growing. We are very happy to have increased the efficiency years over the years, but still the world got more complicated. For us, it's increasingly harder to take the right decision on where to spend the next euro of marketing budget. And we have internally a whole lot more complicated processes and workflows to ensure data privacy and accordance with local laws.
Do you have an example for us? What specifically is hard for you in that process?
Yes, definitely. A marketer today needs to know where his data goes, when it goes there, in what format, how is it encrypted. a marketer, digital marketer 10 years ago probably didn't know that. So talking with data protection and lawyers in the end is an extensive part of a good digital marketer's work today. And that wasn't the case 6 years ago.
Yeah, thanks. Now, maybe let's, Jörn, take you into the loop. As a global airline, how does Lufthansa, as a big company or group, balance offering personalized services and also respecting, especially passenger privacy in your advertising campaigns?
Well, personalization is a key topic in advertising nowadays, and it's also on our roadmap, especially from 2025. We call it hyper-personalization or radical personalization. So let's see how hyper-personalized we can get in the next 2 years. But in advertising, this basically means showing ads to recipient and customers that are interesting to them. So we talk about relevant ads here. And for personalization, to enable that, you often need certain data to do that. So information about the recipient or the customer, what they're interested in and what they are not interested in. And this can be provided, for example, in terms of in the form of third-party cookies that can be provided by Google or Meta for targeting, but we also can use our internal data that we collected from our customers. And we use a platform, as my title name it, is a CDP, a customer data platform. And with that, we can build audiences and we can activate it. So we would encrypt it and push it to a Google or a Meta, so they can offer us this data or similar data like that for targeting. The collection point for our internal data that we built the audience on is Travel ID. And Travel ID is basically the name for the Lufthansa Group that a customer can build their profile and they can connect it to our app and then connect it to their Miles & More account. So it's basically an app where they can manage their permissions and their preferences. And basis for the usage of this data is, of course, the consent. Otherwise, we cannot use it. So the question is now, to whom do we advertise and who do we exclude from advertising? And this is exactly the balance we are talking about. We cannot and we should not utilize this data only to upsell or to commercialize it. We also can use it for excluding people from certain advertising campaigns because they might not want to see these ads. And on one hand, that creates relevancy for the customers and it creates savings for us as a company in the ads.
Yeah, very interesting and very complex, of course. And now if we maybe take a look at the impact of future privacy regulations, if we kind of dive into that a bit. Karen, from your perspective, how do you help companies to navigate the complex landscape of privacy regulations across all the different industries in a way? Maybe you can talk us through that a bit.
Sure. And I mean, like we've just heard, right? I mean, all those systems and setups, they require a technological backbone and a data strategy on the back of that, because a CDP is a system, it's a very smart system, but it needs to be set up according to not only the regulatory requirements, but also the user experience requirements, also the brand requirements, also the, even publishers' requirements in the end, right? And this is essentially where we help companies. It's really about offering expert guidance and also tailored solutions, really collaborating closely also with all the data protection and data privacy officers that companies have in place, as well as, of course, the marketing departments, as well the commerce and sales departments. And it's really around, on one hand, implementing robust data protection measures, including, like Jan also just mentioned, encryption and also anonymization to safeguard personal data, but also really also helping by conducting regular audits and assessments, just making sure that everything's set up and up to date, also preparing for new policies that are going to be launched, the EU AI Act and other measures that are going to affect all of the businesses, and specifically in advertising. We are also providing extensive training and awareness programs. We really leverage, as I mentioned before, more advanced technologies such as artificial intelligence and machine learning to really help the enablement of processing large volumes of data quickly and accurately, but ensuring that personal data remains protected, right? And last but not least, and I think this is probably the game changer, is making sure that companies build a culture of privacy, so that they start living up to the design principles of privacy by design in anything they do, including advertising, including their search campaigns, including their YouTube presence, including influencer marketing, including social commerce, you name it, and really focusing on that build up and build out of that culture of privacy as a commitment, and also as a naturally understood relevant item in an organizational culture, because then in the end, this is going to help clients build trust with their customers and stakeholders. So that's it in a very, very quick nutshell.
Yeah, thanks very much, Karin. You kind of scraped at the compliance aspect. And Mike, I want to jump on that for your next question. How do you at Douglas ensure compliance with, in your case, both local and international privacy laws when running your global advertising campaigns? Does that make a difference in a way, or how are you handling that to be compliant?
Yeah, that's a very good question that is keeping us awake every day. And what Karin said is actually one key element of that. Karin mentioned privacy by design, which when I joined the company 5 years ago, we customized what and how to share data per market. Today, we no longer do that. We rather define a global strategy of what data to use, what audiences to target, and usually most of that is based on our own loyalty program, which is of course helping us. We have 57 million households in Europe actively opted in to participate in our own loyalty program. And if we decide that it is a good idea to do a specific way of hashing the data in a specific moment, we roll this out to all markets we have. Even though you might not need it in Bulgaria, or you might could do it a bit more loose in Switzerland. Actually, this increases the efficiency of our processes, even if we might lose 1 or 2 percentage points of efficiency in some of the markets.
Yeah, that's a very interesting aspect, that you kind of aim to find one way that fits it all in a way, because it makes your compliance easier. And Jörn, at Lufthansa Group, maybe a kind of general question: how is Lufthansa preparing for future privacy regulations? Or if you want to jump on what Mike and Karin said, you may also do that.
So preparing for changes or preparing for something like that is not easy. I would call it more as a reaction. That's how I would describe it. And so how do we react as a company to that? And it's more about what we can do when these changes get announced to be compliant once they become effective. And so what we can do is anticipate them, right? We can follow the developments in the markets and in the industries, what is going on, and anticipate the direction where it could go. At the Lufthansa Group, we thought we can also do create a setup which allows us to act fast in that sense. The Lufthansa Group is very, very big. You don't only have Lufthansa, you have Swiss, you have Austrian, Brussels Airlines, Eurowings. You have a lot of airlines. They operate in different countries, and the whole Lufthansa Group advertises in more than 80 countries. So we said for ourselves, okay, we act according to GDPR worldwide, and because it's the most strict one, and I think that was a good decision that we do that. And we have a topic that is commonly known, centralization. So everywhere where we work with data or we work with tools that can enable or can enhance advertising worldwide, it's heavily centralized. And it's heavily centralized for almost all airlines. And of course, every airline have their DPAs and DPOs, but they exchange on a regular basis. And we have a setup. Even the CDP is when we do advertising or airline plans a campaign, then they contact us and we can support them in whatever they need. And I think centralization is a big key. What we also work on is an advanced permission concept. So a daughter department of ours, for example, they work on an overarching concept that makes it more clear to the customer what we are doing and what the data is used for.
Yeah, thank you very much for these insights. And Toby, when we look at Google and have in mind what Jörn just said, that for them, especially the heavily centralized aspect is quite important. How do you handle it at Google to comply with global privacy regulations, not only the GDPR, while kind of maintaining advertising revenue for your partners in advertising?
Yeah, I think the short answer would be technology and policies. And the long answer would be that, we're using privacy by design, which was mentioned a few times now. That's something we've been implemented and using for many years now. And I think, but there's a lot of more technological advancement that I think I'd like to call out. I mean, we've talked about differential privacy for a while, that, you can use to deliver relevant advertising to groups of people without exposing individual browsing history. Then we also have on-device data storage and computation, which keeps potentially identifying user data on a user's device. So it's safe there. And I think very recently now we're talking about these trusted execution environments. And that's where we've seen a lot of progress recently, which is really a secure computing system that combines hardware and software protections to guarantee even the confidentiality and integrity of the code and its execution. And I think that is something that, where the code is kind of operating in isolation and is protected from observation. So regardless of the user rights. And so this really works like I would say like a house where only the advertiser would have the key to unlock it. And we recently launched a product at Google that is called confidential matching. And that's basically a further development of our existing product Customer Match, where advertisers can already match their own data with Google's data to reach the target audience. And now with these trusted execution environments, we are going one step further, and we actually give a technical guarantee that this first-party data and matching can only use in a predefined way. And so I think there we can again increase the data security for everyone that's involved. So for the user, for the advertiser, and also, for us, as we also have our own first-party data. And I think that has been a concern for customers in the past and a topic for regulators. And that's something we now can really bring to the market.
Yeah, thank you very much. If no one of you has something to add to that point, I would like to jump to our last big session or big topic. We still have a few minutes left. So I would like to address the topic of collaborating in innovations for responsible advertising. Mike, what are your thoughts on the rise of contextual advertising as an alternative to data-driven targeted ads?
Honestly, I believe this would be a step back. I believe the best thing that has happened to ads is relevance. And if we go from data-driven to contextual, probably on average, the ad gets less relevant. So I don't think that's a solution. I believe the solution to that is doing data-driven in a way that is privacy safe. And I'm very proud that we do that at Douglas, and we get better at that every day. But contextual is not the answer, especially not in e-commerce.
Yeah, that kind of leads me to my next question for you. How do you anticipate changes in ad technology and privacy trends impacting your business model?
Actually, I believe for retail, I mean, in the end, we are a retailer.
Yeah.
And for a retailer, actually, this kind of strengthens our position on the market because we have access to customers. Yeah? We are the ones where customers are willingly sharing parts of their data and their consumer behavior. So of course, this is also a business opportunity for us. Yeah, this is not only a pity, but with retail media solutions, I mean, the retail in itself becomes an ad platform basically, where we can trade inventory on our first-party data in a secured way.
Yeah, Jörn, if we stay with that point and kind of, with evolving ad technologies, what innovations do you at Lufthansa, or what innovations are you exploring to create more privacy conscious advertising that still delivers value to your Lufthansa's customers?
Well, we do a couple of things. I would say we try to upgrade our MarTech stack. So I already mentioned the CDP, the Customer Data Platform, that we can use to bring more relevancy in advertising to the recipient of the ads, or to our customers. I mentioned the Travel ID, which is, as mentioned, the profile, the app-based profile where they can adjust their preferences and permissions. What I have not mentioned is a heavily advanced content management platform. A content management platform, you need basically to store the content of the website visitor or the user with timestamp and so on. So everything is stored there. It can include also a cookie banner. Of course, we have such a tool already, but it's in a integrated for the integrated part to other systems, it's not as advanced as we would like it to be. And that's why we are eyeing on getting a new one. Another tool is, and highly relevant for the CDP project and for marketing and on display advertising, is a data clean room. And a data clean room is a secure and controlled environment that allows two or more companies, like an advertiser and a publisher, to find matches in their data to enable personal advertising. We used in the past Customer Match, which was a technology by Google that allows using audiences from first-party data on YouTube or on other publishers like Frankfurter Allgemeine, for example. As a consequence of the Digital Market Act, this Customer Match functionality is now limited for a few months. And we now have to find a data clean room to use then confidential matching, as Tobias described it, or Google Pair, which is a new technology from Google to reinstate these conditions. And this is something we are looking into in the future. And I think when we have that, we have finally a MarTech stack that we can show and we can be proud of.
Yeah, very, very interesting. Karin, for you, do you also have certain trends that you're seeing in the way advertising is evolving in the future, and particularly in consumer expectations for data usage? How are you planning on handling it in the future?
Yeah, I think we've heard a lot already, and I think specifically also with the two advertisers that we have the privilege to have that panel with. I mean, they are both very mature, and they have both started to leverage all the first-party data and the treasure that they have from their loyalty programs, and have really best-in-class approaches. And what we used to know as a data management platform is a CDP today, which is a much more powerful tool, right? And I think really embracing the advancements of that we see in the technology space, even if it's data clean rooms, it's CRM systems that get composed into MarTech stacks, additional new privacy-ready measurement solutions, relying more on first-party data. So that's a trend that has been going on, but it has just been accelerated and supported by new technologies available. Then, of course, we do have the large bucket around advanced technologies from the AI and machine learning space that are really helping all of us to not only analyze data, keep our data-driven advertising approach, while still creating personalized experience without compromising privacy. So I completely agree also to what Mike said. And then I think a third topic that sometimes slips off the table a bit is there is a great demand from consumers who get more and more concerned about the environmental impact of their digital activities. So it's really around sustainability in the advertising supply chain, and really also making sure how that is being managed. And that can then also be used to increase the footprint and the trust in the brand. And many of those brands have started to be much more transparent about their data policies and better communication with customers around that. And there you can really have a competitive advantage by outlining how you even are more sustainable or following your sustainability agenda with, being very conscious of the data that is used, data consumption, and the impact on the environment that it has. And then last but not least, I mentioned that before, it's really the culture of privacy design, privacy of designs, which are two trends that are followed through by very mature companies already, but also picked up by others. And in the end, it's really leveraging advanced technologies to create real privacy-centric solutions that meet regulatory requirements while still using the opportunity to enhance the real experience on the back of everything that is there. That's how I would summarize it.
Yeah, we've got one question from the audience regarding this point. I'll just read it because it's quite long. Isn't the data clean room approach cheating data protection? After all, it's not matching process that it's most infringing on data subjects, but the advertisement and the possible tracking when they see and when they click on the ad.
Is that question for me, I guess?
I guess it refers to your point, yeah.
Yeah, so cheating is a harsh word. When a publisher and an advertiser do matches with both their data, then it is ensured that both the data are consented, right? So, and in that sense, in the state that we are right now, this is not really cheating. And the data is obviously not, you don't exchange raw data, it is encrypted. So you encrypt it or you hash it, so to speak. It's then pseudonymized. Most of the time, the industry standard is SHA-256, if you want to Google it. And then based on these hash values, you can match the data. And yeah, I wouldn't call it cheating. It is just a tool that allows us in the current advertising environment to utilize the data that we have the consent for.
Okay, thank you very much. I just wanted to push in that question. And now getting back to what Karin said, I've got one last question for Tobias, for you, regarding future technology and maybe especially AI. What role does AI and machine learning play in enabling more privacy respectful and effective online advertising solutions?
So yeah, this is obviously a complex question because now we're taking in another big technology trend, which is AI. right?
Just a short look.
I would say that at Google we have like this approach of, we call it bold, responsible, and together. Bold because it's really a big opportunity that we have in AI, especially in Germany, and especially coming from a competitiveness angle across the whole EU versus other regions, where, you know, I think the German Economic Institute in Cologne calculated in a study that there is a 330 billion euro opportunity for us with generative AI. So I think that's the bold part. Responsible, I think I outlined before, and I think a lot of the other panelists also outlined, you know, the accountability aspects, you know, that we have independent auditors, transparency aspects that we also, you know, obviously implemented also with the changes of the DSA, a lot of explainability that we now use also as a consequence of the DSA, but also we had in place already before. And I think the last part of togetherness is really this collaboration that I think is key between, you know, technology providers like us, but also, you know, regulators, advertisers, and partners such as Accenture. I think that coming together is really what is needed. And I think that's also a key takeaway, if you will, from the panel, that, you know, all stakeholder groups are committed for a more privacy enhanced future of advertising. And also in the area of sustainability, Karin mentioned it, it's the same, we need to work together. And that's why it's really helpful to have also Bitkom as a trade body and the digital marketing group, where we can discuss this regularly and also work on it in terms of, you know, papers and common approaches.
Yeah, thank you very much. That definitely is a good takeaway from this panel session. And you just spoke about the digital marketing group, and I just wanted to, mention that at least if you're more interested in these kind of topics regarding data privacy and online advertising, on November 5th, the Bitkom Digital Marketing Group will meet at Zalando in Berlin to discuss AI in advertising, 2024 reality check and future outlook. So I think you then will dive deeper into that topic on the 5th of November. So if you're interested in the audience, someone let us know. And at this point, thank you very much, Karin, Jörn, Tobias, and who did I forget? Did I forget someone? Jörn, Karin, Mike, sorry. Thank you, you all. We took a bit longer, but I think we got to say everything, and thank you very much. And talk to you soon.
Thank you.
Thank you.
Thanks. Bye.
Perfect. So now we have one short session left before our break. And our next speaker for a short session is Professor Dr. Max von Grafenstein from the Einstein Center Digital Future, who will dive into developing more informative and trustful consent designs through empirical methods. I can see him on my screen. So welcome, Mr. Grafenstein. The floor is yours.
Yeah, thank you so much for giving us the opportunity to talk here, to announce our project here on such a broad scale. I have only 10 minutes here. I thought it might be good maybe to reserve a couple of minutes later for a Q&A. If at all, I can also delve into details on my own, of course, so I won't let you get lost in the void. So best come straight to the point. I share my screen. Where we are. Here it is. Oops. So here we are. So we are an interdisciplinary research collaboration now between the Einstein Center Digital Future, which has already been mentioned, but also the University of the Arts based in Berlin, and also this other interdisciplinary research Internet Institute, the Institute for Internet and Society, and the academic spin-off Law and Innovation. And we have been running a couple of research projects in the last 6 years, where we have been researching how to design consent banners in a way so that end users can really understand what they are actually consenting to. And we think that we have found a solution, kind of a solution, or let's say at least an empirically validated way toward such a solution. And this is why we are now developing a universal standard for such a more effective consent banner. So the idea is that this universal standard is, if everything works out, is easily integrable into websites or other online services. And of course, also integrable into already existing platforms such as consent management platforms or European data spaces. And an important part is of the standard, as you can already see, are consent agents, which end users can use in order to preset their consents once in advance. So this is very important from an end user perspective, because in order to counter consent fatigue, which is caused by clicking and clicking and clicking and clicking 50, 100 times a day, consent banners away. And through these consent agents, they can handle this in advance. So the mechanism we built there works in a way that there is still the opportunity for end users to adapt their presettings to the circumstances of the specific website. So if the end user thinks the website is particularly trustful, they can still give consent, right? Even if they had denied it in the beginning, or vice versa. If they are very open and affirmed their consent in the beginning, they can still say on a specific website, this is actually not what I want. But what is important in this mechanism is that they don't have to actively click it away anymore after a certain period of time. So we call this the timeout mechanism. Later on, we will also define in this standard further interlaces. Especially, we will define an interlace to so-called privacy dashboards, where end users can then much more easily than before exercise their data subject rights, so if they wish. And from the industry, you may ask now, of course, so hey, did Mr. von Grafenstein, didn't he mention that these consent banners, this universal standard, will not only be profitable or very good for end users, but also for the business? So how does he come to this daunting claim? And the reason for this is actually that we have reasons to assume, empirical reasons to assume, that this standard will not send consent rates through the floor. So how do we come to this conclusion or to this assumption? Well, the reason is that we have in the last 6 years developed empirical methods in order to measure not only qualitatively, but even quantitatively via A/B tests, 3 things. Which design, so we can take different study groups, and in each study group we test another design, right? So, and we can ask 3 questions, even more, but I just sum it up here. Which design informs the data subjects best, especially about their benefits and risks of a respective purpose to which they are asked to consent? So they can understand much better the consequences of giving their consent. So this is the first question we can measure. The second is, how does this impact the trust of the data subjects into the website or another service they are just using? And the third question is then, and how is this associated to the consent rate? And here comes, so the empirical data we have so far, and we are now analyzing and also publishing in a couple of weeks or months, depending on the review process, are very interesting because they show us actually that there is indeed a possibility to design consent banners and consent mechanisms in a way which really do better informed data subjects about the benefits and risks. So they are really enabled to at least differentiate between the different purposes they are asked to consent to, what they aren't able today. Yeah. And we can also see that depending on the privacy-friendly technology that website providers or other service providers are using in order to achieve one or another purpose, so this has a great impact on the trust that data subjects have in consenting to one or the other purpose. And this then again and we can measure this, has an impact on the consent rate, of course, depending on the purpose. But we can even measure that for certain purposes, there is even a significantly increase in the consent rate. Yeah? So we are still, it's an ongoing process, and we are still trying to improve the consent banners even better and the consent mechanisms, but we are on a very clear path to achieve this. And this is actually already brings us to the point because we are now researching this methodologically since 6 years, and we are now at a point that we start our testing period together with industry partners in order to test the integration of our consent banners into their systems at the end of this year. And we think that spring next year, we will then also be able, if everything works according to our plan, to publish our first minimum viable product. And this is actually also the reason of this short talk here, because of course, anyone who is interested in participating in our industry tests or also end user tests, or everybody who should be in this round here interested in contributing to the standard we are currently writing and then also publishing, or everybody who is just interested in getting updates about the further process is, of course, warmly invited to come to us. My colleague from Bitkom is right now putting in the contact form, also the URL. It's www.consenter.eu/Raute get updated. So everybody is invited to contribute or even to participate as a tester, and we would be very happy to come back to you with further information in the next weeks and months. So this is already everything. We have reserved a couple of minutes for questions. I will stop sharing and hope that I can answer any of them, or some of them at least.
Perfect. Thank you very much, Professor Grafenstein. So far, we haven't got any questions. I think so. Just wait 1 second if maybe some questions are coming in.
The question is this a good sign or a bad sign? So
I think it's a good sign.
Yeah, you mean so everybody will be embracing it?
Yeah.
Yeah, let's see.
No, perfect, I think.
Maybe I can tie into, if you don't have a question, I can tie into it because actually...
Yeah, you definitely can, yeah.
Yeah, the panel before has already discussed that there is a movement in the industry toward more privacy enhancing technologies. And I think we can make there a difference between the B2B sector and the B2C sector. And I think what is clearer so far that if I'm a data processor and I sell my products, advertising services, for example, to my customer who is a controller, and I tell him, hey, with my technology, you apply better to the GDPR. This is already now getting more and more a competitive advantage. But what has been lacking so far is this impact on the consumer market. And the big reason for this is, we have studies who say yeah, I'm even willing to pay more for a privacy-friendly technology. But if we look at how the people really act, there is a huge difference between what people say, pretending or just saying, hey, privacy is very, very important to me.
Yeah.
But if we look at how they behave, there is little reaction, actually. Of course, we have this minority of people who really try hard to protect their privacy. I say so because it's hard. And I think the mechanism, which is really lacking here to also make that competitive advantage work on the consumer market, is to communicate the privacy level. Yeah. And so far, consent banner and all the information you get doesn't communicate how privacy friendly a certain technology is. And this is, I think, the most important contribution of the technologies or standard we are developing there, because we are able to legally assess and also to empirically validate and to check that back against the experts' opinions, of course, of the data protection authorities, of the industry, etc., that our legal assessment is then correct and shared by everybody who is important, to communicate that properly in a way to the consumer that they can really make a difference. Okay, this website provider has a more privacy-friendly technology than the other one. And then we can even measure that this has an impact on the consent rate. Yeah, just to delve a little bit deeper again there to make it clearer.
Yeah, that definitely made it even more clear. Thank you very much. So still no questions, I think. Everyone is happy. So thank you once again.
Well, hungry.
Hungry, yeah, probably hungry. So yeah, thank you very much for giving us this short presentation. And
thank you.
Now we will take a short break as we have a slight delay. We will be back at 1 p.m. and then we will hear a keynote from Thomas Zerdig from the European Data Protection Supervisor. So I hope to see you back at 1 p.m. Welcome back at this year's Bitkom Privacy Conference. We will start this afternoon with Thomas Zerdig from the European Data Protection Supervisor. He will discuss the challenges and opportunities ahead for the EDPS in personal data protection. Mr. Zerdig, very nice to have you, and the floor is yours.
Thank you. Good afternoon, ladies and gentlemen. Greetings from Brussels. First of all, I'd like to thank you for the invitation. It's an honor for me to take part in this conference to talk about, indeed, the EDPS's point of view for current and future challenges in personal data protection. Let me begin by recalling what the EDPS is. Since 2004, the EDPS is the independent supervisory authority responsible for ensuring that the Union institutions, offices, bodies, and agencies, what we call the Union institutions EUIs, comply with their data protection obligations. The EDPS is currently supervising 75 EUIs spread out all over the 27 EU member states, including, for example, the European Commission or Europol. The main tasks of the EDPS as supervisory authority are the same as those of the national supervisory authorities, which you know best, ranging from monitoring and advising activities to enforcement and cooperation, as well as providing the secretariat to the European Data Protection Board, the EDPB. So what are the current and future challenges in personal data protection? In essence, I believe they evolve around three key priorities. The first one is nourish, enhancing the effectiveness of data protection for both individuals and public administrations, ensuring stronger safeguards and better outcomes. The second is necessity. We need to address unresolved issues and clarifying ambiguities in the regulatory landscape to ensure a consistent and effective enforcement. And third, navigation. We need to guide our way through the emerging challenges, particularly in the realms of artificial intelligence, to which we are adapting at a rapid pace. So let me come back to number two, enhancing the effectiveness. We are using the celebration of the EDPS's 20th anniversary as an opportunity to take stock of the past and to build on the present, to approach the upcoming challenges in a way that respects individuals' privacy and leaves no one behind. Throughout this year, we are unveiling 20 initiatives, commitments and actions illustrating the EDPS's continuous aspiration to lead as a modern data protection authority. We are promoting new approaches and innovations to our work that we believe will bolster individuals' right to privacy and data protection. And let me give you 4 examples. At the beginning of May, we published our guidance on generative AI. This document provides orientations on various aspects of generative AI and data protection, in particular on issues related to the application of data protection principles when public authorities intend to use such technologies. We are also working on more transparency for data protection complaints and resolutions. We see that the public trust in data protection critically depends on how well infringements on individuals' privacies are managed. And traditionally, the EDPS has processed complaints internally with minimal visibility provided to the controllers, to the EUIs, and the wider public. Our initiative now aims to reform this way and to reform how the EDPS discloses information on complaints and how we handle and resolve them. By sharing more data on the complaints received and their outcomes publicly, we can hopefully demystify how these are handled, highlight our work, and share, obviously, success stories and lessons learned. One of the other missions of the EDPS is to promote a strong data protection culture inside the EU institutions. And to achieve this, one of our key tasks is to carry out audits and inspections, which are crucial to preserve accountability and to preserve high data protection standards. Again, traditionally, only some audit reports and their executive summaries are shared with the public, for example, in annual reports or for internal evaluations. Again, we believe this needs to change, and we strive to be more transparent in our processes and outcomes, and to publish more on our audits and inspections, also thereby fulfilling our role as educators in data protection. Then finally, we have the EDPS's 20th anniversary book, where we chronicle how the EDPS came into the existence and how we developed, but it's also a rich resource for you to seek what key experts have to say on specific issues of data protection, compliance, and developments. And obviously, this is a free download from our website, so I can only recommend you to read this. With these initiatives, the EDPS hopes to make data protection work better in the future for individuals, but also for controllers and in particular the EU public administration. Then we come already to the issue of addressing unresolved issues and clarifying ambiguities in the regulatory landscape. After 20 years, there are still important issues to clarify for data protection in practice. I see it every day in my office. And while the Court of Justice in Luxembourg is doing its best to deliver tsunamis of data protection judgments, both the EDPS and the EDPB are engaged in providing further clarity, practical tools, and guidelines. So, for example, as most of you will know, on the 8th of March this year, the EDPS issued a decision against the European Commission following our investigation into the Commission's use of Microsoft 365. And we imposed corrective measures on the Commission. The EDPS did not make this decision lightly, but we found infringements by the Commission of several key provisions of our regulation in the use of Microsoft 365. And that's why we expect the Commission to implement, when necessary with the help of Microsoft, all orders by the EDPS. And since we understand that the Commission will intend to implement those measures, we will assess after the 9th of December this year whether the measures taken comply with the EDPS's orders. And at the same time, the Commission and Microsoft, both and individually, have brought legal actions against the EDPS decision before the General Court. The EDPS, of course, defends its decision, and these court actions do not suspend our order. I mention these cases because these cases raise important questions for any data protection professional, such as, for example, on the exact obligations of a controller vis-à-vis their processor when it comes to documented instructions, purpose limitation, international transfer mapping, and unauthorized disclosures. Similarly, I'd like to draw your attention to another pending case in the Court of Justice. Our appeal against the General Court's decision in the SRB case will hopefully provide the European Court of Justice with an opportunity to clarify the case law on what is personal data, from whose perspective is personal data personal, and on the notion of pseudonymization, and as well as the principle of accountability and how far it goes. Turning to another point, crucially for the success of the EU data governance framework, which we all are faced with, crucially for that success will be the smooth enforcement between the Commission and other competent authorities in the member states, but also including data protection authorities such as the EDPS. This is why the EDPB will be working on guidelines on the interplay between EU data protection law, in particular the GDPR, and other EU data laws, including separate guidelines for each of the AI Act, the Digital Service Act, the Digital Markets Act, and on the interplay between EU data protection and competition law. As regards the still hot topic of transfers, we have published the EDPS Model Administrative Arrangement for transfers from EU eyes to international organizations. And this model hopefully will help EU eyes to comply with the applicable regulations when they need to transfer personal data to international organizations within the remit of their role. This model text covers transfers from an EUI to an international organization as a separate controller. There is no obligation to use this model, but the aim is to facilitate transfers and to help us by accelerating the authorization procedure. We have also come across an important question to be clarified concerning transfers of human resource data under the EU-US data privacy framework. Briefly, as you will mostly know, an entity can self-certify under the DPF for non-HR data and HR data, ensuring an extended protection for the latter. This encompasses, for example, limitations on further processing of the data and competences for supervisory authorities. So what's clear for the moment is that you cannot transfer HR data to an entity which is not certified for HR data under the DPF. But we have seen that when it comes to transfers for entities certified for HR data, it seems that there is a divergent interpretation between the member states and the US Department of Commerce. The US side considers that only HR data shared within an employment context is covered. For example, if the exporter and the importer belong to the same company group. Our view is that if, for example, the European Commission transfers personal data of its staff members to a service provider under the DPF, including cloud services, it should benefit at all times from the extended protection of HR data. So we are working closely with the European Commission to clarify this issue. This question has already been raised within the framework of the EU-US data DPF review. And following this, the Department of Commerce, the FTC, and the EU data protection authorities have already agreed to develop common guidance instruments, also in particular on this question. We have in the EDPS tried to clarify also something which is essential for any data protection supervisory authority, the right to be heard. From now on, the EDPS will draft a preliminary assessment and communicate it to the controller before adopting a decision concluding on infringement of the regulation or when we exercise our corrective powers. This is an opportunity where we will also involve complainants. They will also get a chance to express their views before a decision from the EDPS which affect them can be taken. This is a streamlining effort on the part of the EDPS to make sure that the right to be heard is granted in our complaints and investigations procedures. Just for your knowledge, to further clarify certain things, the EDPB has just adopted new guidelines on the processing of personal data based on legitimate interests. This is in particular of relevance under the GDPR. And the good news is that these latest guidelines already take into consideration the recent ruling from the European Court of Justice on this matter from the 4th of October. These guidelines will be subject to public consultation until the 20th of November. There are also more guidelines coming up, for example, on the right of access under the Law Enforcement Directive, and many more, all of which you can find in the work program 2024-25 by the EDPB. What are the emerging challenges? I'd like to end my intervention with a few words on the major challenge that I think we all face these days, and we've seen during those 2 days already at this conference, the ever-increasing use of artificial intelligence, and more specifically, the AI Act and its interaction with the data protection framework as we know it. Well, we'll probably all agree that data protection and AI are heavily interlinked, right? The EDPS's message is data protection and privacy will not merge, nor will they disperse into artificial intelligence. We must defend data protection and privacy against the risk to dilute them into the AI hype. In fact, this could only mean dangerously weakening these fundamental rights, and therefore the two must remain separate. However, I'm not naive, and you are certainly not a naive community neither. Of course, artificial intelligence is fueled by data, and much data that some of the operators refuse to recognize as personal because they claim these data have been aggregated or anonymized, or they were publicly available, and therefore data protection doesn't apply. Artificial intelligence and data protection are different, and so are the legislative frameworks related to them, and they all apply in their relevant scope. Artificial intelligence systems should represent an opportunity and not a threat for, in particular, the new generation. So it's important that we all work together to help, in particular, our children to develop a healthy relationship with technology. And this also means setting healthy boundaries around its use. And therefore, compliance with data protection and privacy is the essential prerequisite to put people, us humans, at the center and ahead of technology. We must work together to defend this identity of personal data protection to protect, ultimately, humanity. You may know that in addition to its role as supervisory authority for data protection, the EDPS is now the competent authority and market surveillance authority for AI systems put into service and used by EU eyes under the AI Act. And this is in this new role, and not in our role as data protection supervisory authority, we have developed a strategy for the use of AI systems in the EU eyes. And one central pillar of that strategy involves a proposal that every EU public administration should appoint an AI Act correspondent to facilitate compliance with the obligations from the AI Act. This role is not the same as a DPO, cannot replace that function, but it is very clear it's similar, and DPOs in any case must be associated and part of the discussion on AI systems. With these small outlooks for the future, I want to say thank you very much. We are aiming to anticipate these challenges and opportunities, and we are hoping that we will be able to enforce with modern tools and survive essentially in this digital landscape for us all. Thank you for your attention.
Thank you very much, Mr. Serdig, for your overview. As for now, we don't seem to have any questions, so we will head right on to the next point. Thank you once again, and have a good afternoon.
Thank you for having me. Have a good afternoon.
Thank you. So we will jump in right into our next panel, which tackles the topic of scoring, its economic relevance and the balance between consumer interests and data protection. Let's welcome our experts from Schufa, Zalando and Coeo Group. First, I want to welcome Dr. Hans-Christian Woger. He is Head of Privacy, AI and Tech Law at Zalando. Next, Dr. Kevin Yam. He is Chief AI Officer at the Coeo Group. And last but not least, Justus Leonard, Head of Berlin Office at the Schufa Holding AG. Yeah, so welcome once again, you all, to today's panel discussion, Economic Relevance, Legal Framework and Digital Identity in the area of conflict between data protection and consumer interests. In our increasingly digital economy, credit scoring and the use of personal data for profiling have become central to business decisions in a variety of sectors, from financial institutions to e-commerce platforms. While scoring offers undeniable economic benefits by assessing risks and fostering efficiency, they raise significant concerns or can raise significant concerns related to consumer privacy and the ethical use of personal data. How do we balance economic relevance with the data protection laws, such as the GDPR, and address the growing concerns from consumers about transparency and fairness in the system? To explore this, as I just said, I am excited to be joined by our experts. To start, I would like to ask each of you to briefly explain the role of your company and how you use scoring, or how personal data in this, and regarding to scoring, why it's important for your business. Maybe, Mr. Leonard, you want to start?
Sure. Thank you very much. I'm very grateful to be here.
Thank you.
Scoring is actually, for many people, still too much a black box many times, or very often. So I'm very happy about every opportunity to tell more about scoring and its significance and how it works. Schufa is one of the most important and biggest credit bureaus in Germany. And well, to make it short, the mission of our scoring is to enable consumers to participate financially and economically. That is the benefit for consumers. And the benefit for companies is to reduce their risk while providing services like loans or other products. So there are, that is very important for me to emphasize the two sides of the benefits: to support companies in their risk management, that is one side, and the other side is to enable consumers to take part in economy and the financial system. So therefore, this is to the benefit to the economy and the financial system as a whole.
Yeah, thank you very much. Mr. Yam, maybe from your perspective, how does that affect you? I think you're still muted.
First
Now
of all,
we can hear you,
Coeo is one of the leading or major European debt collection firms, especially when it comes to the usage of AI and data-driven technologies. And we using and applying AI-driven, machine learning-driven, data-driven scoring models and decision tools for decision making in nearly every process of debt collection. And what is the aim of this application? I would say, on the one hand, we want to improve cost-income ratio aspects. That is clear. But on the other hand, we see a lot of opportunities to improve also customer experience by implementing sophisticated scoring models and models for improved decision making.
Yeah, and last but not least, Mr. Woger, maybe you can give us a short look into how it affects you at Zalando.
Yeah, no, thank you for having me, and thank you for offering the opportunity to speak our perspective here. So, I mean, we as Zalando, we are in a slightly different position than the two people I'm on the panel here with. We are the biggest ecosystem for fashion in Europe. We serve around 50 million active customers at the moment. And of course, offering those customers a trusted environment and an environment where they can feel safe to interact with us and to have a great shopping experience is essential for us. What I want to say today is, or want to hope we focus on the discussion is, there is not one scoring, and this is what I heard in the my two colleagues here talking before me. It's very much focused on the public discussion about payments, about creditworthiness. But scoring is much, much more. There's risk-based decision, there is fraud prevention, and those are even slightly more important for us than the pure creditworthiness decision. But simply for us, Zalando is about selling. We started selling shoes, so we are not in the business of offering credit or loans or anything. Therefore, this is what I want to transport here also today. And I think this gets a little bit lost in the discussion at the moment. Scoring is much more than just creditworthiness checked.
Yeah, thank you very much. That's why you were also on this panel. And yeah, first I want to give back the question to Mr. Leonhard. As you already said in your opening statement, for Schufa plays a major role in credit scoring in Germany. If you could briefly explain the economic significance of credit scoring in today's financial system, if we maybe take a look at that first, and how it balances risk assessment with consumer rights from your perspective.
Yes, thank you very much. As I said in my opening answer, scoring is very significant for our companies, for our economy, for companies and for the consumers. And the benefits for companies and consumers actually go hand in hand, because with our information, credit agency like Schufa it is, we help consumers to fulfill their wishes and companies to reduce their risk. So, but I would underline in the beginning one point which is very important for me, that we as Schufa, we are very aware that we are acting in a very sensitive position as intermediaries between the interests of companies and banks and consumers on the other side. And of course, this comes with a very, very special responsibility. But to come back to your question about the economic significance, companies can reduce their risk. So we help to reduce information asymmetry between consumers and companies. And by having a good picture of associated risks, companies can lower their default rates. And this enables companies or banks to grant more loans and to offer more business transactions or services. And this is, of course, to the benefit of consumers as well, because it supports financial inclusion, economic participation, and it also, which is very important, protects consumers against over-indebtedness, which is a very crucial point, especially for vulnerable groups among consumers. And maybe, I don't know how much time I have, just to get an idea about the impact of credit scoring and its importance to reduce credit defaults. On our own analysis, they show that default rates in the economy without any information would be 12%. And once we add in the end the negative and positive information that Schufa obtains from its partners, these default rates can be brought down to as little as 2%. And I think these numbers illustrate quite crucial the important role of credit bureaus and scoring Schufa provides in creating trust between companies and consumers and enabling more businesses.
Yeah, thank you very much. Maybe Mr. Yam, you can jump onto that in a way. How do you in your company ensure that the use of scoring models doesn't unfairly penalize consumers? And yeah, how do you address the legal framework concerning consumer data protection? Maybe you can take us into that a bit more. You're muted again. No problem.
I think there are several aspects, but to only name but a few. For example, we take great care on selection and preparation of data in the development phase and deployment phase of scoring models. And every scoring model is heavily tested under real conditions, or one can say real-world scenarios. And so even in deployment or after deployment and in the production phase of a scoring model, we invest a lot of effort for the quality monitoring and quality assurance. So moreover, we also use a lot of AI-driven and machine learning tools in order to detect and identify model-related risk. For example, problems like shortcut learning and data drift. These are technology-related or model-related issues, and we are already using machine learning tools to detect these problems that can occur in scoring models. And especially regarding legal aspects, I can say that so every step in the development of scoring models is subject of a profound legal assessment, also with supports of external experts and documentation.
Yeah, thank you very much. Now, Mr. Woger, I would like to come back to you. And as you already said in your opening statement, Zalando kind of has a different role in all of this scoring stuff. Yeah, maybe you want to tell us how Zalando uses data-driven scoring in the context of digital identity to enhance customer experience. Because yeah, in comparison to Schufa and Coeo, it maybe is a bit different, and maybe you can talk us through that a bit.
Yes, I mean, we are in a different business.
Yeah.
So, but I think the question you asked points to two major points I want to address here. One is the major point we are talking about when we talk about digital experience or digital ecosystems for the next years is trust. Justus already mentioned this. Schufa is also looking this in the same direction. Without trust, irrespectively, if we talk about as an ecosystem as Zalando is, or as an agency like Schufa, people will not use our services, or they will not shop with us. They will simply take their business elsewhere. And our great benefit that we do have as European companies is actually to give this trusted experience, to build a safe environment. And this is not only a question of data protection. Data protection is one part of it. There's information security in there. There's use protection in there. There's e-commerce in there. There's all that combines it to that the customer makes the decision, I want to take my business to this company, or I want to use this service. And if we don't build this, or if we don't give the customer the truthful experience concerning this, we'll lose our business. For us at Zalando, scoring is actually a very important part, because as simple as it sounds, we don't see the customer in e-commerce. I don't see when you shop with me. I don't have you in my store. I can't say, maybe this person can pay or not. Or maybe, hey, this is a credit card that was used last time. But scoring is not only checking if someone can pay bills. It's crucial for transaction. I mean, imagine you lose control, or let me give an example. You lose control over your account because your password got leaked and you use your same credentials for every platform. By the way, don't do this. Use password managers, because this would actually ease a lot of the trouble for platforms. But nonetheless, your password get leaked, your credentials get leaked, someone tries them out on our platform, and it worked. Problem is now we only see you logged in with right credentials. Okay, you seem to be a legit customers. Then you start purchasing, and we assess then, is there a purchase pattern that might actually differ from what you did in the past? And you have a payment method and an address that differs? This sounds or looks fishy. We might actually cancel the order to protect you. We might ask for your confirmation. Hey, did you really order this? And this has nothing to do with creditworthiness checks. It's just security. It's just building this trust with the people that, hey, Zalando is really looking at what I'm doing in order to protect me. And this is, for me, the important part of scoring. Think about of layers of protection. It's not only can you afford a purchase, but it's also can you, or is it really you? Is someone impersonating you? And this is essential for building the safe space for the consumers, so that they trust us, as an ecosystem, and that they trust us as a European company. This is how we look at this.
Yeah, thank you very much. I would like to jump on a point you kind of spoke about. I guess most of you heard about the changes to paragraph 37A BDSG. And I would like to, because you just said that there's much more to scoring than maybe what most people think when they first think about scoring. So maybe all of you could briefly tell us how the changes in the BDSG would affect your business, or if it would affect your business. Maybe Mr. Leonard, you want to start?
Yes, sure. Thank you very much. Concerning the new 37, first of all, we very much appreciate that the German government has the chance to act so quickly. That's very good. And we think that this new article is an opportunity to improve consumer protection and also to create more transparency while making sure that there is a legal certainty for scoring after the ECG ruling of last December. Of course, we still may see some changes because the legislative process is still ongoing, right? But as it stands now, we do not anticipate any significant impact of these changes on our scoring or the quality of our assessment. And this is also due to the fact that most of the foreseeable consumer protection provisions and the transparency requirements we already aligned with. So it's a chance to create certainty, legal certainty, to improve consumer protection and also to improve transparency, which is Schufa started Proactive, a transparency initiative already 3 years ago to make scoring more explainable and more transparent. So the development is going from our point of view absolutely into the right direction because the framework or the frame, legislators and consumer expectations is an increasing pressure for a strategic realignment. It's not only the BDSG, it's the more broader picture, which increases the pressure for a strategic realignment towards transparency and consumer protection.
Mr. Yam, do you agree with Mr. Leonard, or do you see other aspects that could affect your business regarding the 37A?
Yeah, first of all, with a focus on our industry and debt collection, I believe that the changes with this paragraph 37.8 will enable our industry to use scoring models in a broader way, and I think that makes sense. But there will be still some limitations and restrictions, especially, for example, when it comes to the usage of address data. And if this makes sense, so we can have a discussion about it if it makes sense or not. But yeah, there will be still some limitations. And especially with regard to the transparency aspect, I would say that the obligation of disclosure, how probability values or scoring values were determined, is a complex issue because so from my perspective, there is room for interpretation, and room for interpretation is not the best situation when it comes to an obligation to disclosure. And on the other hand, these changes with this paragraph could lead to a situation where certain technologies like AI-driven, generative AI-driven, or machine learning-driven techniques that can be used for build scoring models have to be excluded because they show some non-linearities or non-deterministic behavior. And I think this could be a negative from my perspective as a person who has the technology background. This could be a negative impact of these changes. But overall, I think it's a step in the right direction.
Yeah, Mr. Voger, maybe you would like to add something to that. Mr. Yam briefly talked about the address aspect of the 37A. Maybe you want to jump on that aspect?
This is one point that we see for different reasons crucial to or misdrafted, but let me start. So Justus mentioned in the beginning that the German legislator acted very quick. The problem is when you act quick, you don't foresee all consequences that actually do happen in the end. And to our assessment, this actually has happened with 37A, because 37A was from the intention drafted to regulate classical scoring in the sense of creditworthiness, the classical business, because this was also, it was a Schufa decision that triggered this. So it is relatively clear that it should regulate creditworthiness test through Schufa. Problem is, the paragraph actually itself doesn't say that. When you read the paragraph, it actually can be interpreted in a way that includes all types of scoring I just mentioned before. For example, fraud protection. For example, everything that is done on another level would be subject to the same rules at creditworthiness checks. And this is a problem. By the way, the Bundesrat in their latest statement, I think released yesterday or the day before, actually raised this and says, please clarify the scope. Because what we see, if we apply the rules of 37A to every scoring that a company is doing, scoring meaning in the sense of we do a probability score of something, so is this a real order? Then we would actually lose the possibilities of customer protection. And for example, what Kevin mentioned on addresses, when we talk about fraud, one of the main things fraudsters, or where you can recognize fraudsters, is by the address, because they need an address, they want the goods. It doesn't make sense to have fraud on our end without delivering something. And there are known fraudster addresses where we know, okay, we don't ship, we can't ship there. We are not saying, or we are happy that geoscoring is regulated. We are happy that creditworthiness is regulated. This is, there I am with Justus. This is a good step, and with Kevin, this is a right step in the right direction. But the possibilities of the unlimited scope of 37A BDSG actually leads to legal uncertainty, and in the end leads to loss of consumer protection, and to close the loop what I said in the beginning, it leads to a loss of trust. And this is a unique selling point that we have as European companies. If people don't shop with us because they don't trust us, they will go and take their business somewhere else. And this is a real risk that I see with the new 37A.
Yeah, thank you very much. Maybe, Mr. Leonard, would you also say that these developments make it harder to gain trust, or from your perspective? Yeah.
I totally agree with Christian that the scope of the BDSG needs to be clarified. If we talk about the scoring, we as Schufa, our message is that we understand that from a consumer perspective, consumer protection perspective, it's simply not able to justify the so-called geoscoring. But the point is, and Christian said it very well, if we have to distinguish, because there is not only the scoring, there is also fraud prevention, identity check, and the legislator, the German Bundestag, is really should clarify the scope that geoscoring is forbidden in connection with scoring, but it is possible to use an address to guarantee that fraud prevention, like identity check, is still possible after the law is passed.
Thank you very much. Mr. Yam, have you got something to add for that point? Otherwise, I would jump on to the next point. Not so far. Yeah.
So I totally agree with my colleagues, and I think certain points have to be clarified in more detail because I think there still are some open questions, and in the end, so I think that the changes with this paragraph shouldn't lead to more limitation of the application of scoring models or to more uncertainties. I think this is only in the first step a draft, and we should have a further discussion on it in order to improve some aspects of it.
Yeah, I think that will definitely follow us in the next weeks. And maybe to get back to the point of transparency and consumer trust, Justus, Leonard, you just kind of talked about it already, but how does Schufa ensure that consumers understand how their data is used? Maybe we can look at that point in one way, and maybe what mechanisms does Schufa have to kind of regulate that there are no unfair scores being created?
Yes, a very important question. I think I mentioned earlier before that there is an increasing pressure for a strategic realignment. I mentioned the political or regulatory side, consumer protection regulation, data protection regulation, public scrutiny, and there is also a change in the customer requirements. They expect authenticity, control, simple solutions, and especially interactions on equal terms. And that's why Schufa proactively started 3 years ago already a transparency initiative. Several milestones are already done, but the journey by far is not finished. And some milestones we made to gain more a more explainable and transparent score is, for example, well, of course, we started with a new website with a language people can understand, to make it very simple. And a very important milestone was our score simulator. You can play on our website. I encourage everybody to do it because the score simulator simply explains how Schufa scoring works. It explains the principle of how we calculate a person's creditworthiness in 7 steps. You answer questions, and you learn about the most important factors that influence the creditworthiness. And that's a very important step to make scoring more transparent and explainable. There are more measurements or milestones done. We have the Bonify app where we made first steps for a free digital access to their to consumers' data. So especially the score simulator and the Bonify app, I would like to mention as milestones we already did, because we see this pressure, or the increasing pressure for a strategic realignment. And of course, if it comes to contesting unfair scores, we have a Schufa customer service that ensures any incorrect information can be quickly corrected. We have an independent Schufa arbitration board and an ombudswoman. It's Brigitte Zypries, the former federal minister of justice in Germany. So we have several instruments and mechanisms for consumers to contact us when there is any wrong data in their data set or they have problems with the Schufa score.
Thank you very much. Mr. Yam, can you add something to that from your perspective, from your company? How do you deal with these issues and how do you cope with them?
Yeah, so first of all, so from a legal perspective, we fulfill every legal requirement that is necessary. But I, as an AI developer, AI focused person, would focus more on the technological aspects. So we at Coeo we are already using AI instruments in order to improve data protection management. For example, we have implemented AI tools that can detect and identify, so that they can check every incoming communication via email, via call, via letter, and they can identify and detect whether there is for example, a data protection inquiry or data protection issue. And then we can react immediately on that. This is one point we're using for example, in Germany. In UK, we have a similar procedure, AI-driven procedure for the transcription and the scorecarding of inbound calls. This is one aspect. So we see that AI really can support here in order to improve data protection and compliance standards. And in addition to that, I believe that the use of AI can be used for building more meaningful, more robust scoring models and databases. Because, for example, by the usage of modern AI applications like large language models, you can analyze and extract information from unstructured data. And this information from unstructured data is a real treasure when it comes to build more robust, more meaningful and proper data models and data infrastructure for building tools for decision making and scoring. And I see a lot of opportunities. So in the field of the application of modern technologies to enhance and bolster data infrastructure and risk management.
Yeah, thank you very much. As we're kind of running out of time, I do have one more question for Mr. Voger, but we also have a question from the audience, and I think, or from our viewers, and I think that kind of covers my question. So I would just read that question. Maybe you can jump on that point. The question is, are you aware of surveillance pricing, individualized prices for the same goods or services based on consumers' characteristics and behavior technique? Is it possible that companies in the commerce sector and the EU are using that?
Honest answer, I don't know. I would assume no, because when I look at the legislation, having individual pricing based on specific data points, this is, from a data protection point of view, a leap of faith. And in particular, it would damage one thing. It would damage trust. It would damage how people conceive us, because I mean, this would actually mean if I use an Android device or an iPhone device or another device, I might get a different pricing at the same point. And this would harmfully damage how we assess trust and how we gain trust with users. And as I mentioned, if we lose this, we lose the one unique selling point that we have as European companies.
Thank you very much. So as the time actually is up, I just have one short question, and maybe all of you can give one short statement. What next steps should we take in the future to ensure that scoring practices in all of your 3 different businesses and the consumer data on the other side can kind of be in balance? What is the most important point for you that you look forward into the future? Mr. Leonhard, maybe first.
Sure, I can start. I will make it very short because I think that embracing our transparency initiative, which focuses on transparency and explainability, is key to aligning our scoring practices both with new regulatory requirements and also consumer expectations.
Thank you. Mr. Yam?
I think it's important, so not only consider legal requirements and risk management on the procedurally level. I think it's important to integrate it on a technology level. So, for example, one can build compliance pipelines from the AP side in order to integrate compliance mechanisms, data protection mechanisms on a real technical level that they can communicate with development in IT environments and ensure that everything is documented and monitored. I think there's a need for more technical integration, and there are in some branches and areas there are some technologies like this in application, but I think we should spend more time on develop such infrastructures.
Thank you. And finally, Mr. Voger.
I'll try to answer in 2 sentences. We need to build services and ecosystems based on European values. And for this, consumer protection and technical development must go hand in hand. Because if not, we'll lose what we have as European companies.
Perfect. Thank you very much. I think we could go on discussing this topic for many more minutes, but we already are over time. So once more, thank you very much for joining us at this session. And there are no further questions, and at least we don't have any time for more questions. And I hope you all have a good afternoon. Thank you.
Thank you.
Thank you very much. Have a good afternoon. Goodbye.
You too. Bye. So now let's shift right to the next session. Let's shift the focus to compliance for business success. We now have Julius Düvel from Grey Swan, who will highlight how businesses can achieve effective compliance and why it's crucial for businesses. Mr. Düvel, the floor is yours.
Thank you very much. Hello, everyone. Pleasure to meet you. Before I jump in, I will hopefully share my screen successfully. I brought a small presentation today and should be visible now. So once again, thank you for the introduction. Excited to meet you all. Today, I will be talking about the growing importance of compliance and how it can lead to business success, especially in the areas of data protection and IT security. Currently, various regulations and rules are coming into effect. So we are living through turbulent times, and staying compliant is critical for any organization, any company that wants to remain competitive in today's evolving business landscape. Before I jump into today's content, I have prepared a quick overview on what will be covered in the next few minutes. First of all, introduction to GRACE-1, the organization I represent today. We'll look at the rise in regulations and supervision. Then we'll explore some examples of how businesses in the financial sector have handled compliance and data protection. And finally, a brief strategy from our side with some practical steps to potentially improve an organization's resilience. Let's dive into the first point. GRACE-1. We are an independent Swiss think tank that advises companies on complex challenges. We focus on areas like compliance, risk management, technology management, and also financial management, and work with companies and clients across Europe and also Central Asia, where we offer solutions to help our clients stay ahead of regulations and most importantly, stay resilient to all the changes of global scale. Collaborating with our security partner, SSE from Berlin, Germany, we also identify security gaps and protect businesses from digital threats, supporting industries like the finance, education sector, or the public sector to stay safe. Some words on my behalf, keeping it rather short. Julius Düvel, my name. My focus in the past couple of years has been program management, but also with a strong linkage to risk management and compliance management, where I was able to support projects including special 44 audit remediation programs, risk strategy development, and also core banking development projects. But now jumping into today's content and laying the ground for what's to come, we see currently that the world is shifting into political blocks. For example, G7 or the BRICS plus states, where additional countries were added over the past couple of years, while businesses are facing more challenges. Through the formation of these blocks, there is an isolation of power, economic landscapes, and also most importantly, technological innovation. Internally, such blocks are aligning close, but from the outside, they are oftentimes threatened, leading to distrust, fear, aggression, and in bad cases, also to attacks. Some regions are adopting those technologies, for example, real-time payments faster, but in our case, Europe is lagging behind. So we're becoming less competitive, not only in a technological perspective, but also from the IT infrastructure perspective. At the same time, for example, quantum computing is becoming an increasing threat, and this will break our current encryption methods. However, no one knows currently exactly when. So concluding this can be seen for us as a wake-up call, both from a technological but also from a regulatory perspective. Not following the rules, as seen on this slide, can be expensive and also damaging, with three major examples. For example, Wirecard's collapse due to governance and oversight failures led to reforms in Germany's financial regulation. FTX went bankrupt because of poor risk management, also leading to stricter regulations. And lastly, SCB in Vietnam, where billions were stolen through shell companies, showing how weak compliance can not only destroy trust, but also stability and reputation on a bigger scale. And when we look at the regulatory landscape around data in Europe, this continues to grow, especially in the areas of data security and privacy. There are increasing requirements in the European economy. After an initial focus on GDPR, we now see that regulations like DORA, which comes into effect quite short in January 2025 already, or the AI Act in August of next year, and NIS2, which actually becomes applicable in just 1 week on October 17th, we see huge changes. And looking ahead, the CRA, the Cyber Resilience Act, is expected around 2026 or early 2027. And Europe may be behind in technological adoption. It is definitely leading in terms of regulation. Globally, the importance of cybersecurity and privacy is growing. And as this map clearly shows, 77% of countries now have both cybersecurity and data protection laws in place. So compliance is no longer an option, it's an essential for any business that operates on a global scale, and staying compliant at the same time is crucial. Again, as I mentioned earlier, to build trust, to remain trustful, and also to avoid any kind of penalty. Looking into data regulation specifically, Europe is leading the way, targeting 3 main objectives, as you can see here from left to right, where data usage, data security, and data sovereignty are the 3 main objectives. The goal here is to establish a secure, sovereign, and also a user-friendly data economy that protects individual rights for European consumers, businesses, and also public institutions. This works best if the world follows, and this is known as a Brussels effect, where Europe basically paves the way and adheres to other countries following Europe. To highlight just a few regulations, firstly, the DMA, the Digital Markets Act, which aims to ensure fair competition by regulating large digital platforms. The Digital Services Act, DSA, that increases accountability for online platforms and ensures illegal content is removed. The GDPR, which remains the global gold standard, if we can call it that way, for privacy protection. And as mentioned also earlier, the DORA and the CRA, the Cyber Resilience Act, where businesses are aimed to be protected from cyber threats. Moving on, as mentioned, I brought some examples from the financial and from financial sector and from data protection. I will now showcase some of them, and it continues to be one of the most targeted sectors by cyber criminals, the financial sector. On the right-hand side of the chart, we can see that the increasing number of attacks across different sectors, with finance, healthcare, and energy among the most affected. On the left side, we see the regulatory response, particularly around IT resilience, where NIS1, which is currently in place, is being replaced by NIS2 exactly in 1 week, which significantly increases the scope again. XITE, for instance, will be replaced by DORA beginning of next year, which focuses on enhancing the resilience of financial entities. Here, however, MRISC and MRGO will remain in place. As for the general objectives, NIS2 aims to improve cybersecurity in new sectors, while DORA adds new requirements for financial institutions and third-party providers. The German implementation, or the German way of implementation, will lead to a double regulation for the financial sector, but DORA eventually will remain the primary regulation for the supervised organizations. DORA, which again, Digital Operational Resilience Act, is a game changer, or can be seen as a game changer for Europe's financial institutions. It regulates a total of 21 types of entities, 20 financial institution types, and so-called ICT third-party service providers, which are essentially the IT suppliers for those financial entities. It is entirely new for those ICT providers to be supervised by financial regulators for their IT systems. The larger players will manage this transition, but many smaller ICT providers are affected to the extensive oversight and will most likely struggle. Some, like those currently covered by XITE or MIX, are already well experienced with financial and IT regulation. However, this doesn't go for all of the entities. Looking at the reach of DORA and what it actually brings along, around 22,000 financial institutions and 15,000 IT service providers in Europe will be regulated by DORA. While specific figures for individual countries have not been released yet, we know that approximately 15,000 ICT providers and around 8,700 will be directly impacted by DORA, while only 6,300 will not. These non-supervised providers still serve to 22,000 financial institutions. So the main question that evolves, what will the market decide? Will the bank choose a DORA supervised provider or one that isn't supervised? So ICT providers should carefully consider whether they want to opt in to being supervised under DORA or not. When we compare data protection laws on a global scale, we see that many countries are adopting GDPR-like rules. However, through our projects, especially in the Central Asian region, we've seen that data protection laws are not well developed. This is also one of the main reasons why companies like Google or Apple still struggle to establish their operations in the Central Asian regions. Two examples I want to point out, or positive standouts, are India and Switzerland. The Indian law, for example, although it's not fully enforced yet, has two USPs. It is written in the feminine form, and it includes explanations within those articles, making the legal text way more easy to understand. Similar to Switzerland, the Indian law is heavily influenced by the GDPR. Switzerland's new data protection law is considered by many to be an improved version even of GDPR. And my colleague Waldemar Guzin, who is also a member of Bitkom, gave a presentation on this in June. And I'll keep it brief here. The Swiss law is often seen as the better GDPR. And on the next slide, you'll see why. So looking at the Swiss and the EU data protection laws, and to compare these, we see some significant differences that highlight the advantages of the Swiss approach. For example, in Switzerland, companies are only required to maintain a processing directory if they have more than 250 employees, whereas in the EU, all organizations need to maintain one. In Switzerland, appointing a data protection officer is voluntarily, but when appointed, there are incentives for conducting DPIAs, so data protection impact assessments. In contrast, Germany requires a DPO for organizations with more than 20 employees, although there are currently discussions whether this level should be raised to 50. Another key difference is around consent. In the European Union, consent is often not fully compliant with supervisory requirements, while in Switzerland, it's not needed unless there is a violation of personal rights. These three differences alone make it clear that Switzerland offers advantages for businesses and consumers, and in turn proving that good regulation may indeed support business environments. As mentioned, my colleague Waldemar Guzin gave a presentation in June, and I'm happy to connect you with him and also to share latest white papers, which we've published around this topic. With increasing regulation, there is also an increased need for audits and certifications. Supervisory authorities are conducting more audits and including special audits, for example, special 44 audits or the introduction with DORA. There will also be an increased number of entities that will be supervised and also audited. At the same time, self-audits like those for ISO 27001 certifications are also globally on the rise. And as you can see here, it's interestingly China, which is leading in the number of these certifications by far. Just to point out one more number, among the Euro Stoxx 50 companies, 37 hold an ISO 27001 certification. While IT or secure IT may not be the direct cause for success, there is most certainly a correlation. So secure IT often means newer, more powerful IT systems along with a better governance, with a better organized structure, which in turn improves the competitiveness. And coming to the strategy, to wrap it up, and as mentioned before, we've prepared some practical steps for improving a company's resilience. First of all, risk audits. Financial institutions should conduct independent audits to review their risk assessments and to ensure independent evaluations. Next would be market analysis, the analysis of the financial landscape to identify strategic options for the organization company to remain resilient. Thirdly, maturity reviews, an assessment of the internal governance, resources, IT security capabilities to ensure readiness for regulatory requirements and potential changes. Supplier compliance is a fourth step, including a review of suppliers to ensure they comply with new security regulations, for example, especially under DORA. And lastly, strategic preparedness, adaptation of business strategies to respond to increasing demands for security and compliance across regions and industries. And now, I already want to thank you. And if you have any questions, topics you'd like to discuss, feel free to drop them in the chat or reach out to myself or one of my expert colleagues, Dr. Waldemar Guzin, as I mentioned already, or Nadine Hoffmann.
Thank you very much, Julius Düvel, for these practical insights. We, at the moment, don't have any questions, but feel free to ask questions in the chat. I think you will be free to answer them in the chat. So thank you very much once again, and have a great afternoon.
Thank you very much, everyone.
Thank you.
Thanks for having me.
So we now transition to a panel on free data flows and global data security. We will focus on global data security in the face of geopolitical challenges. This panel features industry leaders from the NCC Group, TikTok, and Deutsche Telekom. I will briefly introduce all our panelists. Our first panelist is Jade Nestor, Director of Data Public Policy Europe at TikTok. Then next, Valentin Steinhauer, Deputy Head of Office at the EU presentation of the Deutsche Telekom. And last but not least, Stephen Bailey, Global Director of Privacy at the NCC Group. I will now give the stage to my colleague, Patrick, who is going to moderate the panel. Thank you all for being here, and thank you, Patrick.
You're welcome. So, dear ladies and gentlemen, dear participants, Jade, Stephen, and Valentin, welcome to today's panel discussion titled Free Data Flows and Building Trust, Strengthening Global Data Security Amidst Geopolitical Challenges. So thank you very much for joining today. I would like to open the discussion with a first opening question to Jade. What are the key economic or geopolitical challenges related to free data flows and data protection, and why is this particularly relevant for your company?
Thank you very much. And thank you for having us, of course. So for TikTok, these are both really key objectives for us: to protect data in Europe, according to the GDPR, both in the UK and the EU, but then also to have a global platform and to have global data flows. We have a global user base, we have employees around the world, so we're trying to figure out how do you lean into European data sovereignty, support a global platform, and protect European data. And so we developed something called Project Clover, which we can talk about more, which is our European data sovereignty project. And it's a 12 billion euro investment over a 10-year period. So this is not a small project, which I think shows the challenge of meeting both of these objectives of free flow of data and data protection. But for us, of course, we have a lot of scrutiny. So we're really focusing a lot of attention in this area, trying to protect data and then meet these stringent regulatory demands that we have in Europe, of course, underlined by a framework of rights.
Thank you, Jade. So Project Clover was already mentioned. That's why I'm linking it directly also to Stephen. Do you want to add something?
Hi there. Thank you for inviting me along. The only things I'd sort of add really on those challenges are that we see as an organization, because we help lots of organizations in a similar way that we're working with TikTok. And you know, the two main things really that most companies are struggling with is that fragmented regulatory environment. So many different countries have different cybersecurity requirements, not just at the national level, but that can push out into sectors as well. So, for example, telecoms might have its own, energy will have its own. And that can cause difficulties. And then add on top of that, this growing sort of push towards data sovereignty, data localization is starting to make it a little bit tricky for organizations to think about how they can get utility through sharing data without compromising any of those requirements.
Thank you, Stephen. Valentin, so why is free data flows and data protection relevant for your company, for Deutsche Telekom?
Yeah, thank you very much. To be honest, I think it's relevant to anyone, right? I mean, we wouldn't have this panel without cross-border data flows. I mean, I'm myself based in Brussels, so I'm pretty sure that we have some cross-border data flows going on right now. And of course, it's also extremely relevant for us as a company because we rely on global supply chains. We have customers that, of course, also have global operations that we try to support in this. And I would like to come back to your question about the challenge. And I think the key challenge is really trust. And I think that's also why I think the title of the panel is actually a good one, because it's really this balance between free data flows, but also with trust. And I think on the trust side, we do still see some challenges. And maybe I can briefly mention 4 challenges. I think one is that we still have a conflict of laws, which is due to different regulatory standards, different rules, which is in some parts unresolved. Second, we also see sometimes still a lack of transparency. Do we really know where our data goes, what happens to the data? Third, and I think it's also an important part of the discussion, is really asymmetries also in the global data economy. So do we have a balanced flow of data globally? Is there a fair distribution of data? And last but not least, I think is also about choice in the end, because if we want to have trust in cross-border data flows, it's also essential that users, organizations, citizens have actually alternatives to choose from in order to actually have control over what happens to their data.
Oh, thank you. So allow me, Valentin, to follow up with the question, what do you see then as the biggest obstacle to truly free and secure international data flows from your point of view?
Yeah, I think I already mentioned it. I think trust is really at the center. So without this, I think we cannot have a global framework on this, and we cannot really have an alignment. So I think this is really the first point to mention. But I think it also goes beyond trust because ultimately it's also about security, and it's not only about personal data. I think we have moved also beyond this. If we look at the discussions that we had in Brussels, for example, with the Data Act, this is also very much about non-personal data, sensitive data, for example, industrial data, IP. So I think it's really important to get these 2 dimensions right, trust and security. And then I would add maybe as a third layer, and I mentioned it briefly already before, I think it's also reciprocity. So do we have reciprocal access to data? And because I think to a large extent, we're talking, especially from a European perspective, sometimes quite a lot about how we can enable data flows outside of Europe to other regions. And I think sometimes we talk a bit too little about how we can actually also ensure that data flows into Europe. And I think we need to look at both dimensions.
Yeah, thank you very much. So Jade, if you would like to follow up on this, what Valentin said, and maybe add a little bit more to what extent do you see growing geopolitical tensions between the US, China, and Europe as a threat to your global business, particularly in terms of data flow?
Great, thank you. I mean, I want to follow up on a point that Valentin made about trust, because I think that is so important. And what we've been trying to do to restore trust, I mean, I mentioned leaning into data sovereignty, but the reason that we've been working with NCC Group is to bring in a layer of oversight and accountability about where our data is flowing. We have a segregated enclave for European data, which right now consists of a data center in the US, and then also an Irish data center, and then we'll be bringing one in Norway on board. And the goal is to have everything stored by default in Europe. So this has been a migration process. But then we also built these digital barriers around the data, and NCC Group is monitoring the data flows in and out, because I think part of accountability is having that demonstrable accountability, having that oversight. And so we tried to build that in to build trust, to his point. I think in terms of obstacles, though, you know, we've been trying out this novel approach. I hope that regulators, you know, can appreciate what we're trying to do. And so I think one of the obstacles is maybe like obstinance to some of these new approaches, you know, or not obstinance, but maybe like more like not understanding how all the components fit together. And so I think being open-minded about solutions like this, and also like privacy enhancing technologies, that's something that we're using in Project Clover as well to pseudonymize data. If regulatory acceptance of that, I think would really help us move forward. And in terms of the geopolitical tensions, I mean, I think sometimes because of TikTok and the stories about TikTok, people think of us as, you know, like the only company that ever has any historical heritage to China, right? There are a lot of companies that are doing business with the US, with China, with countries all around the world. If you look at, for example, binding corporate rule documents of European multinational companies, they list China as recipient countries for European data. They list the US, they list all of these other countries. And so I see this global data flows issue as an industry issue. It's not just a TikTok issue, it's an industry issue. I think we all are trying to figure out how to solve the problem and how to comply with the law. But I think that at the high level, governments and regulators need to talk to each other too, to think, you know, how can we realistically help achieve business and innovation goals, particularly in Europe, while also still adhering to our rights-based framework.
Thank you, Jade. So Stephen, Project Clover was once again mentioned, and trust as the bigger headline here. So as part of Project Clover, NCC Group independently audits TikTok's data controls and safeguards, data flows, and security protocols. So what is the rationale behind external data oversight, and how is it done to build the trust?
So what we're doing is we're looking at a number of different things, and our start point is assuring the core elements of Project Clover. So Project Clover is in effect something called the European Enclave, where all the user data for EA, UK, Swiss people will reside. And then between that and the outside are some digital barriers called security gateways that systems and people need to go through to work on the data in the European Enclave, for the exchange of data for systems applications to run. So we're starting at the very kind of base level. So we've reviewed all the source code for those security gateways, and now we're into a process of reviewing any changes to those. We've looked at the end-to-end process, so to make sure that the thing that's approved and then pushed through into the live environment is the same thing and it can't be interfered with on its way and when it's in place. And then we monitor it. We monitor for changes, and we're looking for activity that's going on around that as well. So that's how we're doing it. We've assured the cloud environments that it's operating in, and so now we can see if new things are put into there or there are changes to existing things. We can see that and pick that up straight away. And that's the thing that when we meet with TikTok, with governments and data protection regulators and national cybersecurity authorities, these are the measures that we talk about that we have in place to give that confidence and trust in the fact that the data is being secured and access to it is being very tightly controlled. And we do that kind of away from anything other things that TikTok are doing.
Thank you. So going back to Valentin, so how does Telecom navigate the challenges posed by the recent EU legislation, such as the Data Act and European Cloud Certification Scheme? And what impact do these regulations have on your cloud services and data operations across Europe? And how do you ensure then to be a trustworthy company?
Yeah, I think if you look at, I mean, there's a lot to say about the recent legislations, especially the Data Act is a very complex piece of legislation. But I think if we look at what it actually changes in terms of cross-border data flows, it does two things, which we actually welcome, which is on the one hand, it brings safeguards for cloud users by making sure that there's no extraterritorial access to data stored inside of the European Union that would be unlawful or not in compliance with EU legislation. And the second one, which is I think also equally important, is transparency. It basically requires cloud providers to make transparent towards their customers, where the data is actually processed, stored, and which laws apply. And I think these two steps is something that is absolutely important, because when we talk about trust, I think having that baseline transparency is the first step to get there. Second one on cloud, I think we have had a long discussion about cloud and cloud sovereignty in the European Union and different initiatives like Gaia X and others. And I think what all these initiatives and discussions boil down to is actually more or less the realization in Europe that we have a market that is largely captured by 3 non-European players, right? We have a dependency in the cloud market, and there's not really choice, at least not choice that is outside of the mainstream providers, let's say. And I think part of these initiatives aim to actually create that choice and to bring also, again, more transparency into the market. And I think one of the key initiatives here is this European Cloud Certification Scheme. There's been a long discussion on this. I don't want to go into the details of it, but I think it's interesting to look at certification also as an instrument to harmonize some of these requirements, right? Because we have a lot of sovereign cloud offers in the market right now, but I think the problem is that we don't really know anymore what is really a sovereign cloud, what is behind it. Some companies say that they localize data, others do other things. And there's, I think, by now a bit of a confusion around what is actually required. So I think in that sense, we would actually welcome a harmonization of some of these requirements in a certification scheme such as EUCS to also bring clarity to the market.
Thank you, Valentin. So Jade, maybe you would like to add something to that what Valentin have said, and also maybe you can give us a brief overview of how TikTok manages the challenges of complying the varying data privacy requirements across different jurisdictions, and how does this affect then TikTok in general?
Yeah, I mean, I think Valentin mentioned transparency, and I think that's something that we've been trying to focus on as well, trying to be very open with stakeholders about what we're doing with Project Clover. But then we also really started posting our thoughts about data sovereignty back in 2020 in some newsroom posts, sort of like blog posts that our users could read. So we've been trying to be very open about the strategy. And then as we work with NCC, we've been trying to think of ways that we can be more transparent. For example, listing information about the security vulnerabilities that NCC Group is finding in our transparency reporting. I don't think anyone's done that before. So we've been trying to be creative with transparency. We, for a long time, have listed where our data, user data is transferred, and that just means remote access, but where is it transferred? Other companies don't do that. We've prohibited certain employees, like employees based in China, from accessing certain types of European data, and we've been quite open about that now. So I think just telling people about the journey that we're going on and being transparent has been very helpful. In terms of all the different requirements, I mean, we're very lucky to have an excellent legal team, which identifies all of the GDPR, UK GDPR requirements, and then other global requirements. And they work very closely with our security team, which is the Global Security Organization, who also is working closely with NCC Group to build out the requirements for Project Clover. So I think all of these different components work together for us on Clover, and then also in Project Texas, which is the US version of that. So it's complicated, but there's so much internal buy-in because of the importance of this that I think it makes it all work.
Thank you. So Stephen, it was also once again mentioned that there are, of course, some technical reasons behind, and that you have to install some of those things. So how can you, from your perspective, or maybe outline something for our listeners, how you implement a robust security standards, and how you would see how it will change in the near-term future?
So as an organization generally, so NCC Group works with lots of different organizations, private and public sector, to help them with improving their security posture. And in the same way that we're doing with TikTok, it's really about ensuring that the measures that are being put in place meet the threats that organization is actually facing. And that is sort of in harmony and parallel with all of the other requirements that come in. So we've all mentioned about this fragmented sort of regulatory landscape that there is there. And it really is just about getting the basics right. So it's really understanding the data that does need to be shared and then putting in the right technical organizational measures to make sure that that data is afforded the protections it needs. And so that when you are sharing data with outside parties, whether they're across international boundaries or not, it's only the data that they need to do what they're doing. And I do think that for the future, I think that privacy enhancing technologies are really going to start to come to the fore, because I think everybody, regulators included, understands the importance of data flowing for global organizations. And it really is just about making sure that the things that can flow easily, and some of the stuff that can't flow is protected in some way, for example, through privacy enhancing technologies. And then you have a balance of utility of the data and privacy of the data. And it's that tricky balance of finding the right measure of those things.
Thank you, Valentin. So we're already covering the near-term future or the long-term vision. So how do you see the future of free data flows in light of increasing demands for data localization and national sovereignty?
Yeah, I think we need to probably differentiate a bit here, because I would challenge, at least from a European perspective, and I think it varies a lot between different regions, and different governments have very different approaches on data flows. But I think from a European perspective, I would like to challenge a bit the notion that data flows, global data flows, is contradictory to sovereignty or notion of sovereignty. And I would not talk about national sovereignty, but more of a, in that sense, European regional sovereignty. And I think ultimately it should go hand in hand, the two of them. I would at least like to believe that it's possible to have European tech sovereignty and at the same time keep data flows being open as much as it's possible. But of course, this also means that you shouldn't be naive. I think from a governmental point of view, it's important to enforce your laws and to maintain the protections that are necessary. And I think that always has to be balanced. And secondly, also, I think it depends on the type of data that we talk about, and also on the user requirements, frankly, because there might be some companies that are perfectly fine using, for example, public cloud because they have global supply chains, they want to exchange some data. But I think, as Stephen mentioned, there are also other cases where companies have very sensitive data, for example, that they do not want to be on a public cloud. So currently they use maybe on-premise systems. And I think there we also need to find solutions that actually cater to their demands and their requirements. And that's, again, where I think some of the safeguards and requirements that are being discussed, for example, in Brussels, can play a role in order to help also bringing some of these more regulated and sensitive data to the cloud.
Thank you. So, Jade, also directed at your position at TikTok. So what do you believe then for the near-term future are the most critical actions, so both technically and also politically, must be ensured to secure those free global data flows?
I think that governments and regulators, as I mentioned, need to continue talking to each other about what demands are in place for the economy writ large. I know that that's not necessarily a data protection authority's job, but I think it's more aligned to what is realistically happening, and how can the law still work within what needs to happen at a practical level. What TikTok is doing, as I mentioned, is focused a lot on accountability, and I think maybe that's one way that we can move forward with that discussion, that oversight and accountability piece. And I think that, I truly do believe that data is going to help us solve some of the world's challenges. So we do need to figure out a way to have data flows around the world. And if we look at the Digital Europe stats that trade organization has, there's a huge amount of data flowing in and out of Europe around the world. We need to figure out how to harness that for innovation, for business, but also to solve some of these critical issues, facing us, and do it in a way that respects privacy. I don't think that stopping data flows is going to be the way forward. We have to think of ways to have accountable, safe data flows in and out of Europe.
Thank you. So, Stephen, maybe from your point of view, more focused on the technical side, so you don't have to outline a product roadmap right now, but how would you see, what kind of homework do you have to do in the near-term future to ensure those global free data flows?
I think you're on mute.
I think you're on mute, Stephen.
Apologies, I clicked the wrong thing. I think there's two things. What I'd like to see is on the sort of the political, the cooperative level, greater cooperation between countries around cybersecurity and what the best level should look like and what the normal level that most organizations can operate at. So if you're a small boutique organization and you're just sharing, posting your products out to people, you don't need to have the same controls in place as a bank, for example, or a pharmaceutical company. So I think we need a lot more cooperation on that, just to try and cut down the vast array of different frameworks that there are for cybersecurity and privacy as well. And I think the other thing is just helping to get the privacy enhancing technologies to the point where they become a bit more mainstream, they're a bit more usable, kind of straight off the shelf for organizations, because I think it's still a new and developing thing, and there are very few organizations using it very much. Certainly TikTok are using it at scale, which brings along its own challenges. But I think they're the two key things that we need for the near term.
So thank you very much, Jade, Valentin, and Stephen, for today's panel discussion and your point of view on how to secure those free data flows and how essential they are and will be. So it's definitely, I can definitely conclude that from your point of views that, of course, the geopolitical tensions and the fragmented regulations pose significant challenges to those free global data flows, but they are important and they must be secured. And it was definitely, or it became clear definitely that trust and transparency are critical to maintaining those global data flows, and that you're willing, of course, to make sure to ensure that those trust and transparency goals are reached. And as pointed out from a technical position as well, there are a range of solutions already on the market, and that you make sure with your companies as well to be on point and to, of course, move on and to reach the milestones in a product roadmap to make that happen. So thank you very much once again, Jade, Valentin, and Stephen, for having your views on this panel. And now I would like to hand over to Emily Hancock. She is the Chief Privacy Officer and Senior Director at Cloudflare, and she will explore how to manage data governance and interoperability in an increasing complex regulatory environment. Thank you very much.
Thank you.
Thank you.
Hi, I'm Emily Hancock, Chief Privacy Officer at Cloudflare, and I'm happy to be back here at Bitkom. When Cloudflare was founded 14 years ago, it was on a value proposition to help build a better internet by making it more secure, more reliable, and more performant. Pretty quickly, we also realized that a better internet is a more private internet, and we've been playing an active role in building more privacy into the internet ever since. Not only do our core services provide security that further enhances data privacy by preventing breaches of stored data, but we also dedicate resources to building privacy-enhancing technologies that help people use the internet without having to give up personal information to do so. We invest a great deal in privacy-enhancing technologies and products because we believe that privacy is critical not only to our own operations, but also to the future of the internet. And now, with a global network spanning more than 330 cities in over 120 countries, Cloudflare sits in front of roughly 20% of the internet. We help protect websites and corporate networks from cyber attacks. Today, I want to go a bit beyond privacy and talk to you about something we've been hearing more and more about over the last few years: data sovereignty. This concept of sovereignty, which is essentially the right of an individual or group or nation to control data, is often associated with data localization, which is the idea data should stay in the country or region where it originated. We've been observing a growing trend of data localization worldwide. In the EU, it's largely driven by two factors. First, there's what we believe is an overly restrictive interpretation of the GDPR shared by many data protection regulators. And then second, we see explicit data sovereignty requirements for reasons of national security based on a pretty narrow understanding of sovereignty. But as I'll explain, the reality is data localization can have a negative impact on cybersecurity. And without really good data security, we can't ensure data privacy. And if we can't offer individuals assurances around the privacy and security of the data, then there can't be true digital sovereignty, which is the ability of individuals to securely use the digital services of their choice and control their data as they move around the global internet. So today, I want to talk about how we should be striving for an internet where location doesn't matter, where we ensure privacy and security of data no matter where it's processed. Before we dive into that, I want to take a moment to remind ourselves of privacy first principles. The Fair Information Practice Principles, or FIPS, are the foundational guidelines for protecting personal information. The FIPS are widely adopted, and they form the basis of most data protection legislation around the world. The FIPS include, first, the principle of transparency. Tell people what personal data you're collecting and why. Second, the principle of choice. Give individuals the right to choose how their information will be used. Third is the idea that individuals should be able to review and correct their personal information. And fourth is ensuring the quality and integrity of the personal information that are protected. Fifth, we have the principle of accountability, holding organizations accountable for complying with the FIPS. Six is the principle of consent. And then last, but definitely not least, the principle that entities collecting personal information must ensure that that data is kept secure. Now, while the principles aimed at giving individuals notice, choice, and the ability to control what happens to their personal information are pillars of any approach to data protection, it's that last principle, security, that has become more and more important. We know that many individuals don't read the privacy notices we painstakingly craft for them. I know, it's shocking. We also know that most people have consent fatigue. Think about how many cookie banners we all just accept so we can get to the content we really want. But securing data is one thing that individuals can't really take control of. Banks are online, health records are online, and we shop online. All of these life tasks take place online, and we have little choice but to hope that our personal medical records, our credit card statements, our shopping habits won't be hacked and published on the internet for everyone to see. Now, I don't love that advertisers know my web browsing habits and use that to show me targeted ads, but you know what I hate even more? When my health insurer fails to implement robust security measures and my medical records are exposed, or when I become vulnerable to identity theft because a data broker failed to properly secure my social security number. And those are just 2 data breaches that I was notified about in the past 9 months. So to my mind, when I think about the FIPS, I can't help but think that the principle of security has to be given priority. And that leads me to my next point. Let's talk about how an overly restrictive interpretation of the GDPR can, somewhat counterintuitively, undermine cybersecurity, resulting in less effective data protection. Now, on balance, the GDPR has definitely moved the needle in the right direction for giving people more control over their personal data and in protecting their privacy. And as drafted, the GDPR does not require data localization. Instead, it allows data to be transferred outside the EU if certain measures are met, and it allows data controllers to make a risk-based determination on whether data will be adequately protected when it's processed outside the EU. But in the last few years, data localization pressures arose largely due to the Schrems II case. In the wake of that court decision, many data regulators began to assert that no data could leave the physical boundaries of the EU and be protected, certainly not if a US company was involved. The EU-US data privacy framework has provided cover for EU companies that want to use US service providers, but the sentiment remains. Location has become a proxy for privacy in the minds of many EU data protection regulators, and we think this is a wrong equivalence. Going a step further, the way GDPR has been applied to cross-border data flows may in fact actually jeopardize the protection of personal data, as I'll explain. Our experience and recent research have shown that GDPR-induced data localization threatens an organization's ability to achieve integrated management of cybersecurity risk, and it limits an entity's ability to employ state-of-the-art cybersecurity measures that rely on cross-border data transfers to make them as effective as possible. This directly clashes with the obligation Article 32 of GDPR places on data controllers and processors to, quote, develop appropriate technical and organizational measures to ensure a level of security appropriate to the risk, taking into account the state of the art. In addition, data localization undermines information sharing within industry and with government agencies for cybersecurity purposes, which is generally recognized as vital to effective cybersecurity. Now, the idea of data localization or data sovereignty has popped up in a number of other policy initiatives as well. We're seeing an increasing interest in the EU in matters of digital sovereignty, for both reasons of national security and global competitiveness. It's been an important goal of the EU and its member states for a while now to reduce technological dependencies on a few third country providers, and geopolitical developments have further exacerbated this trend. The much-cited Draghi report on the future of European competitiveness also emphasizes the need for technological sovereignty due to rising geopolitical risks. It suggests that a country, or in the case of the EU, a group of countries, can best defend its national security interests by relying on providers within that country or jurisdiction's borders. And we'll soon have a new European Commissioner in charge of tech sovereignty. These are all a part of a trend we're seeing around the EU's efforts to become more competitive in the long run and encouraging technological sovereignty to avoid dependence on other countries. The quest for digital or tech sovereignty is of course legitimate, and it's understandable from a European perspective. But the desire to gain more control over what happens with European data is getting mixed up with privacy and security considerations in ways that can actually be worse for data privacy and security. So let's take the example of what happened when Russia invaded Ukraine. Ukrainian law required national security data to be stored within the country, presumably because in-country storage was perceived as being better for maintaining control and security over the data. But when Russia invaded, the Ukrainian government had to scramble to change its law and move its most sensitive national security to cloud storage solutions hosted outside of its territory to protect it from invading Russian forces. Meanwhile, in a paper published last year, the Conference of Independent Federal and State Data Protection Supervisory Authorities in Germany went beyond their task description by setting out criteria for so-called sovereign clouds. They argued that companies that market their cloud offerings as sovereign should fulfill certain conditions. In particular, that data be processed exclusively in the EEA by providers based in the EEA to guarantee judicial enforceability of the data protection level. Now, another example is the draft EU scheme for the Cybersecurity Certification of Cloud Services, or EUCS. It's been delayed for years over the discussion of whether it should include sovereignty requirements, which would in fact have nothing to do with cybersecurity. Fortunately, it seems like the idea has finally been given up now, but the discussion is likely to linger for years to come. But all of these admittedly quite relevant concerns about sovereignty must be weighed against the critical cybersecurity protections and data privacy protections that could be achieved with cloud computing and global networks. The fact is, sovereignty requirements for cloud services do not improve cybersecurity. They actually can have the opposite effect. Sovereignty requirements limit the ability to build global data sets of malicious cyber indicators, making it virtually impossible to develop and deploy security solutions that effectively leverage AI and machine learning to detect and mitigate cyber risk. Sovereignty requirements also make it more challenging to mitigate large volumetric cyber attacks, which are best addressed using large globally distributed networks. Such attacks are constantly getting bigger. Just recently, Cloudflare shared the news about another record-breaking campaign of hyper-volumetric L3 and L4 DDoS attacks, including the largest DDoS attack we've ever seen, 3.8 terabits per second. Now, EU policymakers and regulators in favor of sovereignty requirements for cloud services appear to have failed to consider how such requirements can impact the security features that are critical to keeping their networks and data protected from bad actors. Global knowledge is necessary to identify and stop attacks that could come from anywhere in the world. Enabling the use of AI and machine learning to identify and automatically mitigate malicious cyber behavior depends on having access to large global data sets. For example, the size of Cloudflare's global network puts us in a unique position to understand the evolution of global threats and anomalous behaviors. To empower our customers with preventative and responsive cybersecurity, we employ machine learning technologies to automatically transform that information into protections against attempted exploitation of vulnerabilities, DDoS attacks, and other malicious cyber threats. In contrast, a provider limited by sovereignty or localization requirements would not be able to gain the cyber insights from pooling malicious indicators coming from the EU with those available globally, which would leave customers in the EU with reduced access to threat information and automated mitigation of attacks, ultimately making them more vulnerable to cyber attack. Having a global network also allows cyber attacks to be blocked as close to their origins as possible. In contrast, mandating that a cybersecurity provider restrict operations to the EU means that all attack traffic must be imported to the EU. This approach loses the benefits of having a global network to mitigate attacks and has the potential to overwhelm EU networks that end up being required to carry attack traffic. Because sovereignty requirements are likely to have the effect of reducing access to cybersecurity mitigations and threat data, such requirements would risk misleading customers into using services that appear to be more secure based on their sovereign label, but actually provide less security from a technical perspective. And critically, this need for a global approach to cybersecurity benefits privacy too. The GDPR's application should be considered with the cybersecurity benefits of data processing in mind. Building on the GDPR's existing Recital 49, which rightly recognizes cybersecurity as a legitimate interest for processing, we believe personal data that needs to be processed outside the EU for cybersecurity purposes should be exempted from GDPR restrictions to international data transfers. Such a shift would be a truly pro-privacy application of the GDPR. The truth is, the better an organization is at detecting and thwarting security risks, the more protected its data is. And aren't we all tired of the headlines about data breaches? For us mere data subjects, the barrage of alerts about data breaches impacting our government identifiers, our sensitive healthcare data, or the compromise of our banking credentials, it's too much. It's breach fatigue. And as individual data subjects, in many cases, we're powerless to do anything to protect ourselves. So just as many of us have given up on trying to opt out of cookies because we get cookie notifications every time we try to do almost any single thing on the internet, we're starting to end up in a place where we might be thinking, what's the point of trying to keep any of my data private? It's just going to end up getting compromised in a data breach because the service provider I had to use didn't keep the data secure. But what if service providers could actually provide robust protections and data subjects could feel empowered by the fact that their data is processed by a provider employing cutting-edge security measures that adapt as threat actors change tactics? That'd be nice, right? Unfortunately, having that kind of security isn't scalable for every organization if the organizations are required to use sovereign solutions that can't adapt to changing threat vectors. So given the pressures we're seeing from various players in Europe and the growing desire for digital data sovereignty, and with it, data localization, that's not likely to reverse course anytime soon. But I think it is important for all stakeholders to acknowledge that when we're talking about solutions that are designated to achieve data sovereignty, these solutions may not, and often will not, provide better data protection or better data security. So today, I've laid out how overly restrictive data localization can undermine cybersecurity efforts by reducing the effectiveness of protective measures and limiting access to crucial threat information. And I'm urging us to take a truly global perspective on data processing to effectively combat cyber threats. Using collective insights and privacy-enhancing technologies can bolster defenses against evolving threats. We need to find ways to address the understandable desire for technological or data sovereignty without jeopardizing security or privacy protection, and also be clear about the necessary trade-offs involved. Only with this added level of transparency will users be able to make fully informed, sovereign technology choices. It's going to be difficult, but as is true with many things about the internet, rules and regulations are not likely to be the best or only answer. Instead, we need to invest in privacy-enhancing technologies and security measures that protect data regardless of its location. These technologies can help secure personal data, giving individuals greater control and confidence, and enabling them to use the most innovative services the internet has to offer, while at the same time protecting them from personal data breaches. Only by implementing these kinds of technologies can we have true digital sovereignty, the ability for individuals to securely use digital services of their choice and to control their data as they move around the global internet. Thank you so much for joining me today, and enjoy the rest of your Bitkom sessions.
Thank you very much, Emily, for these valuable insights. We now turn our attention to AI regulation in the European Union. Cecilia Alvarez Gordias from Meta will now speak on the topic of AI in the European Union and how to balance data protection with innovation. Cecilia, I'm happy that you're here today, and the floor is yours.
Thank you very much, and thank you for all of you for following this wonderful Bitkom Privacy Conference.
Thank you.
So I hope that you can hear me well.
Yes.
Just checking. Super. Excellent. So thank you very much again. Well, the topic of AI is probably now in every single privacy conference, and this is definitely not an exception. I've been in the field for many years, close to 30 now, and I should say that I have been working with AI my whole life. It was not necessarily the sole subject at all, but it has been present in my professional life in the very different sectors in which I have been able to advise regarding the directive at the time of data protection and then the GDPR. But it seems sometimes lately that AI seems to be like a kind of completely new topic, or that we are always facing challenges that are completely novel. And I have first two reflections. One, that AI is definitely not new, but there has been, as always in the technology, rapid evolutions with respect to certain aspects of AI, in particular with respect to generative AI, that entails that this technology needs to be also studied in order to better understand the implications that we have in the different disciplines. And with respect to the challenges, definitely there are new challenges, this is true, but there are also challenges that are not necessarily new, but the context is the one that has changed. And of course, every time that the context changes, we need first to adapt this and to first understand what this technology is about. And this happened with the blockchain, it is happening now with GenAI, and it will continue to happen tomorrow with the next step that we will have in this technological evolution. And the personal data role is also something that we need always to rethink, because something that I have learned in all of these years of experience is that the data protection is always extremely contextual, and this matters, and this enables also the flexibility that the GDPR enables in order to get adapted and continues to be a piece of law of reference. However, I would like to share some thought with respect to an exercise that, despite the tools that we have in the GDPR, as a privacy community, maybe we have not been very successful at, and that it will be relevant that we maybe improve, in particular with this AI context. And I am referring in particular to the necessary balance among the fundamental rights and freedoms. But this fundamental rights and freedoms balance, that is something that is a given or part of the acquis with respect to how we should need to construe any kind of fundamental right, including data protection, needs also to be put again in context. And the context I would like to refer to are the European ambitions on AI, because we should place this discussion into what the European Union is looking at. We have a European Union digital strategy that is basically aiming at improving our competitiveness, improving also the way in which we create jobs, improving our economic growth, improving our societal progress. And the way in which we have been doing this in Europe is focusing on two main pillars: the technology, and with a quite particular focus on AI, as we all know, and on the data, because the two things are important and indispensable in order for the European digital strategy actually works. And with respect to this data is not only personal data, it's something wider that encompasses personal data and non-personal data. But as we all know, the difference between personal data and non-personal data is far from being an easy exercise, and probably this exercise has not been facilitated because of interpretations of the GDPR that have not been balanced again. So any discussion that we have in whatever discipline regarding AI and that we have in the European Union needs, of course, to be aligned with our European Union ambitions that are actually translated into pieces of law that are not, in this case, the GDPR, which is technologically neutral, but in other pieces of law, including the EU AI Act, but others. When I think about the pillar of data, the Data Governance Act and the Data Act, that are looking at improving the way in which we are accessing data and sharing data and enabling, at the end of the day, that the digital single market is a reality, is also another very important piece of the puzzle. So the GDPR interpretation is not an exception. So we need, again, as it has always been the case, to adapt our interpretation in the GDPR in order that it is coherent with the rest of the legal order, the one that we have been adopting, in this case, through the co-legislative process in the European Union. And as I mentioned before, we have a wonderful tool, and the GDPR continues to be a wonderful tool, as long as we continue to be faithful of what the GDPR says. I mentioned before the technologically neutral principle that we have in the GDPR. This is one that is extremely important. GDPR is not here to regulate AI as such, as it was not regulating any other technology, because it should be able actually to go across the evolution of the technologies and to focus on the personal data processing that is relevant for the purposes of the GDPR, which doesn't mean that just because there is a name in a sentence or in a book, in a shelf, that the GDPR is going to apply with respect to the kind of guarantees that we have taken so much time in order to have identified. The other very important element that we have in the GDPR to do this as well is that among the aims that we have, and this was inherited from the directive, was to contribute to have a single market, in this case, a data single market, which again is perfectly aligned with our ambitions regarding the European digital strategy, as I mentioned before. The GDPR is also a risk-based approach, which is also extremely important in situations like this one, in which, as every time that we have a new technology or new use cases, we are going to have situations in which we will need to actually assess the risks and the benefits of the cost of opportunity that we have of not doing a certain data processing or of doing it. And the last thing, which is not less important, because it is not something particular to the GDPR, but particular to any fundamental right and freedom, is that we have a rule in our legal order that is our fundamental rights are not absolute, and they require to be balanced in order that we maintain as much as we can in the kind of conflicts that we have every day regarding fundamental rights, that we keep as much as we can the essence. So it's not necessarily that we have a win and situation on one side and the other one is losing. Is that we need to be able to reconcile, and not necessarily 100% all the rights at the same time. It very much depends on this context. And let me zoom a bit more with respect to the context in which this construction of GDPR, with all of these tools that we have, should be effective. I think there is no single conference of privacy or another nature in which the Draghi report has not been mentioned. And this is extremely important because of the role that this person has been playing in the construction, actually, of our single market, but also regarding his considerations regarding the European competitiveness, among others, and the call to integrate AI vertically into any European industry, which is actually a very critical factor in order to unlocking, and I cite his own words, higher productivity, job creation, and reminding us that this is an issue applicable to both very large European companies and also SMEs, which is extremely important in all of our European countries. And I know that this is also the case for Germany in particular. So limitations within the EU to use the data in order to develop and fine-tune AI models that are not balanced will hold European companies back and will put European companies at a disadvantage relative to, for instance, companies that are operating in the US and China. And this is not something that I am just having my personal opinion. Again, I am citing the Draghi report. So with this diagnostic that we have and the wonderful tools that we have in the GDPR to do this exercise, why this is actually not necessarily working as well as it should be. We have seen as practitioners in the field that there is a fragmented interpretation and application of the GDPR by the relevant regulators within Europe. This, of course, does not contribute, just the contrary of the achievement of these European goals on AI. It is a reality that we are seeing that our data protection authorities in the European Union are struggling to formulate individual positions or collective positions on how to construe the GDPR in connection to different aspects of AI, and in particular with respect to AI, generative AI model training. And therefore, the industry is faced with a lack of legal certainty. And this is not only with respect to those producing the models, but also who were using the models. The models at the end of the day they are not databases. They are just engines that enables to power products and services and powers therefore innovation that are going to be created, hopefully, by also European SMBs and who are actually our main champions in our European Union or other bigger companies as well. So when we think about how we develop this industry, we need to think about how we produce, which means the existence of the models per se, the training, the improvement, but also the use through open source. That is the case of Meta, who open sources its models and enables, therefore, that it is accessible to a larger part of our economy as well, but with respect to other models, we can say the same, even if probably the accessibility to the model is linked to other kind of barriers in terms of cost or otherwise. So what do we need with respect to this construction of the GDPR? We need a construction that is coherent with the European digital ambitions with respect to the fact that we want to have AI developed, that we want to have data use enhanced, and we want to have a digital data market. And this requires harmonization, but harmonization in a certain manner, which is my second point, which is balanced. That is coherent first, but balanced in accordance with respect to the rules that we have in the Charter and with respect to having much more focus on the safeguards that we can put in place. And it should also be, in addition to be coherent and to be balanced, it needs to be informed. We cannot operate or try to construe a processing activity that is going to be related to a technology if we do not understand this technology. So the technical expertise is actually something that is very relevant in order actually that we may apply our legal concepts and our values and traditions in order to get this balance the best way that we have. So to be productive in this exercise, we need to continue being faithful to the GDPR. And being faithful to the GDPR is not to be restrictive for the sake of being restrictive. It's to be balanced, which is actually something that is reminded even in the text of the GDPR. If we just go to recital 4, it's just a reminder of a rule that it seems to be a bit forgotten. And I would like maybe to make a specific point with respect to part of this interpretation traditionally that has not been helping, I think, us in general with respect to this idea that I think is a misconception that the only thing that protects is consent. There is no hierarchy, as we know, in the GDPR among the legal bases, and each of the legal bases, and sometimes there are many actually that may apply to a certain or a given situation. But the fact that we think about consent all the time, I think is not necessarily the avenue. It's not that it is part of it, but it's not necessarily always the better. And it's actually not always the most protective way of doing this, despite what maybe we can think. I understand that consent is easier to understand, is a kind of binary thing, yes or no, rather than the legitimate interest, which has been a legal basis that, depending on the countries in the European Union, have been very scarcely used, despite the fact that we have a certain number of references in the GDPR, not only to the existence of the legitimate interest, but also cases in which it is understood that the legitimate interest exists. But also we have DPA resolutions, some of them, and we have Court of Justice decisions that are also relevant in this respect. And let me just remind us as a privacy community the importance of Court of Justice decision that we have some time ago in something that is pretty similar to the kind of situation that we are having now, which is the Costeja case, the case of the right to be forgotten. At the time in which the Court of Justice was actually doing this balance among fundamental rights that I was talking about between the freedom of information and the right of privacy. And regarding a scenario in which we were having search engines that are actually facilitating this freedom of information by having access to publicly available data, that of course may encompass materials and contents that have names in it, or that have faces, if we speak about images per se. And the way in which the Court of Justice resolved the conflict between privacy and the freedom of information was actually to focus on the safeguards, and to focus in particular also on how to construe the right of objection in this case in a pragmatic manner, in the sense of something that is adapted to the context that they were analyzing. And what did they do there? It was an objection that was coming exposed with respect to a request, an active request from the data subject, that was able to identify the piece of information that was related to him or to her, and that was, in their view, damaging them, and with a certain number of criteria actually for the search engines to assess the merits of this request in order to do the balance that is required on the legitimate interest balance test, which is pretty similar in terms of exercise of what I am talking about. And then to determine as to whether in this case the data were not necessarily removed from the source, but they were dereferenced. So the way in which the Court of Justice actually was operating is first with a balance of rights, and then also using some kind of innovation in the sense, let's adapt this actually to the new situation. We didn't have search engines before, and now it seems almost that we cannot live. And actually, I read an article of a professor, a Dutch professor quite recently, who was saying that the LLMs and the generative AI models that we have right now are kind of search engines with steroids. I found the image quite illustrative and remind me very much about this Court of Justice decision, but also the methodology that is behind, which I think is very important. And this is something that, again, is very relevant for us as Europeans to be able to think that the ambitions that we have, we are able actually to do this. Let me finish because we are at the top, I understand, of the time that is allocated for my intervention. My last comment will be that in order to do this exercise, we should do it together. It is not very useful to have regulators and regulatees working not together. So public consultation and to have another mindset in which we really need to work together on this is, let's say, my call. So that I would like that maybe we think also as a privacy community of how we are going, let's say, to be able to intervene in a collaborative manner regarding the exercise that the data protection authorities are doing now closed doors regarding their opinion on AI that is going to end on the 23rd of December. So as a Christmas present, I would like to have more collaboration in the field. Thank you very much.
Thank you very much, Cecilia. So far, we don't have any questions. So yeah, thank you once again for your keynote and have a good day.
You too, and auf Wiedersehen.
Auf Wiedersehen.
Dankeschön. Bye.
So please now join me welcoming Paul Farrow for our next keynote. I think he's already here. Yes, he is. Paul Farrow from Microsoft is now giving us a keynote on next generation advertising. Paul, the floor is yours. Happy that you're here. We can't hear you. Not yet.
There we go. Now
Yeah, there we go.
Thank you. Thank you for inviting me. I'm very happy to be here. Thank you to Bitkom. Today I'm going to talk about next generation advertising. I will confess that I actually stole the title of my presentation from the Bitkom title or of their conference page because I really like the next generation way of thinking. I really like that terminology, and I think it really fits well to how we are thinking about advertising at Microsoft. We tend to use other terms generally when we're talking about the work we're doing, like privacy first and so on. And I think some of these terms have become a bit loaded because I think that they tend to emphasize the focus on privacy, and rightly so. It's a fundamental human right, as we say at Microsoft. But I think that term maybe misses some of the other parts of the equation that we have to balance when thinking about the future of advertising as we go forward. So I want to talk about a few of those things today. So who am I? First of all, I'm Dr. Paul Farrow. I did a PhD not in advertising or privacy, but rather in neuroscience or in biology. So I have some understanding of delicately balanced ecosystems, shall we say, and advertising is certainly one of those. I started my journey in advertising at a company called AppNexus. That was, for those who are unaware of that company, that was a company that very much positioned itself as a competitor to Google on all of its advertising fronts, but independent and far smaller. And we had a lot of success, particularly in Europe, positioning in that way, where we worked closely with large media houses or publishers like Axel Springer, Bild.de, and folks who are paying attention, and I'm sure there are a lot that are in this room that are paying attention to the DOJ trial in the US, will have heard the name AppNexus brought up many times in the competition, in the context of competition with Google, which is always a tough thing to do. Now, fast forward to today, Microsoft. I work at Microsoft. Microsoft actually acquired AppNexus. It was always one of AppNexus's most strategically important clients. But since the acquisition, I've been lucky enough to be responsible for the privacy product, which means I sit on the privacy compliance side of the house. That means I figure out how to build and design our products such that they meet compliance and regulatory requirements around the globe. But it also means that I sit on the innovation side. So I think about what our response as Microsoft Advertising is going to be to the developments in devices that are happening and the innovations that are happening in the technology space as a result of regulatory or consumer sentiments and so on. So I think that gives me a unique perspective of how the privacy landscape or the evolution in thinking is influencing advertising broadly. So today I want to talk to you. I'm going to split my talk into kind of three rough parts. Firstly, I'm going to talk about advertising broadly, but then with a focus on personalized advertising, which is clearly relevant to privacy considerations, how it works, why it works, and why it's so crucial to the future of the internet. Then I'm going to focus on the opportunity that I think devices or browsers have in this future in shaping the next generation of advertising. I think we're really at an interesting and critical juncture between the changes that we're seeing around the globe in the regulatory environment, so on, but also technological advancements that are coming together at the same time, and it really represents an exciting opportunity for the whole industry, but devices and browsers in particular. And then I'm going to speak specifically about how Microsoft and Microsoft Advertising and other parts of Microsoft are thinking about the next generation and how we plan to implement the future of advertising. So I'll set with grounding us in what I think should be fairly uncontroversial statement at this point, but which is that advertising powers the free and open internet. You'll hear me refer to the free and open internet a lot during this talk. Essentially, how advertising does that is a publisher creates content. In exchange, the audience essentially pays for that content with their attention. And then in so doing, the advertisers work with publishers in order to buy the attention from those websites in order to get their advertisements in front of the right consumers and make sure that they can sell their products, right? So even from this relatively oversimplified diagram of how the web ecosystem functions, we can see how important it is for advertisers to be able to get their products and their offerings in front of the right people, in front of the right eyeballs. Which just brings us to personalized advertising. Now, personalized advertising is a extremely prevalent, I would say, form of advertising that has really, really grown exponentially or extremely in the past decades. But what is personalized advertising? Why is it so prevalent, and why is it important? Well, really, you can boil it's very simple. You can boil it down to two things. So advertisers are really trying to achieve two main goals. One is that they want to reach the right audience. So if you go to the trouble of making a product or offering, then you want to make sure that you're able to advertise that to the right people, to get that product in front of the right eyeballs. And then secondly, and perhaps even more importantly or more crucially, you want to be able to measure the return on the investment that you've made into advertisements, so the ROI there. So the old adage goes that half of advertising budgets are wasted. We just don't know which half. Digital advertising actually represents a unique value proposition, and that it is actually technologically possible to understand which of your advertising budgets have wasted and which is not wasted. And that's what makes digital advertising incredibly attractive, particularly when it comes to personalized advertising. But in order to do that, users or devices, more strictly speaking, are added to so-called segments, and then actions across websites are recorded. So that in doing those two things, we enable the use cases or the goals which are outlined above. And this allows ad tech companies like Microsoft Advertising or Google or others to be able to optimize their campaigns more effectively, so they can bid up or down on ad slots on publisher websites more effectively, or understanding the value of those web slots, which ultimately leads to an increase in performance of campaigns. So advertisers end up getting more bang for their buck. And this is why you see personalized advertising has grown so rapidly in the decades that preceded. So that's the economic argument for personalized advertising, but there's also the consumer sentiment, which is that the majority of consumers actually expect personalization from the brands that they interact with these days. Now, this is a McKinsey report that's a couple of years old at this point, but it shows a sentiment that we see time and time again in reports, and also anecdotally, that personalization is not just expected, but that consumers do get frustrated even when their experiences with brands are not personalized at all. Now, obviously, personalization has to be balanced with trust, and that's why it's critically important to ensure that we get trust right in the digital ecosystem. Now, the problem, or one of the problems, or one of the challenges with personalized advertising that we've seen borne out in the past 5 years or so, is that personalized advertising is still very much to this day based on so-called legacy technologies, e.g. cookies, for example, cookies. I'll focus a lot on cookies. I could equally talk about device IDs or other identifiers that are used to enable personalized advertising. But problem is that these all of ad tech is still essentially based on these technologies. Now, I'll start with the kind of positives of these technologies. What they do, cookies in their essence, they do allow advertisers to reach their outcomes. So they allow for advertisers to group users into particular audiences and also to measure the effectiveness of campaigns that they put onto so-called demand-side platforms. And they do that by setting unique identifiers, as you see here. This is actually a user ID I pulled out from my browser this morning. User IDs are set, and then in so doing, they're stored in user browsers, and then ad tech companies are able to add users to interests as they traverse the web and so on. Furthermore, you're able to, when a user sees an advertisement, by linking a user ID at the as the advertisement is displayed and then seeing where the user goes from there on in, you're able to measure the effectiveness of the campaign because you're able to see what the action does, right? So the problem obviously becomes in the complexity of this system, right? So again, this is another screenshot I took from my browser this morning, which shows the sheer number of cookies that are on my system in my Edge browser. And not all of these cookies would have been advertising cookies. So some of these would have been essential cookies that are required for just basic usage of websites. But I think it still illustrates the point that we have an incredibly complicated ecosystem built up around the usage of a fairly innocuous and trivial kind of technology. So the cookie has some pros and cons. I think the pros, cons probably outweigh the pros at this point. The pros are that it's incredibly simple for companies that are trying to attain certain outcomes to be able to obtain those outcomes. But the cons are numerous, and they've been borne out in some of the things we're going to talk about in future slides, and some of the things we're seeing in terms of regulation, and also the way the privacy landscape and even user sentiment has just evolved over time. I would group them into three major cons, and probably more, but one is that it's incredibly simple to track users across different domains, across sites. It's really trivial to be able to do that as long as you have technology on the different pages that people are visiting. It's incredibly hard to establish transparency in a system like this, where everything's based on user identifiers and a plethora of cookies stored in your browser across different sites. It's very hard to actually establish how your data is being processed and why in any kind of digestible manner. And the third is that it's very difficult to manage and delete those cookies. So control becomes a real issue. Now, it's very easy, for example, to block all of your cookies or to remove your user identifiers or to allow things. So you have that binary kind of control, but any kind of fine-grained control over the usage of your data becomes incredibly complicated in an ecosystem like this. So what we have is a suboptimal mechanism for establishing transparency and control at scale, so in the ecosystem. So I only have 20 or so minutes to talk about things. So talking about things like transparency and consent framework, which is fantastic development in terms of privacy, is beyond the scope of this, but needless to say, there are challenges. There are still challenges that we need to solve as an industry and an ecosystem. So what do we need to do? We need to move to a universe where the free and open internet is supported and encouraged and facilitated, but that the processes that facilitate and allow advertising to support the internet fundamentally change such that they give users transparency and control at their fingertips, and that everything is designed in a clear and simple way. Now, transparency and control are the bedrock of our regulation. They permeate things like GDPR, and we see them concepts of transparency pop up more recently in regulations, Digital Markets Act, less so, but also in Digital Services Act. But I'd argue that there are not just ethical arguments for establishing transparency control, and it's not just because we need to for regulatory reasons, but it's also there are clear indications that performance campaigns are even improved when users trust and understand why they're being shown relevant arguments. I think a lot of the problems that are associated with digital advertising and the user sentiment that is often negative for digital advertising is because we've lost these fundamental processes, or we haven't established exactly how user information has been processed, or given proper access to control that data processing. And that's something that I'm very keen to drive towards seeing systemic change throughout the entire industry. And I would argue that devices or browsers are in a particularly good position to be able to enact that sort of change, right? So the browser, for example, is literally the agent of the user. The browser and the device are the agent of the user agent. And in being so, it is incumbent upon the browsers to make changes or to be able to act for the benefit or on behalf of the user. And that starts, of course, with ensuring that the user's data is protected and that they have the appropriate controls in order to exercise their data subjects' rights. And we've already seen that devices and browsers have started to make certain changes. So we've seen the deprecation or the reduction of the third-party cookie across many browsers. Edge has a tracking prevention tool, for example, which reduces the surface area of third-party cookies in the ecosystem. Safari, Firefox have also substantially removed third-party cookies, and Chrome is attempting to do so, as many of in the room will no doubt know, with the introduction of the privacy sandbox. But as we remove or increase user privacy, what I think is fundamentally important is that we maintain the vibrant ecosystem that we've built over time, which has supported the free and open internet, namely advertising. And we're also starting to see devices come up with solutions to do exactly that. So Microsoft Edge is releasing a limited version of ad selection API, which I'll talk about in the next slide. But we also see from the other browsers, of course, there's Privacy Sandbox, which I'm sure many in the room have heard of, which is already in GA, is already available in Chrome, and other browsers have their own versions, more focused on measurement, but still aiming to ensure that they support the advertising ecosystem as a whole. But as we roll out these changes to our devices and our browsers, we have to make sure that we do so in a way that maintains competition and maintains the open and free internet. So if we focus entirely on privacy without thinking about the effect that we can have on the ecosystem, then we can lead to drastic changes in the ecosystem, which may be detrimental to the internet as a whole. And that's why we have to be really careful. Now, these are just, I put up 2 examples here, but this is not to point fingers. It's just to say that we, just like in a biological system, everything is finely balanced. And when you tip the scales or you remove a certain technology in the case of a browser, then it can potentially lead to wide-ranging impacts that affect businesses and affect competition as a whole. And I think all of the browsers on all the devices have a responsibility to ensure that as they roll things out or make changes to browsers, they ensure that it doesn't have a deleterious effect on the ecosystem or other players in the market. So that's what's driving us at Microsoft to think deeply about how we can improve user privacy without hurting the market or causing any negative effects or impacting negatively the ad tech ecosystem. And that's why I'm pleased to announce that this week, actually, the timing could not have been more perfect. This week, we have finally released our limited preview, which is available in selected regions of the ad selection API. Ad selection API is, we say in the UK, it does what it says on the tin. It's an API that allows publishers to put place on their websites and to be able to fill ad slots with ads. That's the simple version. Of course, it's a lot more complicated than that. But essentially, the ad selection API is intended to enable I think the description is best made by the Edge developers who have created the API, which is it's intended to enable the web ecosystem to leverage privacy-preserving approaches to support key advertising use cases, even in the absence of the third-party cookie. Now, all of the choices that have been made for Ad Selection API have been made with trying to find the optimal balance or the optimal solution that ensures both privacy and competition. It's less about balance, actually, and it's more about guaranteeing data protection or data privacy for end users, but also making sure that you don't disrupt the ecosystem or the marketplace. Now, it's fantastically complicated Ad Selection API, as are all of these new browser APIs. So I can't focus on all of the features or all of the design principles in this short talk. But one thing I will say is that we've focused heavily on the use of so-called trusted execution environments. Now, I'm sure that you've heard that term in other talks while you've been at this conference. I'm pretty sure Sebastian from Google mentioned it yesterday. But we made an early decision that we wanted, rather than putting our computation onto the device or onto the browser, we would put it into a trusted execution environment. Trusted execution environments are processing units that work on the basis of data protection by applying three kind of fundamental principles. One is that data is always confidential, so there's no data leakages. Processing happens securely and privately. The integrity of the computations are assured, so they're guaranteed, and attestation is possible. So that means third parties are able to attest that the processing is happening in a way that they want it to happen before they put any sensitive or personal information into it. So the key point to take is that trusted execution environments allow advertisers to target effectively, so advertising to happen effectively, whilst keeping user data safe. So we're very excited about that, and you can see the QR code in the corner if you want to learn more. So you can see that we've flipped the pros and cons here from the cookie situation that I showed you earlier. So the pros now are that it's absolutely impossible to build cross-site profiles. There are no longer large databases with your user IDs with all of the websites that you've visited. The transparency is much easier to establish because now the control over transparency is in the hands of the browser or in the device. So we can show you how your information could be being used by an entity in the ad tech ecosystem. And it's much easier to manage because the controls are kept in the browser and not distributed across the different participants in the ad tech ecosystem. One of the largest cons is that it is far more complicated to understand how these things work. The cookie was a fairly trivially easy thing to understand. It's just a text file that's stored on your browser. In contrast, these APIs built on things like trusted execution environments with privacy preserving technology are quite difficult to wrap your head around. So that's one of the main drawbacks. So to wrap up, I see I'm getting close to time. So I would say that we believe very strongly that privacy preserving technology, of which Ad Selection API and trusted execution environments are very much a part and will continue to be a part, will shape the next generation of advertising, of truly private and competitive advertising. And we're excited to hear the feedback from the industry, as well as everyone in this room, privacy professionals and so on, because we're very open to feedback and conversation, and we hope that we can get there together as an industry to provide the best results. So in summary, we want to establish better transparency and control. We think that browsers and devices are in a good position to be able to do that. And we hope that the APIs that we're building at Microsoft will enable the advertising of the future. So all that's left for me to do is thank you for your time. And please reach out to me. I don't know if I have any questions. I can't see my screen. But please reach out to me because I'm always happy to chat about stuff like this. In fact, I probably chat too much about stuff like this. So thank you very much, Bitkom, and everyone for inviting me. I really enjoyed it.
Thank you very much, Paul. We don't have questions so far, so if some come in by the platform, you're very, very welcome to answer them. But thank you very much and have a good day.
Thank you. I'm trying to stop.
Perfect. Before we now move on to our closing panel of this year's Privacy Conference, I am very happy to announce our last keynote speaker. It's Alex Greenstein, Director of the Data Privacy Framework at the US Department of Commerce. I am very happy, Alex, that you are here once again at the Bitkom Privacy Conference and are giving us a very interesting keynote, I expect.
Well, thank you very much for having me, and it's really a pleasure to be back here at Bitkom once again. And it's definitely sort of been quite a journey, I think, since during some of my previous appearances here, we were in a bit of a, I guess, time of uncertainty around sort of transatlantic data flows. But now I sort of come with a different sort of charge, which is to report on the progress that we've made with our partners in the European Commission in restoring stability to transatlantic data flows and launching sort of a new data privacy framework that provides a durable and reliable tool for transferring personal data from Europe to the United States. And so, yeah, it's really nice to be back here at sort of an important conference with good news to share. And so, yeah, I will give an update on sort of the data privacy framework, what we've done over the past year, and then also sort of noting that we recently held our first joint review with the European Commission and European Data Protection Board of the program, which went very well. And so, yeah, let me just sort of launch into I have a slide deck this time, which will go over a few of the key developments in the data privacy frameworks. Let me share right here. All right. So yes, again, sort of I'm Alex Greenstein, the director of the Data Privacy Framework at the Department of Commerce. And so, and I'm here. Oh, here we go. So why is this so important? And sort of like, what is, I guess stepping back, sort of my team oversees and administers the EU-US and Swiss-US data privacy frameworks, as well as the UK extension to the data privacy framework. And so this is, yeah, the team plays a critical role in enabling sort of the transatlantic economic relationship. And sort of as this slide shows, I mean, the transatlantic economy is $7.1 trillion, and it's really hard to conceive of that being possible without the ability to transfer data. Data transfers are embedded in almost every sort of part of the economy, from sort of like including sort of goods trade, but also most importantly services trade. And so, yeah, right now, sort of, yeah, according to some estimates, the annual transatlantic digital services trade is something like $450 billion. And the EU is the destination for 2/3 of US data flows, and the volume of data transfers between the United States and Europe is largest in the world. All right, so yeah, slide talks a little bit about sort of like we support. And yeah, it's important to sort of note that sort of the data privacy framework and sort of like, data transfers in general are not sort of specific to sort of like, large tech companies. I mean, this is the data privacy framework, 75% of our participants are small and medium enterprises. And that is really, and these companies increasingly rely upon data flows to reach global markets and sort of do business and work with collaborators. And so that is an important thing to note. And it's also a reason why sort of the data privacy framework is so important. Certainly, there are a lot of transfer mechanisms out there that companies can't use in order to move personal data. However, the data privacy framework is unique in that it is more accessible, and it provides sort of almost a template for implementation of a good privacy program that is very valuable for small and medium enterprises who may not have the capacity to put things in place otherwise, and may not have the ability or the wherewithal to put in place standard contractual clauses or other transfer mechanisms. So it really does sort of fill a specific niche that I think is very important to enabling companies to access the global economy. And this talks a little bit about sort of like, how we fit into sort of the international data transfers. We're sort of in that bottom box, which is the adequacy decisions, which we received from the European Commission back in July of 2023. And that brought the data privacy framework into force, which was pardon me, a major development in the transatlantic economy and fulfill the commitment that President Biden had made back in 2022. Here's a little bit, this next slide is a little bit on the history of how we got here. I know it's probably familiar to many of you, but I can briefly review sort of what happened and sort of how we transferred from Privacy Shield to the data privacy framework. As you may recall, there was the Schrems II decision, which invalidated the Privacy Shield framework, which was the predecessor, which I also ran. And then following that, it seems remote in history right now, but there was a great deal of uncertainty about what this meant for transatlantic data transfers and companies' ability to do business. And there was a lot of uncertainty and a lot of concern over this. And so we took that as our charge and we began to negotiate a new framework that fully addressed the concerns raised by the European Court of Justice in the Schrems II decision. And so those negotiations took some time. This was sort of also like, during COVID, and it was like, somewhat challenging to, do that process, but we ended up, achieving success. The United States issued and adopted some really groundbreaking commitments on government access to data, specifically Executive Order 14086 on enhancing safeguards for signals intelligence activities. And this also put in place, the United States put in place commitments around necessity and proportionality of surveillance activities, as well as creating a new redress mechanism that culminates in the Data Privacy Review Court, and that implements U.S. commitments. And we and the European Commission believe that that fully addresses the concerns raised by the CJEU and the Schrems II decision. So once we reached that deal, we began to put in place the data privacy framework once again. And this was a important transition because certainly we had been maintaining the Privacy Shield framework during this interim period, but we needed to launch something new as part of these negotiations, and that sort of came about. So in July 2023, we launched the data privacy framework, including sort of a brand new website. Subsequently, we expanded it to cover data transfers from the United Kingdom to the United States. That sort of built on the what we negotiated in the DPF with the European Union, and then sort of allowed sort of companies to agree to sort of apply those protections to transfers from the United Kingdom to the United States. We also, in parallel, were negotiating a separate framework with Switzerland, which we finally were able to bring into force, and the Swiss adequacy decision for the DPF came into force in September of this year. So that was another key development that I think enables, additional data transfers. We did have to make some other tweaks from the transition to Privacy Shield. We increased our fees, unfortunately, starting October 1st, but we had not increased our fees since 2016. And so we needed to keep up with inflation and then also the additional costs of operating the program, because certainly the requirements and our attention to detail and our oversight has only been enhanced since then. And so we needed additional resources to do that. Another thing that happened was we put in place a new backend for our website, a new platform. That was sort of a $1.5 million investment in the program, which I think emphasizes sort of the importance that the United States places on this, that we are really committed to making this a success. And so, we had our first joint review with the European Commission and the European Data Protection Board over the summer in July in Washington. It was a very positive meeting with participation from Commissioner Renders as well as Secretary of Commerce Raimondo. And generally, it went extremely well. There was a lot of positive back and forth about sort of common experiences and what we're seeing in terms of enforcement and sort of how companies are using the data privacy framework. And the commission recently, just yesterday, released their report on the first review, which was quite positive, and I think shows that we are fulfilling our commitments and operating the data privacy framework in a manner that provides strong protections for European persons' data when it's transferred to the United States. So yeah, this year we just certainly was a process of rebuilding. We now have almost 3,000 companies participating in the DPF. I'd have to go on the website and look at maybe 3,000 now. It's been ticking upwards. This is certainly less than the 5,400 companies that we had under Privacy Shield at its peak. However, it's important to note that it's we only had 2,400 companies certified under Privacy Shield at the time of its first review. So we're actually a little bit ahead of the mark there of where we were at under Privacy Shield. So we're still seeing a lot of strong interest in the data privacy framework, and we're doing a lot of outreach to companies in the United States who may be able to make use of it, particularly small and medium enterprises. And we've been trying to get outside of sort of Washington and go to other cities in the United States and tech hubs promoting the data privacy framework. And so, yes, we're like also, looking at sort of what else we can do to sort of help companies make better use of the data privacy framework and sort of helping identify, are there sectors where people don't think that they can use the data privacy framework, but they actually can? Are there additional use cases? Are there places where you could provide better guidance on how to use it? And so this is something that I think we've discussed with the European Commission and the European Data Protection Board, and we'll continue to have a sort of a robust back and forth on that, because I think this is going to be, it's an iterative process, and we definitely want feedback on how the DPF is functioning, and that helps us, improve our management and oversight of it. So yeah, the first review of the DPF was a very good stock-taking exercise, because we were sort of transitioning from launching and sort of rebuilding the program to sort of now operating it and sort of optimizing our oversight of it. And that's something that I wanted to talk about a little bit more, is just sort of what we do and why we take this so seriously. I mean, certainly we've made these commitments to run the data privacy framework in a certain way. And I think the key element of that is sort of our oversight and how we police it and make sure that companies are abiding by their commitments. And you can see here, this talks a little bit about sort of what we do in terms of, doing spot checks of companies, monitoring for negative information in the press about sort of companies and their conduct, sending compliance questionnaires to companies. But one thing that I'd also say is that we also need sort of feedback, and we do need, if there are sort of complaints or concerns about sort of how the program is functioning, we definitely are open to hearing that. And that's one thing we want to have a robust back and forth with our European partners on. All right, and here's a little bit more about sort of our oversight and how we protect the integrity of the program. So in sort of out there looking for companies who are falsely alleging that they sort of participate in the program when they don't actually. And then sort of ultimately sort of if we do find sort of cases where companies are falsely claiming that they are participating or where they are not fulfilling their commitments, we can refer this to the Federal Trade Commission for enforcement action. So in closing, I guess I would say that sort of So in closing, I guess I would say that sort of like we are really happy to have the data privacy framework back in business, and it represents a critical step forward in safeguarding trans-Atlantic data flows while still fostering innovation and collaboration. And we really look forward to working with our partners in the European Commission, the European Data Protection Board, to deepen our cooperation and make the DPF a success. And also, we really do want to make this as valuable as possible, a mechanism for both US and European companies. And so if there is any feedback on the function of the DPF or things we could be doing better or ways we could make it more useful for companies, we definitely would be interested in hearing that. And so I definitely encourage you to sort of be in touch with me and my team about that. And we definitely are like open to sort of feedback. And really, I want to just encourage folks to look at this as a something you might potentially use to cover your data transfers. I've gone on for too long, so thank you very much for your time. Thank you to Bitkom for having me, and let's see if there's any questions.
Thank you very much, Alex, for this overview and update. We do have one question. Maybe you can give a short answer. The question is, has there been any update on the authorities' coordination of the HR data concept yet?
I think that's something that we definitely sort of are talking about sort of with our partners and sort of the European Commission and sort of the European Data Protection Board and sort of it's sort of something that we're looking at about whether or not there's how we can sort of better explain sort of what companies' commitments are sort of under the data privacy framework principles and how to embody those. But that's sort of an ongoing topic of discussion, yes.
Okay, perfect. We don't have any further questions, so thank you very much. I suppose it's still the morning. Have a nice day.
Cheers, thank you.
And bye. Perfect. So now we head to our final closing panel of the day. And the closing panel of today addresses the legal overlaps and how they may hinder innovation. As AI continues to evolve, companies face increasing regulatory pressure to balance compliance with the technological advancements. These frameworks are designed to protect privacy and ensure ethical AI development, but they can also create challenges for businesses trying to innovate. In this session, we'll explore whether these overlapping regulations are creating obstacles and how organizations can navigate them while driving progress. I am very happy to welcome our three panelists for the closing panel. First, I would like to welcome Raffaela Nicolazzi. She is Data Privacy and Consumer Protection Lead at OpenAI. Next, Professor Dr. Sebastian Schwamberger. He is Assistant Professor for Civil Law, Business Law and Digital Law at the University of Rostock. And last but not least, Dr. Axel Kessler, Head of Data Privacy at Siemens AG. I am very happy that you're all joining me at the closing panel at this year's Privacy Conference. Raffaela, I would like to start with one question for you. Tell us, where is OpenAI heading and what major developments have occurred in the recent weeks for you or OpenAI?
Fantastic. So first of all, thanks a lot, Isabel, for the invitation, for moderating this panel. Thanks a lot for also hosting us here in this virtual conference. Well, so I have to ask you how much time I have to answer this question, because I can speak about it for a few hours. We're all aware, right? There's a lot going on at OpenAI at the moment. But I think when it comes to AI, we're living a period in history that we have way more questions than answers. And this, I think, comes naturally with anxiety, frenzy about where AI is taking us. But I think what really fascinates me is how AI is advancing so quickly, right? And every day, basically, we learn new capabilities that AI tools can help us perform for us, right? Mm-hmm. And I think these advancements are not just enhancing our daily lives, but I think it's really paving the way for more scientific innovation, discoveries, efficiency, and much, much more. So the way that I see this being used is, as I said, in very extraordinary ways. And let me give a few examples, especially what we are seeing in Europe. And the first one I wanted to bring is a Danish startup called Be My Eyes. So they are helping more than 250 million people that have vision impairment to navigate the world, right? So they use GTP4 to provide assistance. And personally, I have a friend who has recently rediscovered a vision impairment, and he managed to pick a flight, go to the airport because he used this app in his phone, something that he could not do it before, right? Or we can talk about Klarna, the Swedish fintech that is integrated ChatGPT to provide customer support that's diminishing efficiency, that something would take 11 minutes now takes 2. And also with the government. So the government Iceland is another example. They have partnered with OpenAI. They are preserving national language using GPT-4, also addressing concerns of language extinction. Albania is using OpenAI solutions to accelerate AU accession. So again, I think this fast pace of the technology really tells us one thing, that AGI is not going to come, AI is not going to come in a moment, that we arrive in time. We see this evolving in levels. And basically all that we've seen so far, we consider like a level 1, right? So these are the chatbots that we have that can understand language fluently, right? They can do isolated tasks. And then you asked me about the things that happened recently. So we recently launched OpenAI O1, which is not a new or larger model, but it reached the reasoners level, right? So human level, problem solving, think for longer. And one was first of its kind on that type of tasks, outperforming even some PhD human examples. And just to conclude, I think as we move forward into these levels of AGI or the progress of AGI, the possibilities of innovation progress are limitless. But I think with that advancement, of course, comes very big responsibilities. We're very much aware of that, right? So how to deploy and ensure AI is deployed and developed safely, ethically, and in a way that respects individuals' rights, particularly the right of privacy and data protection that we will discuss in depth here today. So again, having conversations like the ones we're having today is super helpful.
Yeah, thank you very much, Rafaela, for answering the first question. Now I would kind of jump to Mr. Kessler and ask you the question, in your view, what are the key components of effective AI governance maybe in your company, or what companies should focus on when implementing these technologies from your perspective?
Yeah, this is, I could also speak a little bit longer.
We all could.
But I mean, first of all, you need to know which role are you in. Yeah, like Rafaela would probably be in the provider position, and we as company, we would rather be in the deployer position. But what about adapting the AI application to your needs? Are you then growing into the provider position? So this, of course, then changes the whole picture. Interesting maybe for our audience is that I don't see a big difference between high risk and low risk applications, because you need to be, and these are the key components then, because you need to warrant transparency anyhow. You need to check the system, you need to test it. And not only in the beginning, you need to continuously test it. And if you do so, there will be funny results. Just play around with your HR tools a little bit, and you'll get some results which will not be liked by our HR folks, because bias is in large language models, and therefore the results are also often biased. So you need to test it, continuously test it, give transparency, and test robustness of the system. So these are the key components. And maybe that's maybe that's a vague thesis to say it doesn't matter whether it's a high risk or a low risk application. I think you need to take this into account whenever you use AI applications.
Yeah, thank you very much. Professor Schwanberger, from your perspective, if we look at this, what Raffaela and Mr. Kessler, Axel Kessler said, right? From an academic perspective, do you believe that there are legal overlaps between the current regulations such as GDPR, AI Act, Data Act, and are these regulations maybe a threat to innovating technologies?
Yeah, thanks for having me, and thank you for the question. I think that legal overlaps will always appear because it's about different schemes. We have the GDPR, but not only the GDPR and the Data Act that are overlapping with the AI Act. We especially also have copyright law, for example, text and data mining, which will overlap. And from my perspective, it's not necessarily the overlaps that could maybe threaten innovation, or regulation does not really always threaten innovation. It's more that this uncertainty with the current regulation, that we do not really know what AI is, that we do not really know how these legal acts overlap. I'm just taking the example of the GDPR and the Data Act and how this is regulated. And then also the AI Act, when we are looking at Article 22 GDPR and Article 86 AI Act, when it's on the right to explanation, where we don't know if this is already covered by the GDPR or it's covered by the AI Act. What I want to say is that the uncertainty and then the process, how legal acts are currently being published or currently being handled, and this uncertainty that the practitioners are struggling with and also we academics are struggling with, that's, in my point of view, a little challenging. And also the uncertainty between the legal acts, not only in Europe. I just said to Raffaela before that it's not only Europe. When you're training an AI model, you're taking data not only from Europe, but from around the world. And all these schemes work with each other, and they have differences between them. For example, in the US with the California Consumer Privacy Act, or in Japan with their Privacy Act, they are all a little different, and it's not really certain where these differences are or if they are this big as we think. So uncertainty is what I think threatens innovation.
Yeah, thank you very much. Raffaela, would you agree? Is there some kind of uncertainty, or if you could explain to us, how do you ensure compliance with all these privacy regulations within OpenAI, just to be able to continue to innovate the AI?
Yeah, absolutely. So I think there's a main premise when we talk about GDPR compliance and privacy laws around the world, right? I think we're always seeing some conversion in some of the key concerns out there. But before that, I think one of the main premises that we have to have in mind, and that's across the whole industry of how all of these AI models have been developed, is that the ability to provide this transformative and helpful AGI to everyone is really rooted in developing AI systems that are built in vast and diverse data sets, right? So we want AI models to learn from as many languages, cultures, subjects, industry as possible, right? So they can be helpful and benefit as many people as possible. So basically, the more diverse a data set is, right, the more diverse models' knowledge is exposed to, understanding language there is, like a person, right, who travels and is exposed to different cultures and countries, the more people and countries AI can safely serve. So to me, the question actually is how to strike the right balance between safeguarding all this data throughout every stage of the model to the development while innovating it, right? And for us at OpenAI, it means building AI responsibly in three main things, with three key main pillars. So one, it's enhancing transparency. Second is users' controls. And third would be, of course, reducing the processing of data, of personal data, right? So number one, very quick. So we are one of the companies in leadership on transparency. So an example, when we launched in 2029 GPT-2, we published technical papers. We published a model card that discussed in details how OpenAI used publicly available data for training the model. And all those publications are meant to empower users, the public in general, with clear information about the models. Second one, giving users control over the data. So providing users with this access controls, easily access controls over their data, so offering options like data preferences in controls to manage where data, their chats are used for model training or exporting, reviewing data or deleting data. All of this, like having a privacy center which users can easily access and exercise their rights, right? And third but not least, as I mentioned, is reducing the process of personal data from start to finish, right? So implementing a series of privacy protective measures like data filtering to reduce personal information from the training set in the post-training, and then of course reject requests that would provide private or sensitive information. One thing as well in that point, that doesn't mean that the work is done, right? I think to the contrary, back to my first point, that AGI is evolving super fast and super challenging for us to keep up with the pace. That journey will not come without any challenges. And I could speak about challenges around regulatory dialogue, overlaps, as Professor Sebastian mentioned, the need for common standards across the EU. But again, to me, I will reiterate that point that the main challenge will be to keep up with the pace of this AI evolution, which it translates as interactive deployments. And also, I think, learning from real use so that we can better and improve the model as people are understanding what's happening in front of them.
Yeah, thank you very much, Professor Schwamberger. Rafaela talked about the necessary diverse data set. Do you foresee conflicts between the GDPR and the Data Act when it comes to ensuring privacy in AI technologies? And if you see so, how can we resolve these conflicts?
Yeah, I see several conflicts, and I'm just picking out the two major ones. The first one is the legal ground for the processing, where we are all struggling a little, which is, you can either base it on consent, where this is also something that's discussed in Japan, that when you put data online and it's publicly available, that you consent to the processing, or the publicly available data could not even be within the scope of the data protection law like it is in the US. Or it's like in Europe, where you have legal ground when it's put online and it's publicly available. But what we are struggling with is that these two regulations, also the US and also the European one, is based on that the data subject himself puts the data online. And that's one thing that they are all struggling with, because how can I know if a person has put this data online by himself? So that's the first issue that we are struggling with, and how we or all the companies can comply with. The second one, and this is a little bigger, is what should you do when your model is or contains personal data, and if a person wants to have its data erased or has its right to be forgotten. And if you can't extract this data alone from the model, because it's the model itself, the model is able to remember, and how you're dealing with that. So here we are currently discussing on if we do not need a little opener approach on the right to erasure, because it would it will kill the innovation that went into this model if you have to erase it, because it contains personal data and the model is able to remember it. So that's what we are currently discussing in academia, how we are going with the legal grounds for the processing of the data. That's something that will be or can be solved within the current legal framework, but what's more urgent is how are you going to do, or how we're going to erase personal data, and what happens if you can't erase it, because it will not be sustainable if you don't keep up with a model, if you have to delete the model and develop it again. I think that's all clear to us.
Yeah, Mr. Kessler, are you also struggling with these aspects Professor Schwamberger just mentioned, or maybe as a first point and as a second point, how does Siemens integrate AI governance into existing compliance frameworks, such as data privacy regulations that are already existing? And do you have special, are you combining them in a way? Or you're on mute.
Yes, thanks. So I start with our governance efforts, let's say. So in the beginning, we didn't know how to implement all these provisions. And I mean, it relates a little bit with data privacy, but really the topic is different, and if it's more about technology and robustness and yeah, okay, some are a bit parallel. But then when we talked about how could we implement all that, we saw that this is very close to our data privacy by design principles. So when we try to develop a tool, we also need to look at it from a data privacy side at an early stage. And now we said we simply include the AI requirements in that milestone at a very early stage. And so this is currently what we are discussing. And I think this is feasible. We are not really happy with including, the AI Act is so broad. Yeah, it covers with this reference to Annex 1, to the machinery directive or to these medical devices. It covers so much more things. And if you look at the conformity assessment where all this needs to be done, a conformity assessment lasts around 2 years in our house. And so if we just talked about some uncertainties. So if we still have some uncertainties and then add the 2 years period, I think we will really struggle with that. And that was why we were not really happy with this broad scope of the AI Act, and said basically, come on, let's leave out all this reference to all these other EU regulations, because we really know what we're doing for years. It's AI is something we're doing for decades already. I mean, our computer tomographs in the hospital, they know what they do. They simply compare things they learned in the past already. So it's very similar. And now all of a sudden we need to add certain aspects to it. And we simply say that this is not necessary. We could have done otherwise better. So partly we are happy with the EU AI Act, especially when it comes to Gen AI things, really new things. But I think with the old things like the machinery directive and stuff, I think that was a bit too burdensome for the companies, and it will hinder our innovation because it slows us down.
Yeah, thank you very much, Rafaela. As Mr. Kessler said, it's important to look at new regulations at an early stage. Do you at OpenAI also, or how do you plan to handle the practical challenges that are coming up with new regulations? Maybe there are new regulations coming someday we don't know about yet. And are you also trying to establish certain things in an early stage at OpenAI?
Yeah, I mean, I think uncertainty is a constant in the life of any privacy data practitioner currently, right? Which is also something that makes me feel excited about what's coming ahead. And I also share, I think, the views of Professor Sebastian, right? That the legal overlaps will always exist, right? One thing to note, though, is that the goals of both AI Act and GDPR are very aligned with the mission of OpenAI, which is to develop safe and useful AI. On the AI Act specifically, I think many of the practices mandated by the Act are not new to us and are aligned with our mission and the expertise we've built in safety and security. Right? At the same time, there are certain specific requirements, like in general purpose AI applications, that are still unknown and will be specified, as we know, over the coming months. We do have already dedicated teams that are looking to that will make sure that our policies and practices will align with the requirements that will come in. And also one thing as well that I think it's quite important to note here, as we understand and learn how to interpret this in practice is that it should be grounded in science and reflect the current state of the art of the field of AI, right? So these companies in general, most of them operate globally, right? We think AI Act also should think about align with global standards whenever possible, of course, in order to avoid any type of fragmentation that would be unhelpful, right? Especially on the governance landscape and the multiplication of redundant frameworks. On the privacy laws specifically, I think as well it's important to know that we're doing a lot of work, collaborating, engaging with privacy regulators, sharing our knowledge and expertise, hearing and implementing feedback from constructive dialogues. And also, right, GDPR doesn't come in a vacuum, right? It is a technology neutral regulation. So the challenge now are basically how to interpret the specific provisions in light of these new capabilities, right? That's why we also commend the work that's been done by many DPAs across Europe to have public guidance, public consultation on guidance that they are issuing to really have an informed debate about it. And as well, not to mention that I spoke about the international alignment, but also, I mean, within the bloc, right? Within the EU, we need to see that harmonization as well. That's why regulatory dialogue will be key to get that right. An example, right, is the EDPD guidance that we are expecting on the legal basis for model training. So just one on that. So yeah, let me stop here.
Thank you very much. Maybe Professor Schwamberger, you can jump on that point. Do you think that the current regulations on privacy, especially the GDPR, needs to be reformed in a way to be capable of the new developments in AI, or do you think that we're completely fine with how it is and we just have to wait, as Rafaela said, what we're going to get in the next weeks, months, years, and then we'll see?
Yeah, no, I mean, that's a pretty difficult question, because when I look what I did the last 2 years, I read a lot of legal acts and I read hundreds of pages, and I'm at the moment happy that I have a kind of overview on what there is, but I don't have on the exact wording of each act, and neither does academia or any comments. And what I'm struggling with is when you, at the moment, you don't know what some provisions actually mean and if they are working in practice, and when you're starting to regulate again, because at the moment, no matter if you're talking to academia or if you're talking to practitioners, there's a lot of new legal acts that we have to work with. I think it's kind of a lot, but it's manageable, at least to some point. But I would not start again to regulate every new technology that there is on the market, only when it's really clear that something is not working. But I think when I take this example of the right to erasure, I think we need a debate on how are we standing to innovation in Europe, and what is more important. How important is the right to privacy, and how important is innovation for us? Because when the right to erasure leads to the erasure of a whole model, then it will certainly be privacy that will be on top of innovation. And I don't know if we want to have this at the current state where we are, but we need to discuss it, and it's a discussion in the society we need to have on how is the role of innovation in our Europe, and how can we have a competition with the US, for example.
Yeah, thank you very much. Mr. Kessler, would you agree, or do you see other aspects from your perspective?
Yeah, no, it is true that research is going away from Europe to the US and Asia, because we can simply do it there faster and with less costs. The simple act of anonymization of data takes away so much data from our data set, and it involves costs, time, and we lose a bit of the data, and therefore, of course, our business says, so let's do it in China or in the US then. And it is as simple as it is. So I'm really pressing, I think this erasure topic is a valid one for us. From a business side, this pseudonymization and anonymization should really be a lot simpler. And just think about video surveillance in certain areas, for example, in trains. If we try to blur all the people, still it is regarded as pseudonymized data instead of anonymized data, and we still cannot we can use it, but not to an extent we would like to. And the same is for the car manufacturers, a big topic. Yeah, they drive around and take pictures, and it is still within the data privacy arena, although the data is really blurred and you cannot really recognize someone. And it would be just simpler if we have if we make it a bit simpler for the companies to use these data sets.
So you do think that at least you as a company do need more guidance in a way to look into the future?
Yeah, more guidance, but the guidance should then really be also business friendly, and and don't take the worst assumption. And yeah, of course, it's like Sebastian said, it's a bit of a balance and a political question then. Yeah, what are we willing to take? But if we see these days that research is going to the US and to Asia, and I mean, one day maybe they get better medication in such countries because it's used with their data sets in such countries with their ethnic groups, and which better applies to them than to the European population.
Yeah, maybe I can just ask you one other question. In your experience, do you have best practices that companies can adopt to ensure that their AI initiatives are not only compliant, as we talked about, but are also ethical and transparent?
Yeah. So we for a while we were really doing a lot of ethical work. So because we made some bad experience in that area, to involve our, let's say, our ethical view at a very late stage, or it was too late. So we tried to discuss ethical points already at an early stage. There's not a yes or no about ethical viewpoints. It's more we need to include it in our discussion and see whether we really want to do it or not. And it also depends then whether you want to roll out a certain system in Europe or elsewhere. That also matters a lot with our products. And so we include stakeholders from various disciplines in our house, and the ethical group is one of them. It's very close to my artificial intelligence working group. And so we also include the Workers' Council, for example, when it comes to the usage of AI by our workforce. I think it's important to include such stakeholders at an early stage, so that you don't get any obstacles at a very late stage.
Yeah, thank you very much. As we're running a bit out of time, before I come to my closing question, we do have a question from the audience, and I suppose it's for Rafaela because it's about OpenAI. I'll just read it for you. How does OpenAI ensure that personal data is either not ending up in models or can be removed within the legal time frame of a data subject right request? If possible, also elaborate on a technical level.
Yeah, absolutely. I would need way more than 5 minutes to answer this question. I'm happy to follow up with that person. I can't see the questions here in my screen.
Yeah.
But I think, as I said in the beginning, right, we all should acknowledge the fact that to develop these models, you need a vast data set in order to make it helpful and useful. It is also true that in order for the model to not use or not regurgitate personal data, it needs to know what it is. So there is an incidental part of it that has to be, so it knows, so it learns what it is, so it doesn't regurgitate that, right? So even though we're not, tracking or like going through this particular data sets that may have personal data, the reality is that it needs some component of it in the model phase, in the training phase, so it learns what it is. So then, to the second point about kind of like the output, when an individual is writing a prompt, like is not satisfied with the answer they get, at OpenAI, we have something called the Privacy Center that every individual can go there and request any type of data subject rights, including the right to opt out. So I encourage that person that made the question to take a look into that. And yeah, so let me stop here in the use of time.
Yeah, thank you very much. We still have 2 minutes left, so I would just ask you all one last question, maybe a short answer. What must we do to ensure Europe becomes a global leader in AI and data-driven technologies? Maybe, Mr. Kessler, you want to start?
I think we should really look also to the US and other countries, how they do it. So maybe we have an aligned approach, and we are not, that not some providers simply leave Europe out of their innovational cycle.
Thank you. Professor Schwamberger?
Yeah, I think we already heard it today from the European Commission that the GDPR, for example, is based on a risk-based approach, and the same is with the AI Act. And I think we should rather focus on this risk-based approach and focus on there is a small risk that should also be small hurdles for being on the market. And I think that's a way forward than focusing on this risk-based approach.
Rafaela, you've got the last word.
Yeah, so I mean, directly to your question, I think it's definitely like adoption of AI at a scale as quick as possible, right? As we heard, we're already seeing a rapid uptake in the US among consumers and businesses. That's also a concern that we saw in the Drivers Report, right? Where they noted that there's lower productivity growth in Europe compared to the US and other regions. So I think it suggests that, you know, any type of EU policy framework should enable and stimulate AI use rather than just, you know, layering complexity on requirements. And I think on top of what Professor Sebastian mentioned, there should be acknowledgement on accountability from companies as well on how to address risk-based approach with also accountability.
Perfect. Thank you very much to you three. We're perfectly on time. So thank you very much for participating in our closing panel at the Privacy Conference 2024, and have a nice day and evening.
Thank you very much.
Perfect. So that brings us to the end of the second day of this year's Privacy Conference. We've heard a range of inspiring discussions today, from the evolving regulatory landscape and the challenges of AI governance to the balance between privacy, ethics, and innovation, as we just heard. As we move forward, it's clear that collaboration between industry, regulators, and innovators will be key to shaping the future of privacy and technology. Of course, we had a lot of questions today. I think that most of them we had the time to answer, but feel free to post your questions on the platform, and hopefully you will get an answer. Yeah, dear participants, I hope you all enjoyed our topics we covered today, and thank you for your participation in today's engaging discussions. Thank you once again to all our wonderful partners at this year's Privacy Conference, and for making this conference possible and making it free for charge for you all. Thank you to Data and More, Legitimus, Microsoft, Cloudflare, Google, Meta, Coeo, Grey Swan, Graf von Westphalen, Kertos, Pils Legal, and TikTok. A big thank you to all of our over 50 speakers yesterday and today, all our panelists, and of course to you, the audience, for being part of these conversations. Many thanks also to the wonderful Bitkom team in front and behind of the camera. Without this team, this conference wouldn't have been possible. Thank you to Robin, Sarah, Alla, Alice, Kevin, Josie, Maya, Martin, Bennett, Orly, Lennart, Ellen, Paul, Lina, Maxi, Megan, and Stefan. I hope I didn't forget anyone. And a big thank you also to my co-moderators today, to Professor Markus Helfrich and my colleague Patrick. Thank you very much, and we look forward to welcoming you at the Privacy Conference 2025 next year. Have a nice evening.